Welcome. My name is Joe Custer. Welcome to Ignite Legal Tech Innovation 2021, Day 2. As I said, I'm Joe Custer, Associate Professor of Law and Director of the Judge Ben C. Green Law Library at Case Western Reserve University School of Law. Paraphrasing Peter Drucker, the greatest danger in times of turbulence is not the turbulence, but responding to the turbulence with yesterday's logic. The sentiment today, his sentiment, I think, fits well in today's world. Certainly, there has been turbulence of all different sorts, one of which I think one type of turbulence has been COVID-19 and how the legal tech, how actually everyone, but especially legal tech innovation, is addressing that. There's other types of turbulence too, and I don't want to dwell only on COVID-19. This particular program was set for April 2020, right when COVID-19 was starting. It started really in us feeling it in March, and it would have been a much different program then, but still a lot of things have changed anyway, regardless of COVID-19. The legal tech news, like I said, though, on law.com, legal tech, law technology, legal tech news, the sexy thing is to write about COVID-19 right now. And I think maybe too much can be made of that. There certainly have been ripples. And if you put out a legal COVID-19 article right now, it will get play. If you mention COVID-19, a legal tech article right now, it will get play if you put in or write about COVID-19. One thing, though, we can agree on that there has been a bombardment of new technologies emerging in the legal industry lately. And the indicators show that technology adoption will accelerate, keep on accelerating. David Gulbenski from Lumen Legal states that in 2020, many of the industry predictions slated to arrive in 2025 or 2020 or 2030 are actually happening right now, coming to fruition in a global pandemic dramatically altered state. And the timeline for legal industry transformation has been pushed ahead. Technology investments will drive competitiveness. Dean Price, CEO of Aderant, states the competitive landscape is changing and lawyers will need to rethink the way they deliver legal services in order to create a sustainable, profitable practice in the coming years. In 2021, law firms will rethink their cost structures and reduce fixed costs. Law firms that invest in technology to increase efficiency, reduce costs, and mitigate risk will be much more successful. Disruption will continue, according to Tom Cochran, principal of the Cochran Company, making way for a new business model for law firms. He states, uncertainty always increases the pace at which law firms review partner performance and compensation. And we'll see even more firms explore more precise profitability measures. Since the pandemic proved that much of law firms' infrastructure and business model is a choice rather than a law of nature. Workplaces will rewrite expectations as the rules of hybrid work are defined. There will be lawyers and staff that now see the possibilities of working from home. How will technology fit into this paradigm will be interesting. I think technology will be foremost in making this hybrid model work, not only for law firms, but also corporate offices, courts, and legal academia. We already are seeing well-being being a priority, and technology has a big role in this. Renee Branson, principal of RB Consulting, states leaders are beginning to understand that cultivating resilience and emotional well-being in their people will also cultivate high performance, economic strength, and sustainability in their business. The nimble firm will prevail, says Frank Strong, founder and president of Sword and the Script Media LLC. He states two types of law firms emerge on the other side. Those that struggle to return to what was once normal and the tech-savvy firm that embraces the change as permanent. The latter will shed the overhead of excessive office space and open up access to a talent market free of geographic constraints. This will leave them well positioned to employ the sharpest legal minds at the most competitive prices. Obviously, some of the legal prognosticators I've quoted already see, some of them see a pandemic sea change from COVID and how law is practiced and taught. In my opinion, I don't know, some of the ripples, like I said before, are being felt already, but as to the extent, in my opinion, it's not unknown. But the message is clear. To be blunt, get on the legal tech train, regardless. Leave those mired in the paper world or using yesterday's solutions at the depot. They will continue to struggle. Today's program is a perfect time to up your tech game, as tech is now exploding exponentially. Our expert moderators and panelists will give you the latest insights on how to ride the wave coming your way. Another thing just to mention briefly, is legal tech innovation outpacing the law today? Look at the health, for example, just take an example, look at the health law area. Health law is one of the strong areas at our particular law school. Artificial intelligence is still emerging, but also rapidly maturing. AI technologies are entering the market and seek to create efficiencies, cut costs, and improve quality and safety. The potential value of AI is promising, but the healthcare industry will grapple with questions about the responsible use of AI. Few laws directly address the use or development of AI. As such, the legal profession is left to creatively apply existing laws and regulations. Analysis of AI will need to return to the touchstones of ethics and policy to inform the debate. Lawmakers will struggle to develop standards to govern AI without shifting innovation. Accordingly, lawmakers will likely seek to strike the right balance between regulating development and use of the pre-market and post-market perspective. A common theme that has and will continue to drive the dialogue relates to ensuring that AI technologies are not developed as black boxes. It will be hard to trust what we cannot truly understand. Managing legal risk will require evaluating AI tools based on transparency of algorithms, reliability of outputs, accountability of features, and safeguards around privacy, security, and safety. While the law gets sorted out, early adopters of AI technology will be left to allocate risk through contracts with developers, partners, and third parties leveraging AI technology. What about the new laws for artificial intelligence? I mean, that's some of the issues right now, applying old laws and regulations to current emerging technologies like AI. According to the National Council of State Legislators, NCSL, as of May 14th, 2021, 16 states have introduced bills on artificial intelligence. Most of those are currently pending. What about some other areas we're going to be addressing today, like blockchain? As of the same date, 16 states brought bills on blockchain, and 9 of those states have more than one bill proposed. Several are still pending. How about cryptocurrency? 31 states have introduced bills regarding cryptocurrency in the first part of 2021, several states having multiple bills, and several have already been signed by their governors. What about cybersecurity? 45 states have introduced bills addressing cybersecurity, and several have passed and several have been enacted. Laws are being introduced to help deal with these innovative technologies we will be addressing today, but most of the time, it still appears that law is trying to catch up. It appears that the legal profession is still struggling to fit a square peg into a round hole. I will be moderating the e-discovery panel, which will be the first one up today. At this point, I want to introduce the other moderators who will be leading their particular panels. After us, we'll have Robert Ekman, who will be discussing, his panel will be discussing cybersecurity, navigating the gray, sorry. Robert is a Chief Information Security Officer at Kent State University. Then we will have Catherine Lowry give our keynote. She is the Director of Practice Services, Baker Hostetler, Cincinnati. Next, after that, we will have Brian E. Ray, Alan Miles Rubin, and Judge Betty Willis Rubin, Professor of Law and Director, Center for Cybersecurity and Privacy Protection from Cleveland Marshall School of Law, leading a panel on blockchain technology changing the legal industry. And then the last panel will be moderated by Catherine Lowry, again from Baker Hostetler, Cincinnati, on the future of artificial intelligence and what it means for the legal industry. At this point, we are right before 9 o'clock and the start of the electronic discovery panel. I am going, since I am moderating that panel, I have another part I want to start reading right now, introducing the panelists on the panel. We're addressing key issues in e-discovery today. Like I said, I'm the moderator. I practiced for 5 years before I went to academia. And back in that particular time, after communicating with the attorneys on the other side and the judge, the next thing that pretty much happened was the delivery of big trucks in our loading dock with loads of boxes. So that's how we dealt with it. We had people just reading document after document, and I was involved in that, and it took a considerable long time. So my practical experience with e-discovery was limited to what I knew about discovery rules at that time, back before the turn of the century, and how they have changed since that time in response to e-discovery. My involvement with e-discovery largely started when I was at St. Louis University School of Law. In 2012, I proposed a e-discovery class to the curriculum committee. And I had gotten considerable help from my friend at Missouri, Randy Diamond, University of Missouri, who was professor and director of the law library there. I guess, Randy, I should have said it properly, University of Mizzou, or Mizzou University, correct? Mizzou School of Law. Anyway, I would get dirty looks in that state until I finally figured out to call things Mizzou, not only the school, but pretty much the state to many locals there. The curriculum committee at SLU adopted the course, and I taught it for 3 years. I left SLU and went to Case Western in 2015, and I tried twice to get it through. The second time was successful through the curriculum committee. At first, they thought, even though St. Louis was perfect, because St. Louis and Eastern Missouri are a hotspot for e-discovery in this country. There's hot spots, and there's other spots that aren't nearly as hot. St. Louis happens to be one of the hot spots. And so the curriculum committee knew that, and they just took it on. Now, Cleveland, at least Case Western, I can't speak for the whole metro area, was a little bit maybe new to the idea of teaching it in law school. But I took down a number of hours, and I made it from 3 to 1. It got through the second time, and I've taught it as a 1-hour course since then. This spring will be my 3rd time. And there's talk maybe of increasing the hours on it since attendance has been good. So that's my involvement. And now I want to introduce this fine panel who knows a lot more about the topic than I. First, there's Marcel Duhamel. Marcel, I don't know if did I mention your last name correctly?
Not quite. It's Marcel Duhamel, but that's all
Duhamel.
Right.
Okay, Duhamel. Oh, no, anyway, Duhamel. Thank you, Mike. Okay, Marcel. Marcel received his JD from the University of Chicago and his BS summa cum laude from Case Western Reserve University. We like Marcel. Anyway, he's a partner at Voorhees and offices in Cleveland. Marcel focuses his practice on privacy, consumer protection, complex litigation, class actions, and electronic discovery and appellate practice. He speaks regularly on subjects related to several of these topics. Certainly ESI and e-discovery is one of his prime areas. Thank you for being with us today, Marcel. Next, we have Greg Kelly. I've gotten to know Greg and Marcel through recommendations, thus contacting them for this panel back for the April 2020 program, and they kindly agreed to do this again, or do it for the first time in our reschedule for this, July of 2021. Greg is the founder of Vestige Digital Investigation, Greg, in Medina, Ohio, where he is the chief technology officer. Greg has been involved in the digital forensics field since 2000. He is responsible for the creation of Vestige's infrastructure and continues to oversee the process of standardizing and streamlining Vestige's forensic analysis to provide consistent, high-quality results in a timely manner. Greg leads Vestige's digital forensic and e-discovery services. His responsibilities include helping to determine the strategic direction of the company and overseeing the day-to-day operations and internal information systems infrastructure. He helps in performing as well as the management of digital forensic investigations and leads the data evidence specialists and forensic analysts on the Vestige team. Thank you, Greg, for being here today. The next speaker is a good friend of mine, Randy Diamond, the one who really basically helped plant the bug of e-discovery in my ear and said I should teach it. And so I owe this part of my work life to Randy. Not only did he make the suggestion, he basically helped me write the first syllabus. So thank you very much. I've learned a lot from Randy over the years in e-discovery, and is always a source of help. He is a very giving type of individual, and I've benefited from his friendship. Professor Diamond is a co-founding editor of Legal Information Technology Journal and SSRN eJournal. He is also co-editor of the University of Missouri School of Law Legal Studies Research Paper Series on SSRN. His public work has appeared in the North Carolina Journal of Law and Technology and in Library Trends. Professor Diamond has served as the president of the Mid-America Law Library Consortium, MALCO, which is a co-sponsor along with the Case Western Law Library for this program, day 1 and day 2. MALCO is a consortium of academic law libraries. Randy is a member of the American Association of Law Libraries and past president of the Michigan Law Library chapter. He is originally from New York City, but is pleased to have spent most of his adult life, he says, in the Midwest and to have raised his family in the Midwest. So Randy has, even though he's a transplant, he has a lot of liking for the Midwest. So at this point, I'm going to turn it over in the order in which the speakers are listed on the program. First, Marcel, then Greg, and then Randy. They're going to give you their background in e-discovery. And then after that, we're hoping that we get questions from what the panelists are saying. And certainly I have some in the chute that are ready to go if need be. So anyway, gentlemen, Marcel, it's passing to you.
Fantastic. Good morning, everyone, and thanks for taking a little time out of your day to listen to me. When I discovered that I had the highly coveted spot of being the first speaker on the first panel, I was extremely excited. It's second only, of course, to the even better spot of being the very last speaker on the very last panel. So hopefully caffeine deprivation will not prevent you from asking questions as I proceed. I'll do my best to answer them as they go. What I'd like to talk to you about is the use of AI and related technology in e-discovery from my standpoint in a fairly pragmatic way, as I see it happening in real life in courts that I practice in. And there are a couple of caveats to that discussion, right? The first is I'm only speaking on behalf of myself. There are other people who may have very different perspectives than I do, and some of those people may disagree with some of what I'm about to say. That's okay. It just means don't take what I say as gospel. Take what I say as my relating to you what my experiences have been. And then the other thing I want to say is my understanding of this technology is as a user, right? I don't develop this technology. I don't sell this technology. I'm a user of this technology. So I'm coming from this discussion or to this discussion from that perspective. But because I'm also an advocate, it puts me in the position of occasionally having to try to explain this technology to clients, to opposing counsel, and to judges. So I've had to learn something about it in order to do that effectively. So what I'd like to talk to you a little bit about is why we use AI at all in discovery, what it means when I say we use AI, what we're using and how we use it, what the limitations are, because AI is not a panacea. And I'm gonna say this over and over again. It is one tool in the discovery arsenal, but it is not a complete panacea to every discovery problem. And I'm going to talk about some of the limits of AI, both so far as a technology, but also, and this has nothing to do with the fault of AI, what AI is used for and what it's not used for, and probably will never be used for. And then I'm going to leave you with a few takeaways from the perspective of a practicing lawyer. So first of all, when we talk about AI, what I'm talking about are things like TAR, technology-assisted review, CAR, computer-assisted review, predictive coding. You've heard of all of that. Some of that is sort of AI 1.0, right? And now we have additional stuff, computer or continuous active learning, CAL. Think of that as sort of e-discovery 2.0. And I'm a big fan of CAL, and I'm a big fan of TAR, CAR, and predictive coding too. But again, I want to point out these things are tools. They are not panaceas. First of all, whenever you use any of these tools, they're only as good as the underlying data set, right? So you have to get collection right in the first place. And when we talk about e-discovery, it's not uncommon that we focus so much on how the producing party is reviewing documents and preparing them for production that we sometimes tend to overlook things like how did that producing party collect the documents in the first place before they were ever reviewed for production? And then there are a couple of other key components of discovery that we often overlook. Once I've produced those documents, how do I get to find out what's in them, right? It's not enough for me to satisfy my obligation under Rule 26 and under Rules 33 and 34 to produce documents to the other side. At some point, as a litigator, I want to know what's in those documents, because nothing is more disquieting to me as a trial lawyer than to be 3 or 4 months away from trial, knowing that I've produced 5 million pages of documents to the other side and not knowing what those 5 million pages of documents said, right? It doesn't do me any good under those circumstances. And similarly, when the other side sends its 5 million documents to me, I need tools to get my arms around those documents as well. And things like CAL and TAR and predictive coding aren't as useful at that side of discovery. They're fantastic for culling what you have to actually look at before you produce documents. They're not as good when it comes time to actually getting your arms around the substance of what those documents actually say and prioritizing those documents for use at deposition or use at trial. And the other thing that people often forget is the quality of the people who do the actual eyes-on review. because no matter which AI tool you're using, somebody is either training the system or training the system and reviewing documents. And if those reviewers are not adequately trained and not adequately supervised, and if you don't have a very robust QC process that has early intervention in the event things are going south, then these tools are going to fail you. And it's not because the tools aren't working, it's because you're not using them correctly. Part of using them correctly is having reviewers who know what they're doing. So I'd like to talk about some of the specific limits of a few of these tools. So let's talk first about TAR, CAR, predictive coding. Again, what I call AI 1.0, right? The way these tools generally work, and I'm not talking about the black box, I'm talking about from a practitioner's perspective, what happens. Typically what you need is a fairly senior level lawyer who really understands the substance of the case. May not be lead counsel, but it has to be a fairly senior person who really already understands the substance of the case. And what that person does is they train the system to look for responsive documents. And it's really binary. So what they do is they get a set of documents that the system generates, and they start coding. Yes, no, basically. Responsive, not responsive. And then as they continue to code sets, the system, using various algorithms that I don't pretend to understand, will continue to promote documents to that trainer for that trainer to review and continue to code either yes or no. And the idea is sooner or later, you reach a point where the system says, I can now tell you with X percentage of confidence that you have found Y percentage of responsive documents in the universe of this set. And then you reach a point where you've decided, either because you've negotiated with the other side or it's strictly internal, that you have the level of confidence that is acceptable to you and the recall rate that is acceptable to you. And then you say, great, and you produce the documents. So what are some of the restrictions with that? What are some of the problems with it? Well, first of all, it does require a fairly high level of knowledge about the case before you start, right? You have to at least know what's likely to be responsive and relevant. And that means you can't just staff the case with people who have never touched the case before. The person who does this training is going to bill at a pretty high billable rate. And that means that the per document review cost from that person is relatively high. The whole idea is that he has to look at far fewer documents than he otherwise would to find the universe of responsive documents. So over the course of the document production, it's much less expensive. And that makes sense, and it works if you have a large enough data set. But our experience has been that these particular tools don't work all that well if you're trying to review only, say, 30,000 documents, right? If you're going to be looking at 30,000 documents, you're going to have to review so many of them anyway in order to train the system that you're probably not seeing much of a cost savings. In fact, it may be more expensive because, again, you're using somebody who's billing at a much higher hourly rate than if you have a few first years working at it. So this stuff works really well on big productions. Doesn't work really well on what I would call a small or maybe even a mid-sized production. And in my universe, if it's much less than 50,000 documents, it's probably a small to mid-sized production. I don't think of a production as large until I get above that 50,000 level. And even then, I mean, I've worked on one case where both parties produced over 25 million documents to each other. That's a big production. The other problem with this with this particular technology, maybe I shouldn't say problem, I should say limitation. It works great on certain types of documents. It's fantastic if you're reviewing emails. Fantastic if you're reviewing Word documents. Our experience has been not so great at reviewing spreadsheets, not so great at reviewing balance sheets. It's fine if all of the responsive spreadsheets happen to have the same file name. That it can generate. But if what you have to do to determine whether or not a particular document is responsive is to actually look carefully at the spreadsheet and see what's in it and what's not, This technology isn't great at that file type. Excel is not really built for tar and car, at least in our experience. Also doesn't work really well with other types of documents that aren't easily translated into text, right? If you're needing to produce, drawings in a patent case or schematics, that sort of thing, flow charts, again, doesn't work all that well in that context. What does work in smaller cases and larger ones as well is CAL, continuous active learning. So continuous active learning in some ways is similar to TAR, but some of the differences are that you don't need somebody who is quite as much an expert in the case as you do when you're training a TAR system. The idea of continuous active learning is that you have a set of documents and they are being batched out. And as reviewers code them for responsiveness, CAL is able to learn from that coding and promote additional documents that are more likely to be responsive. And again, the idea is it's statistics driven. You reach a point where you've reached a level of recall that you are satisfied with. And for those who don't know, a recall, the recall value is the percentage of responsive documents that exist in the universe that you have actually produced. Think of it that way. So 90% recall would mean you are confident that you have found 90% of the responsive documents. And then on the opposite side is precision. The idea of precision is what I am producing to you consists only of responsive documents, right? So 100% recall and 100% precision, which is unattainable, but that's a different issue, would mean I have produced to you all of the responsive documents, that's 100% recall, and only responsive documents, that's 100% precision. That's sort of the gold standard that everyone would like to get to, and we will never get there. My experience has been the higher your recall number, the lower your precision number, almost by definition. But CAL is very useful for smaller document productions and mid-sized document reductions. But again, both of these technologies are really coding a binary result, right? Responsive, not responsive. That's it. What they're not doing is issue coding. Issue coding is selecting what issues a document is related to, right? So I look at a particular document and I may say, this document is related to 6 different issues I have in the case. Furthermore, it's a hot document. It's really important. This one helps me or it really hurts me, but it's a document that's really important. CAL, TAR, that stuff, generally speaking, doesn't do that, right? So you still need a physical reviewer who is well-trained to identify those documents, who takes the time to still code those documents. So what's the cost savings, you're wondering? Well, the idea is the only documents they're actually coding are the ones that are being marked responsive. And what these applications do is limit, cull, if you will, the set of documents that the reviewers actually have to look at in order to make those calls. And that can result in an enormous cost savings. We do find that these work best in conjunction with search terms. And here's what I mean by that. If I just collect from my client all of the emails that consist in somebody's mailbox for a certain period of time, I know from the outset that the overwhelming majority of emails I'm getting will have nothing to do with the case, right? I'm going to have lots of emails about donuts in the lunchroom that nobody needs to look at. And I don't even want my reviewers having to spend any time looking at those emails, even to simply say they're not responsive. So typically what we do is we try very hard, if the other side is at all cooperative, to negotiate a set of search terms with the other side, which we use to cull the initial collection. Then we apply these technologies to that set of documents. And that, we hope, significantly multiplies the chances that we're going to be looking at more responsive documents and less non-responsive documents. Neither of these technologies, by the way, work very well in privilege review, at least in our views, right? So somebody still has to look at documents for privilege. You still have to come up with a strategy to review privileged documents. One of the other problems that we encounter is the misunderstanding of this technology by judges and less sophisticated opposing counsel. I can't tell you the number of times I've experienced people who seem genuinely to believe that if I want to produce documents on behalf of a multinational corporation, all I have to do is pick up my mouse and speak into it like I'm talking to the Star Trek computer, right, on the Enterprise, and say, computer, give me all of the relevant documents and give me none of the non-relevant ones, and boom, out it will come. It doesn't work that way. Part of it is my job to advocate and to teach the judge and opposing counsel. But in cases where we have a problem of asymmetric discovery, which is common, an asymmetric discovery is a situation where instead of two big businesses suing each other, for instance, I'm representing, say, a large business being sued by an individual plaintiff in a class action. They have almost no discovery obligations, so they're not going to own anything, right? So it's all on me. And every time I tell them that there is any sort of limitation to what I can do for them, their immediate default is that I must be hiding things. The only reason I would object to anything is because I'm trying to hide something. There can be a real learning curve for opposing counsel. Unfortunately, there can also be a real learning curve for judges. So here, I think it's important that when we talk about AI in the literature, I would urge academics to do this too. We don't overhype it, right? We remember what these tools can do for us, but we don't create the impression that this is a magic silver bullet that is simply going to allow everyone in a 2-week period with almost no expense to generate hundreds of thousands or even millions of responsive documents and produce them in discovery. If there's a big limitation to AI at this point, I would say the biggest one is its misunderstanding by people who don't deal with it every day. And part of that is because I think we sometimes overhype it.
Marcel, I'm sorry to interrupt, Marcel. You do have a question, and I would like you perhaps to let me read it, and then we'll pass it on to the next speaker at this point, if that's okay. The question is, does the skill of writing good terms and connectors searches translate for this purpose?
Absolutely. The answer is absolutely yes, provided you are using a review tool that has a robust Boolean search capability, right? You can write the best search string in the world, and if you're using a rudimentary review tool that can only do single terms, then it doesn't help you. But absolutely, complex search strings are, in my view, far better than simple search words. So when I say search terms, I'm talking about something that looks like a really complicated Lexis search, sometimes 2 or 3 lines long per string. That can be extremely effective in culling the set of documents you're looking at. And I think I am almost out of time. I will just drop one last point before I stop talking. It is extremely important, in my view, to negotiate a good clawback provision in any document production. And although that's not really part of the discussion about AI, it is a thing that is often overlooked. So by clawback, what I mean is an agreement that both sides reach. Anything I produce to you, if at any point in the litigation I realize that document was privileged, I get to claw it back, you can't use it, and the only use you can make of it is once I put it on a privilege log, you can challenge my assertion that it's privileged, but until that challenge is resolved by the court, you can make no use of it. That's exceptionally important when you're reviewing large quantities of documents, especially if you make the strategic decision to produce documents without a physical eyes-on review, which does sometimes happen in very large document productions where you've used something like TAR, you've concluded it's probably responsive, but we just don't have time to look at it before we push it out the door. If you're ever going to do that, make sure you have a very robust 502 order. That's a reference to Evidence Rule 502. And I said about a third of what I intended to say, but time goes fast when you're on a 15-minute clock. Thanks a lot.
That's right. Thanks, Marcel. That was very interesting, and I learned from that. Next, we have Greg Kelly, Chief Technology Officer of Vestige Digital Investigations in Medina, Ohio. Greg?
Thank you, Joe. So I don't think, Marcel is the leadoff hitter there. I don't think you realize he did a great job of setting me up with a very poignant phrase at the beginning, get collection right. And that's what I want to talk to you about here is getting collection right. If you think about with e-discovery about 10, 15 years ago, we were dealing mostly with computers. That was it, computers, servers, emails. World was pretty simple at that point in time. Started advancing in around 2010 and 2012. Cell phones started showing up and people started looking at text messages on cell phones and what can we get from cell phones. In the last 3 or 4 years, the amount of the types of sources of electronic data has really exploded. It's gone way beyond just computers and cell phones and emails. We're into Slack, we're into social media, we're into all sorts of other information you can get from cell phones. And we're blending this amazing thing called the cloud with our physical devices. And so some of the topics I want to talk about with collection are first, where does your data sit? How do we handle privacy concerns? How do we handle security and encryption, things like that? Then after we've handled all those questions, how do we get the data? And then lastly, how is it handed off to the next process? Okay, so let's talk about where does the data sit? As I said, it used to be very simple. You go to computers, you pull the data from the computers, pull someone's mailbox, you're done. That's it. That's not the case anymore. First of all, you have to identify, and a lot of times organizations don't know where their data sits. They don't know, they've got anywhere from dozens of employees to hundreds of thousands of employees. And each employee uses different resources. As much as IT would like to believe and trust that everybody's saving things on a network share, everybody's using the approved technological devices, that truly is not the case. You have people setting up Slack channels. It's very simple. You get a personal Slack, a Slack installation, and there's no fees to it. And all of a sudden people are talking on Slack. And yeah, they're talking about, the upcoming football game or a movie they just saw over the weekend. But they're also doing a lot of business talk. That's why they're using Slack. It's a lot easier than email. And now all of a sudden you've got to think about collecting from Slack. People are setting up their own Dropbox sites, using their own personal OneDrive just for transferring data, especially now that we're blending in the remote work versus working at the office. People are trying to find ways, how do I transfer that data back and forth, especially since IT has turned off the ability for me to use my thumb drive. I can't plug in a thumb drive and use that anymore. Well, I'm just going to transfer it up to Dropbox, and then I'm going to go home and I'm going to bring it down to my home machine. I'm going to work that way. So you've got these issues with identifying where that data is. And let's go beyond that. If you think about when I talked about cell phones, 5-10 years ago, if you wanted text messages, if you wanted the pictures, things like that, you got it right from the cell phone itself. That was the one and only source. Now, that may not be the case. Text messages while you may see text messages on a phone, they're actually living in the cloud. Let me give you a perfect example. Not a day goes by where we don't receive a call here, assistance in collection, and they tell us, hey, we want to collect 4 or 5 individuals. We want to get their cell phones, and we want to get email. Stop. Hold right there. Cell phones, even though you're using your cell phone to receive emails, send emails, the messages don't exist on your cell phones. So what you see is not always what you get. Those email messages exist up in the cloud. Your cell phone is just a passive device for that. The same could be true for text messages. The same could be true for pictures and videos and things like that. So you have to consider when you're dealing with whether it's an iPhone or an Android, do we need to get iCloud? Do we need to get the synchronized data with an Android phone? Do we need to pull what's called a Google Takeout and get all of that data? And so there are a lot of different areas to consider, a lot of different pieces to consider. It's not just as simple as go grab a couple of cell phones and a couple of computers and you've met your burden. Like I said, not a day goes by when someone calls up and they want emails for a cell phone. Not a day goes by when I get an attorney that calls me and they're dismayed because we thought we collected all the data, and lo and behold, one of our witnesses is in a deposition and they say, oh yeah, we talked about that. We talked about that on the Slack channel. And now everybody's head explodes and motions start flying regarding spoliation of evidence and not collecting, and you run into those issues. So identification is very, very important these days. You've got to get someone that has the technological know-how to come in there. And it's a combination of maybe an outside consultant, but definitely someone with the technological know-how, whether it's internal IT or again, an outside consultant, and the attorneys and the witnesses, bringing them all together and deciding what you need to get, where it's going to be, and how you're going to go about getting it. So now you've identified your information. Now you've got another big issue that's going to hit you in the head: privacy. Okay, talking about cell phones. 90% of the cell phones out there used in the business world are personal cell phones. Okay, bring your own device it's a thing. It happens all the time with cell phones. And you first have the situation where the witness will say, sure, I've got text messages on my cell phone, I'll give them to you. Then all of a sudden, when push comes to shove, well, they've got messages on there with maybe their doctor, or maybe they've got messages on there with a spouse, or they've got messages on there with someone that they don't want their spouse to know about, or they've got all sorts of other messages on there. And people start clamming up real quick when you ask for that personal device. So it's how you go about, getting that information, how you go about alleviating those concerns. And one of the things that attorneys sometimes will miss the boat on when they come to us is say, okay, we want to collect text messages from John Doe, but we only want to collect text messages from John Doe between John and these other people. That's not technologically feasible a lot of times, okay, because of the security. So if you go back and you think about, again, the old days when it was nice and everybody was happy and we all lived in peaceful times with computers, you could selectively pick information, pick and choose. I want this folder. I want that folder. I just want this mailbox, so on and so forth. You can't do that with cell phones. Cell phones have a different security model. They only give you what they want to give you. And when it comes to collecting that data, you have to make a full backup. 9 times out of 10, you gotta make a full backup of that cell phone to get those messages. And so it's a negotiating process of letting the witness know, hey, we have to collect the whole thing, but that collection process, we're not looking at anything. We're just running an automated process to collect the data. And then we're going to filter it out, and the attorneys are only going to see those specific messages. And then whether you decide to delete the rest or hold the rest, the attorneys are only seeing just those specific messages. Now, I caution you on ever agreeing with a witness to say, we're going to collect your whole phone, just pick these certain types of messages and delete the rest. Raise your hand if you've had a witness that's been completely truthful with you about who they've discussed certain situations with. Marcel's laughing hysterically over there because he knows the situation. You can't do that. You can trust, you can ask the witness to trust that you're going to keep the data secure somewhere, but you can't get rid of it, because I guarantee you're going to find another individual that's a party to the situation. You have to go back to that, and you don't want to have to go back to the custodian and collect again, because guess what? The second time you go back to collect from the custodian, lo and behold, yesterday, their dog ate their cell phone, and it's a mess all over the floor. Magically, it's magic how that happens. The day before you need to collect from a cell phone, that it finds itself in a river, it finds itself in this dog's stomach, or their kid stepped on it, or something else. It's amazing how that happens, and each one of those stories is truthful. I kid you not, each and every one of them. But that's what you're dealing with. Okay, so you negotiated with the custodian, you get in their information, you figure out a way to separate privacy. Now you got security and encryption. Okay, if you get a cell phone and you don't know the PIN, forget about it. You're not going to get that information unless you want to wait a few months and you want to pay, I'd say $5,000 or more to sit and have a device churn at that phone and try and guess that PIN. Okay. So you need to get the PIN up front. Security becomes even a bigger issue when you're dealing with custodians where they have emails up in Gmail or Yahoo or some other personal account, because you might get the username, you might get the password, but then you're going to have to pass some sort of two-factor authentication. That becomes really difficult when you're dealing with, unfortunately, deceased witnesses or dealing with witnesses that don't want to be too cooperative. Okay, you've got to make sure that not only do you get the the username and password, but you're going to have to work with the custodian for 2FA. The way we typically do that is we set up a time, we talk with the custodian directly, and we tell the custodian ahead of time, change your password in case you use the same password. Not that everybody uses their same password for every single account, because I know that's not true, but in the event that they use their email password for their banking, go ahead, change your email password. Let's have a conversation. We'll get that from you. Let's do the 2FA and let's move on, okay? But then also you deal with security concerns and encryption when you're talking about preserving data from either a Windows PC or a Macintosh computer. All right, more and more Windows machines these days have BitLocker on them. If you don't have the BitLocker key, you're not going to get the data. There's no magic to that, okay? With a Macintosh computer, if you don't have the credentials, you're not going to circumvent the encryption on there, all right? So credentials become important. It also becomes important to identify the encryption up front so you can handle it when everybody's together and someone's not on vacation and so on. So we've identified the data, we've handled privacy, we've handled encryption. Now, how do we actually get the data? Okay, I talked about before when you're talking about cell phones and other things, selective collection is really not practical a lot of times. Collect it all, then split it out, call it off like Marcel was talking about. Call it off with keywords, call it off with individuals' names, things like that. Send that data on to the next group. But computers, easy as far as dealing how to get that data. Except Macs these days are becoming a little more tricky, but that's a technical topic for another time. Cell phones, if you have the PIN, you're going to get that information more likely than not. But now if you're talking about cloud data, if you're talking about things like Slack, if you're talking about things like social media, I haven't even mentioned social media. So let's talk about that now. The social media world, whether it's Twitter, Facebook is actually notorious for this. Facebook changes their API, their APIs as far as how they give you access to the data almost on a monthly basis. And so what does that do? What does that mean? What that means is your IT department or your third-party consultant may have been able to collect certain data from Facebook in a certain manner and was easy and fine and dandy a month ago. Today, not so much. And maybe we can't get that data. Maybe we have to go old school method and start taking screenshots. And that's happened sometimes. Or sometimes reverse happens, which is good, but rarely is that the case. It's a constant game of Facebook changing APIs or other social media companies changing their APIs, and then the vendors that write the software to collect the data changing the APIs to go with it. So we had a case where we were collecting a Facebook group post that went back about 2 years, and it darn near took us 2 years to collect it. It took about 2 months, to be honest. It took about 2 months to collect it, but it was a very painstaking process because the information was tough to get to from the standpoint of, for those of you that use Facebook, you go to a post, you see the post, you might see 4 or 5 comments. Okay. Do you think that's good enough just to grab 4 or 5 of the most relevant comments on a relevant post on Facebook for a case? That's not going to be enough. You got to get all the comments. In order to do that, you have to have a mechanism to expand all those comments and the replies to the comments and the likes and the dislikes and the smiley faces and all that stuff. So what I'm saying is it's no longer just as easy as when you're just collecting data, from a computer. So finally, let's dive into the next part about how is this handed off. Again, when you talk about computers and even cell phones, well, not necessarily cell phones, but computers, a file here, a file there. You get an email. Usually when you get an email, you get the whole trail behind it. You can kind of read it. It's easy to do. Text messages, it's 140 characters, maybe 200 characters. That's it. If you're running keyword searches, you have to make the decision about whether or not, do I want just that message that's responsive? Probably not. I want some of the replies and some of the messages before that. So how do you decide what to get? Is it maybe a 24-hour cycle around the message? Okay. We've had some customers that will come to us and say, well, you know what? If I have a responsive message, give me the whole conversation. Okay, great. With the keywords you picked, you managed to hit on conversations between the custodian and his wife and his kids. And so guess what? Now you've got 50,000 messages to go through. Not practical. So it's a matter of how you're going to present that, what decisions you're going to make as far as what you want to get and how you want to look at it. Same thing when you're talking about social media or collaboration tools like Slack. You want to see it as it is on the screen as best as you can. It's not always practical, but that's what you want to try and strive for, is get that. You want that smiley face to look like a smiley face. Case in point, we had a matter a few years ago involving an iPhone involving a sexual harassment case. And it was a big deal as far as how a rainbow was rendered. And I will tell you in this case is that the different versions of the iPhone rendered that rainbow in different manners that actually mattered in the case, mattered in the sexual harassment claims. And so things like how you're presenting that data, how you're handing it off, how it looks, stuff like that, you really want to make sure you're talking about that up front and you're getting it as close as possible as you can. And again, I'll tell you, something as simple as a rainbow emoji and how it's rendered on an iPhone 6 versus an iPhone 7 can be a very important thing in a case. All right. So that's really all I have to talk about, from that standpoint. Collection isn't as simple as send someone out, go get some phones, go get some mailboxes, and go get some computers. There are a lot of things to consider because, the data doesn't always sit where you think it sits. You've got privacy concerns to get over. You have to deal with the security encryption. You have to deal with the organization that's holding the data and how they're going to give it to you. And finally, how you're going to present that data.
Greg, that was I really appreciate it. I learned a lot on that one. That's an area I'm not that strong in. So thank you very much. You do have a couple questions here in the chute. I'll read them out to you, okay? One's regarding the news story about the Sandy Hook litigation, seeking discovery and receiving random images. The individual, if you want to open the Q&A, does give you, if you want to bring it up, the actual article. And this has been, this one's from BuzzFeed, but it's been, been out there. How would you have recommended the attorneys adjust their ask to assure that they got the social media presence, but more meaningfully?
Yeah, so, looking at this case and understanding the background on this case, it's highly contentious. Now, most litigation is highly contentious, as I'm sure Marcel can attest to. But I think what you have is a situation like this where the parties didn't really come together and trying to collaborate. They were obstinate and pushed forward, and the people asking for the information didn't decide to better explain what they're asking for and make some provisions as far as how to do it. So the side producing it said, we're going to give them what they want. And that's what you get. When you don't consider, what you're asking for and look to talk to the other side about a process and protocol so that you don't have issues like this, you will have problems like this. For instance, talking about keywords and using good keywords, I had a case, it's now probably been about 15 years ago, where one of the keywords we were asked to search for is the preposition onto. And it was like, what possibly could you think? What possibly would you get that would be relevant by searching for the word onto? It wasn't onto and something else. It wasn't onto in a phrase. It was just a single word, onto. So when you have certain things like that, and part of it is the requesting party, they're under the gun. They oftentimes get one shot at this, or very few shots, and they want to make sure they don't miss things. And so, they ask for everything under the sun, and therefore you're going to get everything under the sun. So I guess to sum it up, it's a matter, it's a thinking of consider what you're asking for. What's not just what's the from a human standpoint, what you think you're going to get, but bring someone technical that's going to say, okay, when you ask for these things, here is what you're going to get. You know, consider that. Don't just consider these keywords in a vacuum with just attorneys and the client thinking about it. Bring in that technical person that'll say, when you ask for these things, this is what you're going to get because these are the limitations around it.
Thank you. Marcel, you have your hand up.
Yeah, I just want to jump in real quick on that point because I agree completely with Greg. There are two very closely related issues there. If the other side refuses to negotiate with me in an effort to narrow their discovery requests, then they are going to get what they asked for. And inevitably, they go back to the judge and they say, oh my God, all I have here is a whole bunch of emails about donuts in the restroom, or in the restroom, that'd be really odd, donuts in the lunchroom. But that's the band playing Friday night, donuts in the restroom. But if you say to me, you want every email sent or received by John Smith during this period of time, and you refuse to negotiate with me about search terms to figure out which emails are relevant, when 98% of the stuff you get back is totally irrelevant to your case, but it is an email sent to or received John Smith, you don't really have much right to complain. And sometimes you have to trust opposing counsel a little bit. A very quick example, and then I'll shut up. I had a case in which the opposing party's last name was a 3-letter word. Well, for the sake of argument, we'll call it Cho, C-H-O. And they absolutely insisted that I search all of our documents for that 3-letter word as a standalone word and return every single document that hit on it. So when we searched that term, we discovered over 5 million responsive documents. Why? Well, it turns out my client was divided into geographic regions, and it used the 3-letter acronym CHO for one of those geographic regions, right? When I explained that to the other side, they didn't believe me. So when they got 5 million emails and ran to the judge to complain about a document dump, the judge had absolutely no sympathy for them whatsoever. So sometimes you have to be careful if you are the requesting party to take care to make sure you know what you're asking for and what the heck you're going to do with it when you get it.
Yeah, right. Thank you, guys. That was very, very interesting to say the least. And Randy Diamond, we're off to you.
Joe, thank you to you and your colleagues at CASE for putting together such an interesting program. I am honored to be a part of it. Good morning, attendees. I'm going to share my screen. And hopefully you can see Classroom to Practice. As Joe mentioned, I've taught e-discovery now for over 10 years. And Marcel and Greg have really teed up very nicely the motivations I have for bringing this to legal education. A lot of what I try to convey to students are what they're going to face in the real world in terms of the challenges and complexities of identification of ESI, the complexities of collection, the dangers of self-collection, warning students to carefully vet AI, don't buy into the hype, be aware of the privacy issues and concerns, and look out for cell phones in rivers because that's going to happen a lot in many different shapes and forms. The students that I've had have run the gamut. When I first taught the class 10 years ago, one of the students there is now heading up the e-discovery practice at a mid-sized firm in St. Louis. Many of our students have educated their smaller law firms who did not have e-discovery practices or cases before, helping bring them up to speed and creating great career paths for them in those environments. And most recently, the best student I've ever had in e-discovery this past semester began her summer associate position at a large law firm and reported back to me that her very first assignment was a complex issue on metadata, and she felt well prepared. So that's the positive. Educational opportunities are expanding, both within law schools, where today there are many more e-discovery classes than when I first started teaching it. There are many practicing lawyers who are teaching these classes as adjuncts, who are bringing direct practical skills into the classroom. And then outside of law school, a very good trend is the abundance of CLE programs like this, workshops, self-guided courses, institutes. Really, if you want to educate yourself about e-discovery, those opportunities abound. So education is a positive. What are lingering concerns? What have I seen over the years? And I think what bothers me the most is that we see repetitive mistakes. The same issues and sanctions keep arising over and over again. And I have to wonder, what is it that is preventing, these are not necessarily technical issues, but just basic diligence, concentration, keeping your eye on the wheel, keeping your eye on the client. And these mistakes keep happening. We see inordinate discovery delays, faulty production resulting in unending motion practice, and severely consequential mistakes in terms of waiving privilege and confidentiality. As Marcel referred to, the clawback agreement and the 502D order are basic core practice competencies in e-discovery. As I teach the class, I try to bring in, there's plenty of current examples, and I'm so glad that we've already talked about the Sandy Hook example. That was covered nationally in NPR. It is such a stark example, and I love the analysis that Greg and Marcel gave in terms of the tension between the plaintiffs and the defendants. The plaintiffs looked at this as an old-fashioned document dump, and the defendant's position is, hey, you got what you asked for. You didn't narrowly tailor your discovery requests, so no harm, no foul. And we can leave it to both sides of the table to continue to argue that motion before the court. So what I'd like to do is share with you some observations across different segments of parts of the course that I teach. By no means is this comprehensive of everything that we cover, but in the spirit of assessing and sharing my thoughts on the state of e-discovery, here we go. Legal tech, for some. When I think about my original exposure to e-discovery, much like legal research, where the legal research databases in law school are available to everybody, once you get out into practice, that world segments where the large firms typically have all of the access to bells and whistles to those services. And it varies then as you go to the smaller firms and into public interest work in terms of access for legal research. And I think the same patterns holds with the legal technology. In teaching the class, I have vendors who make the software available to me that has very robust search features to it. But I'm acutely aware that most of the students and the practices they're going into are not going to have those same review platforms. So happily, in the last few years, there have been vendors that are intentionally marketing their software for smaller cases, for lower cost options, and I introduced that to the students as well, and that's a positive sign in development, with the caveat that in that scenario that Marcel was talking about, where you need the robust search features, you may not have them in that particular tool. A recent development is Craig Ball, who is a renowned practitioner, thought leader in e-discovery. His blog is well worth reading to keep up. Points out about a free tool at Google called Pinpoint, which is intended for journalists. And here's what it says on the Google site about Pinpoint. It unlocks hidden stories. It explores and analyzes large collections of documents, search through thousands of documents, quickly find important stories within troves of forms, handwritten documents, images, email archives, PDFs, and more. See the big picture, understand and filter documents by key people, organizations, and locations. So as there is a possibility for some technology that might be available to further level the playing field, so to speak, within legal tech. Cooperation constraints. Everybody, no one can object to cooperation, and in fact, it is heavily a big part of the e-discovery judiciary. The Sedona Conference Cooperation Proclamation has well over 100 judges that have signed on to it. The case decisions are replete with courts referring to the importance of cooperation amongst parties, yet it's a real challenge. And I think one thing that I point out to the students is there's always going to be an inherent tension between the plaintiff's bar and the defense bar in terms of bringing together, achieving that level of cooperation. Certainly, objectively, cooperation benefits the client. It saves money. It gets the case resolved more quickly. But where are the tension points? And what I point out to the students is we look at the reaction to the 2015 amendments. Plaintiff's bar was very concerned that the proportionality provisions were moved up into 26B1. They perceived that as a potential constraint on discovery. The sanctions under Rule 37E in terms of the amendments in 2015, eliminating the possibility for obtaining severe sanctions such as an adverse inference in situations of negligent discovery misconduct, limiting it only to intentional, those severe sanctions only to intentional misconduct. That was a tension point for the plaintiffs. From the defense bar, they largely argued that these changes were not terribly significant, that the proportionality provisions were always there. They just happened to get moved up. So that is illustrative in that way. And more currently, what I wanted to share with you in talking about proportionality is, how do we know, how can the judge make a fair decision when there's just been enough discovery, or when we can allow the requesting party to dig deeper? And we see very real challenges in proportionality arguments. They oftentimes are very superficial, where a producing party will argue, no, this is disproportionate to the case, and not provide any objective financial figures to actually objectify what the burden actually is. So I was fascinated to see that at the Georgetown University, a project that is underway under the James Humphreys Complex Litigation Center. The project is called Benefits and Cost Proportionality Model, a New Framework. If you go to their website, you will find working drafts of some very interesting charts that help to, are designed to help the court objectively analyze the degree of burden, cost factors, the scope of who the most significant custodians are. And so that is, to me, a heartening example in e-discovery in terms of trying to work towards creating tools that can help for better resolution. What was interesting to me, though, is when I attended the webinar on that, my sense in listening to the commentators on it was that the plaintiff's bar was very much reluctant and suspicious of how these tools would be used. So that's the most recent example of that tension point. In terms of evolving ESI, when I go back and I'm teaching the history of ESI, and it's important, the Zubilate cases with Judge Shira Shinlin, very much the outcome in those cases informed cost shifting issues, the scope of preservation, and many of the rulings in the Zubilate cases found their way into the 2006 amendments. And at that time, backup tapes were the focus of the reasonable accessibility issue in that particular case. And perhaps over time, as ESI and technology changes, maybe backup tapes are not as difficult to produce as they once were. But I could say backup tapes to ephemeral messaging to highlight the importance of changing ESI, as Greg alluded to, with Slack is constantly changing. And what I don't have on there, I think is interesting, is the arguments that can be made that can be somewhat specious sometimes There was a products liability case, famous one, in re Pradaxa a few years ago, in which there were sanctions motions coming against the defendant for failure to implement a legal hold properly. Basically, the defendants acknowledged that they had not properly preserved email, but they argued to the judge that they should not have been taken to task for not preserving text messages because text messages were not a prominent form of communication. And that argument didn't fly with the court because, in fact, Pradaxa had been, their employees were required to use, to do text messaging as part of their business transactions. So we move on to more current scenarios in which increasing use of ephemeral messaging in government agencies, in business, and the use of ephemeral messaging, messaging that is not inherently preserved, it can be reasonable under a consistently deployed information governance policy. Where it runs into trouble is when ephemeral messaging is used suddenly as a means within a litigation or an awareness of forthcoming litigation to hide information. So in terms of education today, we just have to be prepared for these evolving technologies and how they are received in the discovery realm. In terms of the sanctions spectrum, I mentioned Rule 37E has constrained some of that, but that's at the highest level in terms of intentional deprivation. It's created some more nuanced ways for the judges to deal with less severe discovery issues and problems through curative measures. And so I like to describe to the students what we have are what I call discovery fender benders, the minor accidents that occur inevitably in the course of extensive litigation. They're not intended. And we don't want to over-sanction on that. We don't want a get-out-of-jail-free pass. We want cases decided on the merits. But in those relatively rare circumstances where there are indeed real train wrecks, we want the court to be able to invoke properly Rule 37E upon a full showing of intent to deprive. The thing that I do emphasize to the students, and this is an inherent limitation of teaching a class, is that by definition, the cases that are in the case book are cases where problems have arisen. So I don't want to give them a disproportionate view. In fact, much of discovery is functioning outside of our vision. It's happening. We can see it in the dockets, and cases are moving along, and discovery is being handled properly. So I turn the students to what I say they need to focus on are best practices. And 502D orders, I just lead off with those because for years I've heard judges at conferences talking about how Federal Rule of Evidence 502D just should be automatic and that it's largely still unknown, not implemented. This is the scenario to protect against the inevitable and inadvertent disclosure in these hundreds of thousands of electronic documents being disclosed. Something on both sides is going to be disclosed that both sides want to pull back, and the 502D order is what accomplishes that. And then moving on to other best practices, the Sedona Conference principles are a wonderful place for all kinds of educational materials. And some things that I found in teaching the class too are that there are, Greg and Marcel talked about negotiating good protocols. And if we do this up front and we make the meet and confer under 26F meaningful, if both parties come to the table educated, they bring the technology experts who can in fact affirm whether something can or can't be done, the chances of heading off those excessive discovery motions, bringing the case to resolution are much better. And there's an abundance of materials out there to give examples of different protocols. Craig Ball has a wonderful preservation letter. It's a great sample. And then to conclude, one final tip that I found is in the spirit of forensics, and I'm not talking about forensics in terms of the technology, I'm talking about forensics in terms of a rewind of the videotape, the luxury of legal education, where we can look at mistakes that happen in a case and go back and see where was the point where the lawyers could have done something differently to head this off. And so what I'm able to do with students is to show in those cases where the judge has ruled in favor of a particular party, oftentimes the affidavits and declarations that were submitted by those attorneys give you a paper trail of what was done right, the defensible collection of information showing all of the steps, how the documents were produced properly. And that becomes a wonderful tool for students and a resource for practitioners who want to up their game. And I will stop there.
Thank you very much, Randy. That was very informative. And at this point, I'm just looking down at the question and answer sheet. There's currently nothing there, but anyway, I highly encourage people to go ahead and ask questions. So also, I have a few, and we'll get started then with what I have. This is just a question. Maybe it hasn't impacted your practice regarding e-discovery, but I'm just curious, has COVID-19 impacted, in your opinion, e-discovery? And if so, how so?
Well, I'll take a swing at it first. No. But here's why. From my perspective, the vast majority of e-discovery work right now has been being done remotely for some time, right? Your reviewers may not even be law firm employees, but even if they are, what they're doing is they're logging into a review tool from the comfort of their own home or possibly from offices all around the country. The data may or may not be hosted at your law firm. We host some of our own data, but the data may be hosted elsewhere. Very little of what we do in the e-discovery world requires people to be physically present at a specific location. The days of sitting in a document warehouse, reviewing page after page of documents in a banker's box are, for the most part, completely over. Even if you have a physical document production you have to do, that's going to get scanned in, probably as a PDF or a TIFF, and that's going to get reviewed remotely too.
So,
okay.
Yeah, from my perspective, it's 180 from Marcel's. When it comes to collection, when it comes prior to COVID-19, the pandemic, we were doing some remote collections for clients of ours that were accepting of that. What I mean by remote is that we don't send someone on site or the device isn't shipped to us. We send instead like a remote kit. We use some other technology to remotely collect the data. And a lot of clients and law firms were against that. It was just something they didn't know, and so they weren't comfortable with it. That changed completely. When COVID hit, we sent most of our staff home. They were able to work remotely to do the analysis and things like that. But I probably spent the majority of my time here in the office shipping things out, taking in shipments back and forth as far as doing remote collections. And so the ability to do remote collections it's gotten a little bit better, but really what's increased is everyone's comfort level. Nowadays no one has a problem with, go ahead, let's collect my cell phone, remotely, or my computer and things like that.
Interesting.
I think I'll just jump in from the standpoint
Sure.
of legal education. And in teaching classes online, by necessity over the past year, students are learning new skills in terms of how to use Zoom, as the courts increasingly have online hearings. Our pretrial litigation class was converted entirely in that fashion. And, happily, we will be prepared for preparing students for both in-person and online court representation.
Great. Okay, we do have a question that came up. Thank you. This is a very informative program. Now, what if you need to search across old email mailboxes, which are archived and backed up and not in active production?
That's not really much different than, from my perspective, not really much different than anything else. One of the things that kind of left out in my talk is kind of the desire by some people to use, a lot of people use Office 365 for email, and therefore they have a desire to use sometimes the search tools in Office 365, which you can do to an extent, but they are deficient in a lot of ways. You just have to understand that. So I think maybe what this question is about is they don't have the mailboxes in a system that's searchable. So it's just like normal e-discovery. You collect that data, you document where you got it from, and then you decide how are you going to search it. You know, it's going to be indexed with some type of tool, OCR, non-searchable documents, and then you're going to apply search terms to an extent before it moves on to, you know, the next phase as far as, you know, Marcel and his team in the review. So it's not, you know, of course, if they're on backup tape, things like that, then there may be some technological hurdles to get at the data, especially if you're talking about, like, instead of archived PST files, you're talking about an entire archived, maybe mailbox store or virtual archiving of an Exchange server. Then it's a matter of, you know, bringing in people that understand that technology and you know, how to go about doing that. You know, we've dealt with that, whether we're restoring the entire mailbox store and picking off the mailboxes to be searched, or just restoring different mailboxes. It all depends on what the technology and how it presents itself and how you go about doing it. So the devil's kind of in the details with that, but there are tried and true practices in doing that.
So I agree with all that. I'll just add this gloss to it. It does depend on the nature of the archive. If what you're talking about is, you know, a strictly disaster recovery backup tape system where the only reason the business employs the system is in the event of a complete catastrophic failure and it's going to reload everything, I will often argue that going into that backup system in an attempt to find specific emails is going to be disproportionate and crazy expensive. On the other hand, if it's just, you know, literally that they've got it in some archive folder, that's not going to be a problem at all. So I really think it depends on the nature of the archive and why the client archives the data. It's really hard to argue. But here's the way I usually put it. I ask an IT guy this question, because IT guys will always tell you something can't be done when what they really mean is it's going to be a pain in my butt to do it. So I always ask them this question. If the CEO calls you and says, I deleted this email by accident, I need a copy of it, are you going to get him a copy of it? If the answer is yes, then we're going to have to do that for purposes of document production. If the answer is no, there's no way for me to do that, or I could do it, but it's going to cost $5 million, then I'm going to argue that it's disproportionate and that I don't have to do that for purposes of document production.
Okay, another question. GDPR and other privacy regulations, friend or foe?
GDPR is terrifying for an American multinational company, right? You're based in the United States, you're involved in litigation in an American court, but you have emails and personal data from your EU employees. There have been, to my knowledge, 3 or 4 federal cases that have addressed this question in the last couple of years. If the defendant asserts that production of specific emails could cause it to violate GDPR, does it nonetheless have to produce the emails in American litigation? And so far, for various reasons, the district courts that have addressed this question have said, yeah, you sure do. Really for 2 reasons. The first is district courts are not necessarily convinced that making that document production will violate GDPR. And they point out that no one has yet found a single instance of a data protection authority enforcing against an entity in the EU for producing emails that are responsive to requests for production in an American court. So there's that issue. And second, the American courts ultimately tend to say, look, too bad. This is an American court, and I'm ordering you to produce these responsive documents. And if that causes you a problem in a different country, that's really your problem. Too bad, so sad. So if you really are faced with a potential GDPR problem in document production, it can be the source of a lot of anxiety.
So I'd say it's been friendly from the standpoint of it's gotten companies to think about, do they really need to keep all this data? It's really brought information governance to a to the forefront, and companies are talking about, gee, do I really need to keep this or not? It's also provided some challenges. Worked a matter where individuals were over in the EU, and when they say you're only getting certain messages, well, you are only getting certain messages. So one of the solutions we kind of came up with, we're setting up, using the cloud and setting up virtual machines that were physically located in the country where the custodian sat. So we didn't have to pull the data out of their country or anything else like that. And then processed all the data up there in the cloud on that machine. That meant using that machine to collect the data, using that machine to slice and dice that data, and then provide it over, and even sometimes for review. So it's led to, I don't want to say friend or I don't want to say foe from that standpoint. It's just gotten people to think about new solutions. What's a different way we can go about doing this to alleviate concerns from that standpoint?
Great. Again, anybody, and they have been coming in, any questions you may have, but I'll go to one I have. What, in your opinion, guys, is the worst part about e-discovery? The judge, the complexity, the cost, the lawyers, or whatever, what you may think?
The worst parts are clients, opposing counsel, and judges.
Okay. Do you want to elaborate?
I will. So, there are really two complexities here. The first, and I alluded to this when I started, was the severe misunderstanding of this technology and its capabilities that you see exhibited often by lawyers who do not represent commercial entities. So I don't want to throw stones at the plaintiff's bar because many of these lawyers are phenomenal lawyers, but they don't deal every day with the problem of how to find emails in a massive pile of emails, or how to find text messages in a massive pile of text messages. It doesn't take a lot of effort to draft a set of requests for production, but it can take enormous effort to try to respond to that set of requests for production. And lawyers who, as a normal rule, only have to go to a single individual to ask for those documents have little understanding of or sympathy for lawyers who have to deal with a very large enterprise. It's magnified by the confusion that a lot of judges have as well. First of all, judges hate discovery disputes as a rule. I mean, some judges will get engaged, but most of them loathe dealing with discovery disputes. And they tend to be somewhat suspicious of any lawyer who says no, right? When a lawyer says, I can't do X, there tends to be a suspicion about that. So that's one of the problems. And the other problem is dealing, frankly, with opposing counsel. Again, I alluded to this earlier, who don't know how to ask for what they want, right? They send these incredibly broad requests for production, refuse all overtures in an effort to try to narrow them. That forces you either to make a decision, go to the court and bring a discovery dispute to the court's attention and ask the court to narrow it. And again, courts hate it, so you can only go to that well so often. Or you give them what they want, and then when you do give them what they want, inevitably they complain that you gave them exactly what they want.
I'll jump in with some perspectives of my worst from the perspective of students going into practice and clients, as Marcel mentioned. What about the scenario with a junior associate who is told by a company or an executive, no, we don't have that information. We did not participate in that patent standard setting hearing. You can't take the client at their word, but what a tension point that is. You can't offend the client and say that they're liars. You have to have some means of strategies that are use smarts in terms of how you double check. And then are you supported by your supervising attorney who may not want you to probe too deeply with the client? Those are some obviously ethical issues that young lawyers are going to have to face. The second worst for me is, once again, those repetitive mistakes. And I could pull up any number of cases, but what struck me was a few years ago when the McDonald's CEO was forced out after being involved with improper working relationships. An internal investigation was done at that time. And interestingly enough, they overlooked information that was on his cell phone. So you would think, in conducting an internal investigation, McDonald's would have had top flight lawyers who would know how to do this properly. And it seemed like such a basic omission that resulted in so much extra work, and then the subsequent lawsuit in terms of trying to sue the former CEO. And there's just a plenitude of those worst examples out there as well.
All right. Still, any questions you may have? Next question. What are the essential technical competencies for e-discovery? Beyond, two parts, beyond the essentials, what makes for a successful e-discovery team?
I think it's a collaborative team. You need to have one where from the beginning, you're bringing in, again, the legal, you're bringing in key witnesses, and you're bringing in your technology group. When you don't do that up front, you find yourself behind the eight ball, whether it's all of a sudden a deadline that pops up and you don't realize some of the technological hoops you have to jump through to get the information you're looking for and get it in the format you need it in, and so on. Without legal, you don't have a good understanding of what really is required of you to do to satisfy the discovery request, or if there's a subpoena or what have you, or a motion to compel, and describes a certain process by which this data has to flow or this review has to flow. If you don't have all those people together to discuss it and understand it, then that's where you end up with missing information, or you just don't get the job done right. And then, like I mentioned too, bringing in the witnesses or the custodians, understanding from them, where the data now, to Randy's point, and as I said before, you can't always believe, the client themselves, but at least you can get some information from them, some understanding from them as far as where the data exists, what they use, and so on. Even something as simple as open up your computer, open up, File Explorer. Show me where you go to save your data, or at least where you think you go to save your data. And then that's a good, jumping off point from there to then get to the bottom of where that data really resides, and where else it might be.
Okay. At this point, we have about 6 minutes left. I'm going to ask our wonderful panelists. By the way, at this point, I would say let's give our folks here a hand, and everybody would be clapping. But I think you gentlemen did a very rousing, gave a very rousing panel. And for someone like me who defers to your expertise, I learned a lot. So thank you very much. Any parting shots, you guys?
Other than if this was a late afternoon presentation, we'd hear a lot of snoozing on the other end, I think, since we turn the speakers on. But I mean, it can be a boring and dry subject, but I think Marcel and Randy brought in some really great perspectives from the legal and the education side. I know a lot of times when I sit in these presentations, I don't hear a lot from the legal education side, and some of the things that Randy brought up I thought were really, really insightful. So hopefully our attendees got a lot out of this.
In that regard, we just got a comment. Fantastic panel. Thank you. Another comment. Not boring at all. Thank you.
I think the only thing I would add as a parting shot is think about defensibility. think about how you are going to explain to a judge how you did what you did, why you did what you did. Don't be in a position where you're in front of the court at a case management conference, or God forbid, at a hearing on a motion to compel, and the judge says, why did you do this? And your answer is, I don't know, I'll have to get back to you. Although that is a better answer than making something up. Document your decision-making, recognize that you're making decisions today that may not be brought to court for a year, year and a half, 2 years in some cases. So document how you arrived at the conclusions you arrived at. And when it comes to your clients, trust them, but verify. Even the clients who are being completely honest with you often have no idea what data they really have. The general counsel never knows what data they really have. I mean, inevitably, general counsel's office is in the dark about what people are actually doing on text messages, for instance. So trust, but verify.
My parting words are, it can be a dry and boring subject, much of it, but it is vitally important. And especially in this age of disinformation, what is essential to defeat that is the truth, authentic evidence, the pursuit of that. It's a very worthy cause.
Well, fantastic. Gentlemen, again, thank you very much for your time today. We are coming to the end of panel one. I encourage everyone to come back and be back by 10:45 for our next panel on cybersecurity, navigating the gray, if you have the time. So once again, thank you all. We'll see you in a bit. Hello, everyone. Welcome back to Legal Tech Innovation 2021. And I should say that's Ignite Legal Tech Innovation 2021. Day 2. And I just wanted to tell everyone that a question came up. The code actually will be, the code for CLE will be mentioned at the end of the conference. There is only one code, okay? And now I want, also I should mention the sponsors. That's MALCO, Mid-American Association of Law Library Consortium, and the Case Western School of Law Judge Ben C. Green Law Library. With that said, at this point, I want to introduce the next panel, Cybersecurity, Navigating the Gray. Your moderator will be Robert Ekman, Chief Information Security Officer from Kent State University. Go ahead, Robert.
Thank you, Joe. Appreciate that. I'm assuming everybody can hear me and see me okay, and I can hear and see everyone else, so that's good. So first of all, I wanted to thank Joe and certainly Case Western Reserve University for hosting this critically important event. I mean, this topic, these topics we've been discussing these past few days are absolutely critical to understanding not just cybersecurity and privacy and compliance, but also, how we're going to ultimately keep people safe in the future, keep them safe oftentimes from themselves, but sometimes from bad people and bad actors who want to do bad things. And so I'm very proud to moderate this panel. I think we've got, a wonderful mix of talent and understanding and experience from the industry to bring to you today. I've had a chance to commiserate to some degree with each one of these folks over the past couple of weeks on this panel. And certainly tons of respect and admiration for the work that they do each day in their respective fields. And so without further ado, again, my name's Bob Ekman. I'm the Chief Information Security Officer here at Kent State. And I'd like to if I could start with Sue, if you wouldn't mind, maybe introducing yourself a bit to the world and say hello.
Thank you. I'm Sue Workman. I'm Vice President of University Technology and Chief Information Officer here at Case Western Reserve University. And I have responsibility for virtually all technology at Case Western Reserve. So I always tell people you can blame me for almost anything that goes wrong here. Or hopefully you can say, oh, great job. But I'm really looking forward to this panel. I appreciate being invited.
Well, thank you, Sue, so much for attending. Mark, how about you?
Thanks. I'm Mark Schultz. I'm the Goodyear Tire and Rubber Company Endowed Chair in Intellectual Property Law and the Director of our Center for IP and Technology Law at the University of Akron. My research focus and a lot of my work in recent years has focused on information security, and that's trade secret law and then cybersecurity law, which, cybersecurity deals with the threat vector, but ultimately we're all trying to protect our information and systems. And so I see the topics as united together. And I've worked with the OECD and the World Intellectual Property Organization and have written reports and of course, ordinary academic research on this topic. And thank you for having me.
Excellent. Thank you so much, Mark, for being here. Greatly appreciated. Robert, how about you, please?
Hi, I'm Bob Fernier. I'm the director of the Lunsford Academy for Law, Business, and Technology at Chase College of Law in Northern Kentucky University in the Cincinnati area. I teach digital privacy and security to masters and law students and have done that, I guess, for a couple of years. So my interest is primarily academic, although I've been practicing nearly 40 years. I was on the e-learning task force for the ABA and vice chair of ABA Tech Show. What I've primarily tried to do in the last few years is to teach a very, very comprehensive, wide-ranging number of issues on a very rudimentary level to new lawyers and MLS students. It's quite a challenge because I have to say that this area, as with all areas in law and technology, I've created an online program of 8 different courses for law students and MLS students, is that it changes literally every month. And so, we're talking about ransomware today, and the White House is launching a new ransomware initiative this morning. And so you can be an expert one day and behind the times the next. And so I think we're all going to struggle a little bit not being able to respond to every possible new development, but I think we'll give it a shot. Thank you.
Thank you, Bob, very much. And absolutely no doubt, when we think of security, we oftentimes think of keeping bad people out. And I think what gets lost in that messaging sometimes, especially coming at this, if you look at the panel, if you look across our panel, we've got, somebody who's been in the IT space, a leader in IT in this area. Sue didn't go into a whole lot of her background, but she certainly played a pivotal role in helping us to establish the Northeast Ohio Cyber Consortium. And I've been party to watching her do much of that work. Mark and Robert, I've had less interaction with you over the years, but certainly I think when you look across this panel, I don't want to give away anybody's age, but we've probably got about 100 years of experience between the 4 of us, right? So,
I think you're being generous.
I'm probably being generous. But truthfully, though, when you look across this panel, what we bring to the table is a solid, IT understanding, a solid IP understanding from an intellectual property perspective, a solid legal understanding as it relates to data. And certainly, I do my best to bring the tinfoil hat approach of being a good security person. In addition to that, I also have been an adjunct professor in this space for about a decade now here at Kent State University and also at Cleveland State University. Here at Kent, I've been blessed to teach, digital science or emerging technology students cybersecurity, which is fun. Try to keep it real simple and straightforward because it's an introductory course. Up at Cleveland State, I actually teach for the Cleveland State Marshall Law School for Brian Ray up there, help them to establish the Center for Privacy as well. But in my teaching there, it's a very different application of cybersecurity. It's much more focused on the data compliance, legal issues, auditing, more of the, what I'll call the soft skills and security that we desperately need. Oftentimes when we think about cybersecurity and privacy, we think about this huge SWOT of requirements and approaches and defenses that we have to have in place. And one thing that I talk quite a bit about is defense in depth, putting as many barriers between us and the bad person as we possibly can, just to make it harder for them to get to us. I mean, if we're all being brutally honest with one another, the truth is, if a nation state wants into our environment, if they want our data, they're probably going to get it. So I make it abundantly clear when I talk about cybersecurity, whether it's here at the university or elsewhere, I ask people to really change their paradoxical thinking about security. It's not a matter of if it's going to happen to us, just assume that it will. So it's not if, but when. And what I like to do is prepare organizations to be resilient in that space when that occurs. So it's be able to recover, be able to move forward, be able to react and respond should it occur. And so what we did today is we assimilated our ideas for topics for this panel. We kicked around a number of thoughts that we wanted to cover today. Some of which, I'll be honest, AI always bubbles to the top. When we do blockchain, always bubbles to, whenever we talk about security and especially legal challenges. But as we looked over what other panels were looking at, we really kind of decided to stay away from those topics a little bit and focus on some other topics that really spoke to a couple of different things. One is certainly the defense in depth model of, thinking in terms of your cybersecurity programs at your organizations, whether you're a lawyer or a cyber person or an IT person, thinking in terms of defense in depth, thinking in terms of as many barriers as you can put between yourself and the adversary. And the more diverse those barriers can be, the harder it will be for them to get to you. With the thinking there being essentially that basically it's like the ADT sign in the front yard, right? It's the sign that says, hey, in the Doberman in the window kind of thing. The bad guy, might come up and case your house and go, you know what, I'm going to go to the place that's not as difficult next door. And so that's essentially what you try to do, is assimilate a security program robust enough to do that. Another big topic that we wanted to consider, and we probably should keep top of mind as we move forward, is this notion of adaptive risk. And what do I mean by that? Adaptive trust and risk. And that is that trust and risk are constantly evolving. Back in the old days of IT, back when I like to say when I had bangs, you used to be able to put in place a trust program and pretty much be good with that and move on to the next thing and just trust that technology was working. In today's day and age, number one, there's simply too much for us to monitor. We cannot possibly monitor everything. So we have to take this adaptive approach to trust and risk and identifying what's most important to us and monitor that the most. And I hate to say it, but identify what's least important and perhaps monitor that the least. The point being is you have to understand what you have in order to do that. So that's kind of the second big pillar of our conversation today, is around this notion of adaptive risk. So defense in depth and adaptive risk. And then the third big piece, honestly, is just awareness and legal understanding. How does all this apply to the legal world? And so we came up with 3 topics today that we felt were very good for us to discuss. And I'll be honest with you, we put a hook right in the beginning of it because we wanted Mark to kind of present this notion of ethics and talk about ethics, especially as it relates to data and IP. And so we're going to go into that here in a minute, but we also have some other topics that we hope will interest you greatly. The second topic really focuses on vendor security and vendor compliance, which, if you think in terms of the SolarWinds breach and the Microsoft challenges that have existed and so forth, I feel that is a wonderful topic for us to explore as IT security and legal people working together. And then the third topic, as Bob had mentioned, is ransomware. I don't think we can get out of a cybersecurity conference these days without touching on it. So I just kind of wanted to give you a preview, a little bit of a teaser as to what you'll see today and what you'll hear today. And certainly turn the controls at this point over to Mr. Schultz, who's going to walk us through this notion of ethics as it relates to security, as it relates to privacy and data. Ethics plays a huge role in who we are as an organization and who we support. And I think that it oftentimes gets lost in the mix of different types of attacks. And it's certainly in the fog of war during an incident response, keeping your handle on ethically what you're doing. It's easy to put in place a tool that lets you probe an environment and get all kinds of data. But it kind of goes back to the Jurassic Park thing. Just because we can doesn't mean we should do it. So Mark is here to give us a talk on cybersecurity law in general, how it applies to what we do each day, and the focus on ethics. And so with that, Mark, I'm going to turn it over to your capable hands.
Thanks so much, and I really appreciate the chance to be on this panel. I'm certainly not the security or IT expert that some of my colleagues on the panel are, but let me tell you what I do know. Okay, so first let's look at the topic and the nature of the threat, and then I want to talk about some of the obligations that law firms have. But from the law firm perspective, or really, I guess, maybe from a general perspective, when we're trying to protect a system, we largely want to protect it. We need to remember we need to protect it because we have other things we're trying to do. Like cybersecurity, as I mentioned earlier, is a threat vector, but there are plenty of instances where if you have valuable enough information, it walks out the door with only a low level of technology involved, and even human intelligence is often used. In the trade secret field, we hear these kind of talks from the FBI all the time that sound like Cold War spy novels, but aimed at middle management of tech companies who probably never dreamed they'd be the subject of a honey trap or something that's straight out of an old spy novel. So there's a lot of different threats to your information. And one way to think of this is we have, on the one hand, we care about cybersecurity because we have systems that need to be up and available. And boy, we really saw that with the pipeline incident, that it's not just the information in the system, it's also the availability of the system. We also have confidential information. And from the law firm point of view, you have a general duty of confidentiality, I'll talk about in a moment. But you have this kind of weird problem in that your clients are constantly come to you with different problems and divulge different information to you. And so you have this fluctuating level of sensitive information on your systems. And candidly, you sometimes may not understand how sensitive it is. And that's a challenge. I remember as a young associate getting the lecture about not talking about our cases on the elevator because we didn't own our building completely. And it seemed like you almost dismissed it at first. Well, what do am I really working on anything that important? I guess maybe I had, a more modest point of view as to what I was doing as a young associate. But I came to realize some of the things we were working on would move markets. And it was insider information. So you could, from one day to the next, a law firm's systems may contain client information that could be the most valuable trade secrets of your clients. It could be information that could move markets, or it just could be very personally sensitive information for people. It's a wide variety of information. And so when we look at confidential information from the law firm point of view, we have a very general duty, but we have some specific duties. We might have trade secret obligations. We might have privacy and ethical obligations. We also may have specific obligations. If we have financial data, as I mentioned, you may have a wide variety of financial obligations under federal law. And overlapping these issues of system availability and protecting information, you have obligations to third parties, your clients, and also other people whose information you may have, and national security in some instances. So who's out to get you? I don't think I need to belabor this point to most of you. So the thing is, there's so many different threat vectors: the unscrupulous competitors and employees, the thrill seekers, the crooks, and so it's challenging when one thinks of this area. One has to realize that there are all sorts of threats out there, and I think what the ransomware situation is teaching a lot of us is that even people who don't think of themselves as above the radar or that important or having high stakes information can find themselves the subject of a cyber attack that is extremely destructive because your information and systems are important enough to you that people can extort money from you for them. Okay, let's talk about law firm vulnerability. As Robert said, it's a matter of when, not if. And the ABA, the American Bar Association, has made that point as a matter of ethical opinion. You should expect to get hacked. And the number of law firms reporting a security breach in 2020 was 29%. And so when you figure that's just an annual reporting requirement, when you figure the old adage applies that you've either been breached or you don't know that you've been breached, but you've certainly been breached. 29% is certainly a low end figure. So law firms are vulnerable and under attack, and it's a regular problem. So what do we need to do about it? Well, let's talk first about the ethical obligations under the rules that govern lawyers' practice. And then there are a couple other brief points I'll make. Okay, but let's focus on the ethical issues. Okay, model rule 1.1. Traditionally, this rule applies to competence. We need to provide competent representation. Interestingly, since 2012, cybersecurity has been part of that obligation. And so your duty of competence as a lawyer now includes competence in selecting and using technology, including cybersecurity. And you have an obligation to keep up, to learn what you need to learn, or hire competent people that can help you comply. So communications. So here we now are obligated under formal opinion 483 to notify clients of a data breach. So we have to, if there's a data breach, we have to explain to them in a sufficient manner that they can make an informed decision regarding the representation. In other words, you have to be very candid with your clients so they can assess the threat just like any cybersecurity expert or IT function within a company would assess the damage done by the breach. You need, as the lawyer, to cough up that information to your client so they can do that kind of assessment. Of course, ultimately for lawyers, so much of our obligation falls under Model Rule 1.6. And as somebody who's taught ethics for many years, let me take a step back for our audience. Some of you know this quite well, but I want to point this out. A lawyer's duty of confidentiality is extremely broad. It's not just about information that would be a trade secret or information that's conventionally secret. It's all information related to the representation. And so, when I go through this in hypotheticals to class, to my class, one of them would be you're at a cocktail party, somebody comes up to you, starts asking you questions. Oh, you represent so-and-so. How are they doing? How's their business doing? Even though, probably anybody in town might be able to answer that question, as their lawyer, you should not comment. Except maybe in the most favorable generalities, but any information related to the representation falls within your wide duty of confidentiality. So when you think back to that, the diagram I made with the big circles, the law firm has a very big circle around its obligations to keep the information it has about its clients confidential. So within that large entire point of view, there's smaller areas of obligation like material that's attorney-client privilege, material that's constitutes your client's trade secrets, information that it falls under other obligations, but even the most mundane information is ethically required to be kept confidential. And Model Rule 1.6c tells us that a lawyer shall make reasonable efforts to prevent inadvertent or unauthorized disclosure or unauthorized access to information. And this particular provision was written with cybersecurity in mind. And so comment 18 to these rules states that tells you what you're supposed to do, a risk-based analysis, which makes sense for such a general set of ethical obligations. And given the general nature of practice and the very different types of information you have, indeed, your security obligations require a risk-based analysis, so that if you have your client's most deepest, darkest personal secrets, or your client's, commercial information that constitutes a large part of the value of the company, you have a very heightened, duty to protect that. Whereas maybe with more ordinary information, you might have a lower duty, a lesser duty. And of course, we balance that against what's feasible, practicable in conducting your practice. Of course, the challenge here becomes, as is often talked about in the cybersecurity area, the difference, the difference between a risk-based analysis and a compliance-based analysis. In law, we would often call this a standards versus rules problem, right? Where standards, the risk-based analysis is adaptive to each situation, but it requires a much more case-by-case analysis. The answer is uncertain until after the fact. Did you do enough? Did you do what you should have? A compliance-based, or as we think of in the law, rule-based system tells you exactly what you have to do, which may not be suitable 6 months from now when the security threat evolves. But remember, we're dealing with people who want to practice law, not be cybersecurity experts, so they are inclined to say, just tell me what I have to do. But the model rules say, yes, you have these obligations, and there are definitely things that lawyers do that are likely going to be the standard of care, but you have to have a level of security appropriate to the information you have. Okay, just to be clear, model rules 5.1 and 5.2 are the clauses that kind of sweep up all of these obligations into a management level responsibility. Historically, what we're familiar with is that, for example, lawyers have an obligation to bill reasonably, which means not cheat on their billable hours. And that's a personal obligation, but as a partner or supervisor, you also need to make sure the people who work for you are doing that right. The same thing with having proper docketing software, making sure your associates who work for you are competent. And now these duties have, in recent years, been expanded, of course, to cybersecurity. So if you're managing a law firm, or even if you're a mid-level lawyer at a law firm, you have a duty to make sure that everyone who works for you is meeting the cybersecurity obligations of the firm. And the comments make clear, in the commentary of the rules make clear that this extends to staff and outsourced functions. So you have the buck stops with the people in charge of the law firm. You're supposed to be, and you can't just shove this function off on somebody else. You still have a duty of supervision and a duty to keep up with this. So what are you supposed to do? Well, these are some really basic suggestions that, to many people on this conference, you just roll your eyes at. That yes, of course, these are the things we need to do, but they're at least a starting point for the discussion. And I've seen enough. I've read enough cases. I've seen enough law firms how they operate that having all of the basics would be a pretty big achievement. Hopefully not for the most sophisticated practices, but there are plenty of instances where people are relying on outdated software, poor password hygiene and functions. And of course, as we all know, as is the topic du jour, all the working from home has made all this that much worse. I think I'll stop there because I've taken enough time. There's certainly other things we could talk about. The law firm itself has tort liability potentially, which is still evolving in this field. You're also going to have some statutory obligations in some states, depending on the laws they've passed. Once again, another evolving area. This is still a young field in many ways, and we don't have comprehensive cybersecurity duties that are written into law, especially at the federal level. You have the FTC monitoring people, but the FTC's still really largely confines itself to false advertising. Essentially, if you say you have security that you don't, you could get in trouble. And of course, we have increasingly executive orders are trying to by imposing standards on vendors to the government, are increasingly trying to improve the standards for society as a whole. So I'll stop there and hand it back over to Bob and my colleagues.
Mark, yeah, leave that slide up for 1 second if you could, please, because I think what's an important point here to mention is very similar to if you have a relationship with a third party that needs contracted, the more risk there is in that relationship, the more elements you build into that contract to help mitigate that risk. Cybersecurity is a very similar game, not dissimilar at all, actually. And in fact, when you look at many of the basics that Mark has identified here, these are what I would call, controls that we would implement to help mitigate risk. And so you have to think in terms of the cumulative aspect of those controls. It's not descriptive as add cloud backup and you're good. It's cloud backup plus strong firewalls, plus antivirus software, plus strong password. All of this together creates a risk profile reduction. And so it's that cumulative aspect of risk reduction that really is what we're after here. So that's, and I think this applies very similarly from the cybersecurity technical space to the cybersecurity legal space. And so I'd like to, if I could, ask Sue or Robert, I'm not sure whom, Bob or Sue, which one of you would like to weigh in on this notion, but please feel free to contribute your thoughts and what you've seen relative to, what Mark has introduced us to here.
Sue, would you like to go first? I can take a stab.
Please, go ahead.
I'm coming at this from a different perspective a little bit, not having spent my career in cybersecurity or in the academic world. I'm in my 38th year of practice, and I had a very strong interest in technology. That's how I got involved in the ABA and the Law Practice Division. I'm on the ABA Law Practice Division Ethics and Professionalism Committee. And one of the challenges that we have as lawyers isn't that the knowledge isn't available or readily available. It's that we're dealing with an audience that still is reluctant to adopt technology that will benefit themselves and benefit their clients. It's an education gap. One of the things that we do at the Law Practice Division is to teach the 4 pillars, management, marketing, leadership, and technology to lawyers. We are a free member benefit to anybody with the ABA, so we're now one of the larger organizations, and I've been in leadership there. And part of my responsibility with the ABA Tech Show was to create educational programming for lawyers. And when you look at the recommendations that we've talked about today, and Mark didn't mention incident response plans, which can be, are an integral part of dealing with data breaches. Most law firms, particularly the smaller ones that we cater to at the ABA, they're never going to have something like that. And even the larger law firms, when you look at a organized, thorough incident response plan and all the responsibilities necessary to discharge your obligation under 477 and 483 that Mark talked about, most lawyers can't even begin to understand how to do that. So the great challenge that we have, I think, is in addition to having these great presentations from Mark or Robert and Sue talking about the practical aspects of cybersecurity and what lawyers' obligations are to that, we have to find a better, easier way to implement this knowledge. And to me, that's probably the greatest challenge, because when I teach rudimentary cybersecurity and data privacy, we don't have time to get to this issue. We might spend one module on incident response plans. but it's such a complicated area that it kind of reminds me of the old days when I was part of the environmental law department at Dinsmore, one of the bigger firms in Cincinnati. And it was brand new, and you just needed 2 or 3 people who knew something about environmental law to kind of be experts. And to find those lawyers in cybersecurity and privacy today is quite a challenge. I mean, one of the surprising things that I found out, for example, with, I guess it's 483, Mark, you know, our obligations and notification, for some reason, the ABA didn't include former clients, right? And that seems, if you have an obligation to inform existing clients, you would think that you would have to inform, you know, former clients as well. But there's so much information about these obligations, like those little known, you know, aspects of these opinions, that education is really the tough part. So what I think that the industry needs to do is to somehow package, you know, cybersecurities for dummies, and then find a way to outsource, you know, this information to really make it usable, because it's great information. It's absolutely essential. But as we all know, the #1 cause of hacks, you know, it's really social engineering. It's training human beings to really not make the mistakes. You can have all the technological defenses, but ultimately, when you talk about all the great hacks in the last few years, like the hack of the Democratic National Committee or the Hillary Clinton campaign, it's on spear phishing or phishing or something like that. Sorry, I didn't mean to dominate. Go ahead, Sue.
I'll just pick up there too. You know, you hit on it. I mean, it's the people that are probably the weakest part of this. And when you look at this list, or you look at incident response, you know, right now we still are fighting. We're fighting wars with hackers that are using holes from years ago, not necessarily yesterday. So I think, Mark, when you said you know, teaching your students, it's okay, because, you know, most of the things are vulnerabilities from, you know, years ago that people just didn't patch. And so, you know, it's not always easy, but I think all the, you know, the things that Mark has listed here, really, other than cloud backup, but we had an offsite backup, you know, those have been really good practices for a really long time. And we still find that, you know, people will allow these things to go through. I might add to your list there too, just to make sure you have a 2-factor authentication, and making sure that, you know, you at least ask twice who somebody is, and they have to prove twice who they are, at least. So, you know, I think that's a good thing. But also on incident response, I think it's something you have to practice. You know, you don't want to just have a plan even, but I think you have to practice, because your roles sometimes change. You know, if you go with the NIMS framework and those kinds of things, the roles that people play in their day-to-day jobs might change during an incident. And that's a really hard thing for people to let go of, the role that they have in a normal situation, and then perhaps go to being the commander, or going to be the public information person, those kinds of things. So I think it's really important. And while we always say, oh, we're going to do a tabletop on this, or we're going to do these, sometimes those get put off. And I would just say, you know, we need to make sure in practice that we are actually practicing the things that we want to have happen. And it really makes a difference when an incident does happen.
So isn't the problem the old motto that parents have to deal with? Do as I say, not as I do. You know, eat your vegetables, and we go to McDonald's. I mean, I'm embarrassed to teach cybersecurity and privacy because of my bad habits, right? You know, I really do want to know if that Nigerian prince has $2 billion in the bank that he wants to send to me, that I might get my $400,000 cut. You know, you almost can't resist sticking your finger in the fan because social engineering is so powerful. And when I show students some examples of social engineering, like a woman with a recording of a screaming baby, you know, calling up the IT department and says, I can't find my password. And, you know, and we all succumb to our own human vulnerabilities. And that's a great challenge for cybersecurity, even in the law firm environment.
Certainly.
So an interesting thing about the law firm environment, I practiced 10 years before I was an academic at both medium-sized and very, very large firms. You know, there's a sociological aspect to law firms too to keep in mind. One is they're very hierarchical, and the people at the top of the hierarchy are often the oldest. So when I started practicing in 95, for the next, you know, well, really for the next 10 years, there were still partners who had their secretaries, because they had them at the time still, print out their emails, and then they'd write the responses by hand. Now, sure, there's a younger generation in charge now, but they're not, you know, they're not the millennials. They're not the Generation Z folks. They're older. They're struggling. And the second issue is that the billable hours are king. So anything that doesn't contribute to the bottom line gets shoved aside, and even often very important things. That's that's life in a law firm. And the third thing is that very interesting point that you made about roles changing during a cyber incident. It's sometimes people who usually take orders are giving orders. And I remember on 9/11, we were in a very tall office building, and it was basically the people in charge of our emergency response were pretty, down, people lower in the hierarchy who usually took orders, and they were coming around and ordering us out of our office. And I remember there were a few partners who kind of grumbled about it, and they had to be really sternly disciplined by people who aren't used to doing that. So that's a problem too in a hierarchical environment, is you get these role reversals during an emergency that you don't have people who are used to responding, to playing roles that they're playing. So that's interesting too.
Mark, I think it's even worse than that. What we do in big firms is to delegate to the IT department, right? And these are the guys that, if you remember the Saturday Night Live routine, the kind of nerdy guys who come in and they're not like leadership quality. And we assume that we're paying somebody, so much money to take care of these IT issues, when in fact, it is really a, bet the bank kind of, bet the store kind of issue when you've been hacked. And the IT folks, they understand that nobody is going to listen to them until it's too late. And that really is, so it's not just the younger lawyers, and the older lawyer dichotomy. It is lawyers are king. I mean, my ego was so huge. And when I got hired by a big law firm, I thought I was 1,000 times smarter than I really was, and I couldn't change the oil in my car, right? So I think that is another challenge. It's just the structure of law firms, particularly medium to large size law firm. The people with these responsibilities that we're talking about today, they don't have the support and the respect that they need to have to prepare the law firm for this eventuality, which you have quite rightly said, it's not a if, but a when situation. And then when it happens, those who are responsible for really solving the problem, it's really a finger in the dam type of situation. By then, all kinds of bad things are starting to happen. And then the whole embarrassing question about, am I really going to notify my clients about what happened and the potential for a leak? Or am I going to do what so many law firms do when it comes to self-policing ethics issues, just not say anything?
So I think this is, Bob, you've touched on some endemic parts, Mark and Sue as well. We started our conversation today talking a little about adaptive risk and trust, right? And this notion that we can't possibly watch everything. We have to be very selective about what we go after. And Sue had touched on that notion of the incident response drills. I would strongly encourage that if you are a lawyer working for a company, working in a law firm that supports companies, you should be offering to take part in those drills. You should be at the table, listening to what's happening and understanding what's happening, because oftentimes when we go down the path of incident response, we oftentimes have to include legal. And then back around to that adaptive trust piece, make sure that program is ready to address most recent threats. If you look at what happened with the Colonial Pipeline attack, which we'll talk about a little bit later today, that was a very different ransomware attack than from what we've seen previously. That was more of an operational attack than it was necessarily an encryption attack or a ransomware attack, a traditional ransomware attack. So make sure that you're revisiting that program and that it's positioned to support you. And then the last thing I want to touch on before we go on to our next topic, this has been a wonderful conversation, Mark, and thank you again for leading us through this. This notion around it's too late, right? And I think, Bob, you had mentioned that. It's too late to try to figure these things out when you're sitting in the incident. The fog of war kicks in, and I will absolutely assure you the fastest path to remediation almost always becomes the right path, whether it's the right path or not. So my suggestion, it's almost like organizations become addicted to this mediocrity. Like, it's okay, we're doing enough to keep the lights on. We're doing enough to keep security in place. Let's just keep that where it is so we can invest elsewhere, not realizing that when bad things happen, those investments elsewhere get pulled back very quickly. So this whole conversation is really around culture, and it's around hearts and minds, and it's around helping people to understand the role that security and privacy plays. And I think this has been a wonderful discussion on that front. With that, I'm going to ask that we move on to our next topic. Mark, can I go ahead and share my screen, please? Okay, you should be able to see my screen now. So this was our first conversation around ethics, and I think we covered the majority of these issues. I'd like to switch topics a little bit and help us focus a little bit on technology vendors and discussions. So what constitutes a vendor security program in any typical organization? So vendor security has become a much bigger topic for us as we've experienced many issues as it relates to vendor security. SolarWinds is a great example of that. We had a situation where we had a vendor who was implicated in some way and had an issue, and they were not able to resolve that. So I would ask that this group kind of delve into this topic of vendor security and how do we keep things safe and how do we ensure security as we move forward? Who wants to start with this topic? Let's start with Sue.
Okay, thanks. So this is a big deal, and I think, it's become bigger recently with SolarWinds and certainly the printer nightmare thing and Cassia, all those things. And so I think there's some really big things that we really have to think about here. And again, preparing for a problem. So, but it starts with the contract. I think the very beginning is the contract that you have for your system. So I heard this morning actually that some software is sold from another company. So software might be represented by another company. So Microsoft might have Dell represent them or others. And so, but what those, and they're called VARs, usually value-added resellers. And those VARs are starting to have an indemnification that protects them should the company they're representing have a security problem. So if you bought from the VAR, then you may not be able to go all the way back to the originating company, and then there may be securities between them. So the contracts have to be very, very carefully looked at, but also you need to be very aware of that. And then also, I think, Bob, it was you maybe that even told me that some cybersecurity insurance now are eliminating this as an insurable event. So I think we've got to make sure that our cyber insurance is up to date and we understand what those mean. But I guess, for the departments outside IT that you should consider including in the strategy, I mean, certainly the risk organization, risk and compliance, they need to be involved in here as well as legal for sure. Here, we would, of course, have IT security, but we probably also might include some faculty members that have this as a expertise and get their opinions as to what we might do at Case Western Reserve. But, I think this is certainly a topic that in the last couple of months has really opened my eyes to see we really got to figure out how to deal with this whole vendor security thing.
We do, and vendors, and you mentioned right off the top that it starts with the contracting. I would argue that it actually starts before the contracting process. I do that we're evaluating vendors prior to and understanding their cybersecurity posture so that we can include in that contract those very critical elements. Mark, would you like to add anything, or Bob?
This is Bob. I'm going to definitely defer to Mark in just a second, because this is outside of my area of expertise. But one of the things, I'm obviously a big ABA guy and a big fan. The ABA put together a cybersecurity task force. And for this event, this kind of vendor risk management program, they have an excellent they've done an excellent job of kind of putting together 83 pages of what you should look at in order to and I'm going to try to share this without having to share my screen necessarily. Let me find it. And it's a very, very comprehensive, at least their perspective, checklist for vendor contracting, and hopefully some of you can see it there. I highly recommend it. It's the 2021 second edition of Vendor Contracting Project Cybersecurity Checklist. And as I mentioned, it's 81 pages long. So it doesn't, while it's directed at lawyers, it's really more of a checklist that any institution can use and everything else. So I'd strongly recommend that you take a look at that. And if you're teaching that subject, it's a great all-in-one checklist of all the different issues that you might want to look at and to frame for your students.
Very good, thank you. That's very good advice. Another area for us.
So, I had a couple comments on this too. So the background law and the standard contracts can be a challenge in this area. Tort liability for vendors is still an evolving area. And don't forget, think about what the sort of the whole industry, the IT industry looks like writ large. What's the standard of care there? Well, do you expect a product to work perfectly? Have you ever bought a piece of software, office software, that worked just well as your car? No, it's constantly subject to updates and patches. And that is part of the standard of care in this industry that many are starting to object to, or have been for years, that they're, for security vendors, there may need to be something more like strict liability or some heightened duty of care. But the tort obligations are actually relatively, the standard of care for vendors is actually shockingly low. Second point is then when you get to the contracts, well, you could try to fix this in contracts, but you're in a negotiation with the vendor, and the vendor's trying to protect itself. And so this is what I did. I did IT transactions from software licensing to billion-dollar outsourcing deals in practice. And what fascinated me was some of the mission-critical vendors. Their lawyers would try to include things like force majeure clauses. And now, not to get too technical for everybody on the conference, but you know what a force majeure clause is. It excuses your duty to perform in the event of a disaster. And I remember laughing out loud at seeing those clauses sometimes, saying, my client's hiring you for disaster problems, right? For if there is a disaster, you're supposed to be the ones that ensure that we get through it okay, and you're trying to excuse your liability. Well, this is standard in a contract, not this kind of contract. Another issue is when you're dealing with some of the bigger vendors, the big companies write contracts that disclaim everything. So, I was in the field as it evolved, And I remember when the big companies, IBM and at the time AT&T, others started to enter it. And for the first time, we started to see these form contracts written in 7-point font. And I remember I had a client ask me to review it and review one of these contracts. And I got, about a half hour into the exercise, and I realized it was kind of futile. And I told the client, essentially I can sum up this agreement that says whatever happens, you lose, we win. And really what it comes down to is a piece of business advice. Do you want this name brand vendor who has done everything they can to contractually avoid liability, or are you going to work with somebody you can negotiate with? And there's pluses and minuses to both. And you have to get pretty big and be a pretty important customer to be able to actually negotiate contractual liabilities with big vendors. Microsoft is probably not going to negotiate with a small university or a small law firm. So that's the sort of thing you have to think about. Like, you have to be aware of what the background liability is and what the tort rules are, and what the contracts say when you're choosing a vendor. And legal, that may come into part of the decision as to who the appropriate vendor is, because you do have some vendors that are trying to shield themselves inappropriately, I think.
Mark, Robert, my background is in litigation for all of my career, primarily for large corporations and governmental entities. And I will tell you, for those, we have 75 participants online, and I dare say that a number of those are litigators, plaintiffs' lawyers or defense lawyers. And I foresee that this area is going to be one of the new areas for litigation and litigation opportunities, whether you're a class action lawyer. We saw that with the Colonial Pipeline incident. Class actions were filed almost immediately. And it's interesting because once you, a lot of my litigation experience was in risk shifting, representing the top dog and then going down and trying to pass that risk on to everybody else. It's a very, very complicated area right now of litigation to say who's at fault, because SolarWinds distributed that software to hundreds of companies that were affected. And at the end of the day, each one of those companies is going to say the problem wasn't us, it was with them. You'll have it, suits for indemnity or contribution. And the complexity of these issues may seem boring to the litigator who's out there right now listening, saying, what do I care about, negotiating vendor agreements and everything else? But this is an area that if you're involved in litigation, inevitably, you're going to have to understand vendor relationships with principals, because I do believe that technology is going to be the source of a lot of business for lawyers, not because we're drumming it up, but because there are these responsibilities that have to be sorted out. And when you have a company, a vendor that has a problem like SolarWinds that affects the, hundreds of governmental entities and companies, somebody is going to come along and say, I've got a problem with what you've done with my data or what's happened with my gas prices, and I'm going to sue. And as a lawyer, who's not interested in IT or vendor contracting, having this little bit of information, maybe the kernel of information that helps you in your personal careers.
Yeah, I'd like to add to that, because I think this is an often overlooked area and focus of security that organizations tend to kind of just assume is happening through the contracting process, and probably shouldn't. The comment earlier around this could be the next big bastion for legal challenges, I couldn't agree with more. I'm not a lawyer. I don't play one on TV, but I do know, and I've been around the block a few times to know that vendors interact with our data. And at the end of the day, as this organization, we own that data. And if we give a vendor access to it, we can't abdicate responsibility for security to that vendor. We can't just say, well, we're just going to assume you're going to keep it safe. If you look at every single cybersecurity program coming down the pipe now, especially as it relates to like healthcare with HIPAA and others, they're beginning to focus more and more on vendor relationships. I think the HIPAA program here in the United States anyway was probably one of the most forward thinking as it began to include this notion of business associate agreement. But we're beginning to see other programs move in this direction. One of the big focuses we're beginning to see in the higher ed space is a myopic focus almost by the federal government on NIST 800.171, which is the control of unclassified information. That particular regulation has plenty of controls related to vendor controls and vendor evaluations. And so I think this notion that we own the data, regardless of who touches it, we still own it, we still therefore have to say grace over it, is incredibly important. And then this notion around assessing risk that we've touched on a number of times. So one tool that we use here is from EDUCAUSE. It's called the HECVAT tool, Higher Education Community Vendor Assessment Tool, HECVAT. You can look it up on the EDUCAUSE site. EDUCAUSE is spelled EDU-CAUSE, basically C-A-U-S. That solution really allows us to evaluate vendors. And so it's a spreadsheet. They answer questions. They get a score. It's actually quite nice to use. I would encourage you to take a look at it. It's focused on higher education, but you could easily manipulate some of the fields to focus more considerably on what it is you do. But we use that tool to assess vendors upfront as best we can. And then the last thing I'll mention too is we're beginning to see now our insurance providers are focusing more and more on our vendor relationships and what steps we're taking to do that. One thing we have begun doing is including a data security addendum with every contract that involves technology that basically is a laundry list of the cybersecurity requirements that we require. Of course, we put applicable language in there so that not every vendor has to meet every requirement. Some vendors won't interact with healthcare data, so therefore won't have to meet HIPAA. But certainly we want them to understand what our privacy, what our regulations are, what our compliance structure is, so that they can engage their program accordingly. Any additional thoughts relative to other guidance and approaches that people should be considering as they consider their vendor relationships from the panel? Okay, very good. So moving on to our next topic. So let me get this moving along here. The last topic we're going to touch on today is ransomware. Ransomware has become a much bigger focus as a community, as an organization. And I think it's important for us to focus on those threats that are most prominent. And certainly ransomware is one of them. We have to keep in mind that ransomware takes on many different flavors. It can be delivered in many different ways. One method for delivery is through being able to get access to an environment, be it through the firewall or through a backdoor, and then injecting malware into that environment in some way. A second mode, and probably the most common mode, in fact, this is the most common mode that malware is delivered into an environment, and that's through email, through a phishing campaign through email that fools people. I think Bob has touched a number of times on the social engineering aspect to this, getting people to click on things and open things and click on links to watering holes that download malware and so forth, and then or perhaps trying to get their credentials. And credential compromise, where they're able to steal credentials, is another method for adversaries to get malware installed. Once it's installed, its goal is really to do a few different things. The first thing they want to do is they want to find your most sensitive data. So they want to stay very covert in your environment and kind of scan the environment looking from different machines. So they try to move laterally and then look throughout different servers and endpoints for sensitive data, specifically, that healthcare data, that PCI data, payment card information, that financial information, the personally identifiable information. Their primary goal is to get their hands on that data so that they can then begin exfiltrating it. And exfiltration is where they pass it out through the firewall in small bits and they store it up on a website somewhere. Once they felt comfortable that that's been done sufficiently, they may also try to find your backups, because their goal would be to encrypt your backups and then begin encrypting forward to your production environment, so that by the time you notice you're being encrypted, it's too late. And then the third thing they'll try to do, of course, is ransom you. And then I think it's important for us to remember, as a ransom process, there's payments and all kinds of things involved. So hopefully this little opening to this discussion has generated a lot of thoughts on behalf of the panelists, on behalf of yourselves, as far as what ransomware is. But I wanted to ask the panel, if I could, what are some of the most prevalent methods of exposure that organizations see today? We talked about email and different things, but as we begin to talk about remote work and COVID, what are some of the legal aspects to that? And what industries do you see as being most at risk for ransomware attacks as we move forward?
Well, those are a lot of questions. In teaching ransomware to my students, hospitals generally tend to be the industries with the most sensitive information, like hospitals, tend to be the usual targets. And right now, I think the biggest problem that we have with ransomware isn't so much the volume that's reported in the press of several hundred million over the last 7 years of ransomware payments. It's the unreported, incidents that we're really talking about. So I don't think we have a really good sense of which industries are actually, being affected, how badly the problem is with ransomware. And the toughest part of your question, I really think, is a reporting issue, because the challenge that we have with ransomware really is something that Mark pointed out at the very, very beginning. When it happens, it's too late, right? It's almost like the way that medicine deals with COVID or something else. There's not a whole lot that you can do once it hits you. I mean, you can make sure it never happens again. You can try to get your data back and everything else. But there are very limited law enforcement responses. And it's not like you can call the cops and say, look what happened to me. Can I get some justice here? Although, ironically, I saw that the DOJ several weeks ago was able to recover the vast majority, or they think the vast majority of the Bitcoin associated with the Colonial Pipeline ransom attack. But I think the challenge of answering these kinds of questions is the reporting aspect. I mean, most of us, I don't think, in businesses in particular, they don't want anyone to know that there was a risk of losing your data. And so even though there are obligations to make disclosures, I think that we're not really seeing that so that we can really fully appreciate the full scope of the problem.
That's excellent, Bob. Thank you. Mark, or Sue, rather? Let's start with Sue. Sue, what are your thoughts?
Well, yeah, I just think there's just so much here. I mean, and so many things we really need to think about. And I guess one of the things, the best thing you can do is try to prepare. And I mean, I'm more of a practitioner, not a lawyer, and I don't pretend to be one either. So, so I think that, one of the things you really have to think about, and these companies have to think about, is just first of all, how do you prevent it as best as possible? And then, there's holes everywhere, as we see. But then, as you've been saying, it's not if, it's when. So how do you prepare for that? So one of the questions that we're asking internally right now is, do we pay it? When do we pay it? How much, what's the threshold before we would pay it, so that we know that before something might happen? Oh, I'm sorry, did I get ahead of you there?
All right, I thought it'd be good to put these questions up as well.
And then also, not just do we, but, as Bob alluded to, most of the time it's in Bitcoin. So do we go ahead and try to get some Bitcoin somewhere so that, because it's not really, I guess I actually never bought it myself, but, I guess it can take some time. And so do we want to go ahead and have something ready? I don't want to put us at risk just by, being prepared to pay it. But at the same time, it's like, I think those are decisions that we might not want to wait until something happens to figure that out. So I've asked our Chief Information Officer, Security Officer, to begin to think about this, and we'll talk with our executives about this in an upcoming meeting. And you mentioned the backups. I think, now that's a really common thing for the hackers to do, is to go and find your backups and corrupt them before they, actually let you know what's happening. So, it's just a really big war. And, I just think that the only way we're going to fight this is to really to do it together. And we're all fighting the same war. And the only way it's really we're going to make any kind of progress whatsoever is to band together and really, really try to fight back. Us doing it individually isn't working.
Correct.
So one thought I have too is, in some ways, the Colonial Pipeline incident was both illuminating in bringing public notoriety to this problem, but also obscuring in certain ways. Because what do I mean by obscuring? Because I think that it was the case of almost of the hackers were like the dog that caught the car there, and that it was there was even some indication that they realized they had taken basically they now had the notice of the CIA and other intelligence agencies, which is not really what a smart criminal wants to do. And I guess that's the point I'm trying to make, is that the smart criminals would probably rather get, $100,000 here and $100,000 there from law firms and hospitals, or millions of dollars, but not they're likely not aimed at infrastructure, because, as I said, now those guys have to watch their backs. They've become national security threats. Not to say that there aren't national security threats, because more than one foreign power has bots and other things. They're constantly probing our infrastructure, and they have bots aimed at the heart of it. And a lot of security experts think that the next war will have a huge cyber component, and could really, fundamentally threaten our ability to function as a society. But meanwhile, the ransomware problem is actually everybody's problem, as Sue said, because most of it isn't most of these guys aren't going for the spectacular, splashy win. They're going to be going after the smaller companies. And as Bob said, information sharing is the key. This is another evolving policy issue, and it's going to always be really hard to get companies on board, because companies don't want to share embarrassing information unless they have to for SEC disclosure purposes. But otherwise, they're not quick to share this. I've known this working on policy issues regarding information security for years. I can talk for an hour to a general counsel of a company or another executive about how we need to do something about this. Washington needs to do X, Y, and Z. And then if you ask them, are you ready to step up and testify or join a coalition, they immediately back off. They don't want to take the lead. They don't want to admit they have the problem. So this is a real fundamental problem. Information sharing is a real fundamental problem in this area.
I wanted to ask the panel, if I could, real quick, just an interject a thought here. So I recall recently that the current administration, when the Colonial Pipeline attack happened, said, look, that's a private company. This is a private matter. We're here to help in any way we can, which I'm certain they were much more engaged than that. But I wanted to ask this group, what role, what responsibility might the federal government have, or other, local or state governments have, in helping entities stay safe from ransomware and to combat ransomware? What are your thoughts relative to that?
Robert, I was just going to chime in after Mark's comment on that very issue, because this is very much like the American Revolution. We're talking about militias battling a global war, in cyber terrorism. When you're talking about ransomware, we've had 4 attacks: SolarWinds, Colonial Pipeline, JB Meats, and then to Mark's point, this latest attack several weeks ago, where a couple hundred companies were held hostage for $4,000 a piece. Who wouldn't pay $4,000 to protect the integrity of their data? But that's $70 million. But it's the companies like militias that are really, having to make the decision about what can we do to fight back. And I think that's part of the ineffectiveness of the administration, to really say, this is what the American government is doing to help, is part of the problem. They do have a task force that they've set up to deal with ransomware. President Biden is supposedly, as we speak, sometime today, has this major initiative with respect to ransomware. They announced several days ago that Revil, or however you pronounce it, that major, ransomware gang has disappeared over the last few weeks, and maybe because of the threats, by the American government. But from what I understand, and this is something that I discovered, in teaching my classes, anybody can get ransomware software off the dark web or other sources. You don't have to be this major super criminal to figure out, how do I program stuff to hold somebody's computer hostage. And in spite of the fact that, many states have ransomware statutes, they criminalize it. It's really up to the private, sector to figure out how they're going to stop it. And Mark's right. Each one is every person for himself, right? I don't want to reveal what's going on. Don't want to showcase our vulnerabilities for the plaintiff's lawyer who's going to be wise enough to bring an action. So that is the challenge. It's you can't fight a war when there isn't really any coordinated defense or attack, and maybe aggressive U.S. policy is what we need. I don't know.
It feels a little like we're all playing checkers and they're playing chess, right?
That's right. That's right.
Excellent. Any other thoughts on this notion of government interceding and assisting and being more prominent as it relates to ransomware? Sue or Mark? Okay. Another area that, and in fact, a question came in. And
Bob, there was a question in chat.
I was going to touch on that. One thing I wanted to mention relative to that, and then Sue, I'll turn it over to you, is we have been receiving supplementals, and we've seen supplementals being issued by insurance carriers for ransomware specifically. I think organizations across all verticals are seeing this now. I think insurers are really becoming smarter about how they're approaching ransomware. So I wanted to give the panel an opportunity to talk a little bit about your experience so far in that space. Where do you see this going as it relates to insurance? So Sue, please, any thoughts you might have?
Oh, I was just going to tell you there was a question there. Oh. but well, I think it's important to be very aware of this and review your insurance policies, and then probably be prepared to pay a whole lot more if you want to have this covered. I don't have a whole lot of more advice than that for you. I'm sorry.
Okay, thank you, Sue. Appreciate that. Any others?
This is Bob Frenier. Part of my career, a good chunk of it was as an insurance coverage lawyer. And again, this is to my colleagues who are lawyers out there and who are litigators out there. I think right now the trend is do not pay from the federal government and the Department of the Treasury, because it only creates additional opportunities. I haven't, although I recently attended a webinar on cyber insurance. I don't know where the insurance industry is going to end up, but I do believe that what we're going to see for lawyers are opportunities to litigate coverage issues like this, particularly ransomware response. Because I think that part of the challenge here is if you're hit as a business for a $4,000 bill, in order to free your ransomware, and your deductible is $10,000 or $20,000, ransomware coverage is not going to help you. And I think that, again, one of the areas of opportunity for lawyers who are, in this webinar, who want to look for kind of a future opportunity for business is going to be in this area. And my guess is, having represented a major insurance carrier in litigation across the country during the asbestos coverage litigation, insurance companies are not anxious to pay. And it's not just what the policy says, which are usually based on insurance services organization ISO forms that are developed for specific kinds of risks. You can have the same language in every single insurance policy, and insurance companies take a different interpretation, not necessarily deny coverage, but to get a consistent position on how that company is going to deal with this issue. And if you're having a flood of claims in a particular area, you'll hire lawyers to develop this the company position, because you cannot have claims adjusters defining how the company is going to interpret a particular policy. So I foresee, if there already aren't new ISO forms developed specifically to sell coverage for cybersecurity risk, particularly for ransomware, you're going to see them, number one. And then number two, there's going to be litigation over inconsistent positions that various carriers take as to what their obligations are with respect to each one of those policy provisions.
Excellent. Thank you, Bob.
So, and I guess I would just note and maybe underline what others are saying, but this is something that I think the longer you practice, the more you learn that there's what the law says, but often, you have to look at what the client's insurance policy says with regard to both, compliance and planning and litigation. And of course, putting aside separately, it's often tax considerations drive everything too. But it's fascinating that we can look at whatever state statutes have been passed or are passed about things like disclosure and liability, and what your obligations are under various regulatory standards. But it may in the end be the insurance industry that drives a lot of this. And then that's just true in so many areas of practice. I teach copyright law, and believe me, entertainment companies look at their insurance policies and deciding what material is safe to include, what they have to get a license for. They look to that long before they look to any case law. And that usually determines things. And it's like that in one area of law after another. So it's, I guess, something most of us know, but it's good to reiterate that the insurance industry may determine a lot of the policies here in the long run.
Mark, I think just to build on that, Robert and Sue, the challenge for the insurance industry is they're learning about the scope of the risk as the rest of the world is. So it's not like they've got 50 years of history on how to insure a fire loss with a home. This is brand new stuff. And you may, as a lawyer, look at a policy and say you're okay or you're not okay, but because these are evolving risks that insurance companies are having to assess, underwriters don't have that specialized knowledge about what these risks really entail, because they don't have the expertise of Robert, Sue, and Mark to really understand what these risks are to be able to assess them. That's the challenge.
That's a great point, Bob. Great point.
Yeah, I would echo that as well. I think another thing that I don't know that the industry is quite ready for is insurance companies are becoming not just smarter about how they're insuring and how they're assessing, but they're standing up cybersecurity practices within the insurance companies. I was a party to an organization at one point that received a notification from an insurance provider that they had stood up what's called a sinkhole. A sinkhole is a URL basically out on the internet that acts, looks, and feels pretty normal, but it's actually a place for that directs virus-related traffic to it. And so it acts almost like a hacker website. Think of it as a honeypot, if you will, out on the internet. And this organization was notified by that insurer that, hey, we're seeing traffic from your organization. When you hear that kind of thing, that's a very offensive, and I don't mean that in the bad way. I mean offensive as in offense versus defense. That's a very offensive approach to cybersecurity, a very forward-thinking approach to cybersecurity that I actually encourage. I think if insurance companies are able to do that and provide that intelligence back to their constituents and others, quite frankly, it becomes a service almost in and of itself. And I'll be curious to see if the insurance industry starts offering these types of services more to their customers and partnering with organizations that provide cybersecurity services. So I think are there any other thoughts on the insurance piece as it relates to ransomware? Because I'd like to spend just a few minutes, if I could, Joe. I think we have till 12:15, correct? Is that right? Yes. Okay. Yeah, I see you shaking your head, so that's good. I want to spend a few minutes on the payment aspect. I know that organizations oftentimes are left in the lurch relative to payment. Should we make payment? Shouldn't we make payment? What are the legal ramifications of that? I know we touched on some of this. Just if we could real quick, just kind of revisit that topic quickly. What kind of parting thoughts would you have if you could give your kind of 1 minute synopsis of how to handle payment? What would you suggest organizations, especially the lawyers that are on this call, think about as it relates to payment of ransomware?
This is Bob Fernier. Pay. If you can afford it, pay, because just hiring me to give you advice on what you should do is probably bigger than the bill that you'll pay the criminals. And I hate to say, that even though the FBI, the Treasury Department, and some in Congress are developing legislation to say, we're not going to, we're going to criminalize these payments. You really have to view this as a business decision. You have fiduciary obligations to shareholders. So companies have to make, and customers, obviously. I think they have to make a practical decision, much like I wish I would have, not been around this person who has coronavirus and who didn't get the vaccine, but it's my fault. I didn't do all the things I needed to do to take care of that. And so I'm going to go ahead and face the consequences. I say pay.
Thank you, Bob. Sue or Mark, any parting thoughts as it relates to payment? I love the advice, pay it, but what is your approach to this? What is your thinking?
I'm going to defer to Mark. I'm not a lawyer, so I would like to hear his answer, actually.
I think Bob gave the pragmatic practitioner advice that it ends up being a cost-benefit analysis, because it's you're dealing with you're dealing with it after the fact. Yeah, it would have been better if there wasn't that coronavirus infection. It would have been better if that accident didn't occur. It would have been better if you'd had properly classified your employees and paid them overtime when they were supposed to. But now that's happened. Now the question is how to get out from under it with the least pain. Of course, what we're creating here, taking the practitioner hat off and putting the law professor hat on, we're of course creating a collective action problem here, where everybody acting in their own interests creates a problem, because it becomes a very profitable criminal enterprise to do. And so at some point, the government has to address it. But I don't think that, for just my opinion, from the policy perspective, telling people not to act in their own self-interests or trying to prohibit it when they're in the midst of a crisis is not an effective policy. The governments deal with collective action problems, not by kind of wishing them away, but by attacking the source of them. And so I think that there's a government role in trying to fight back against the criminals, and with all the tools available to the government, regulatory, financial, criminal, intelligence agencies, et cetera.
I'm not sure I really understand the government's position either, because law enforcement will tell you if somebody has a gun and they're about to shoot you and they say, give me your wallet. I mean, I don't think any of us would say, don't give them your wallet, right? Just the risk is far too great. And when you're talking about ransomware, you just look at Colonial Pipeline. It paralyzed the East Coast, right? Gas lines in North Carolina took hours. And if you're talking about simply paying $4 million, that's a drop in the bucket to a company like Colonial Pipeline, and taking care of the issue. If the government afterwards wants to do what the DOJ did, find the culpable party, recover the ransomware, and then punish those responsible, maybe they've done that with Revel. That's something that the government can do. But as a practical matter, if I'm a lawyer for a general counsel for a major corporation, and it's not that much money, I think it would be irresponsible and prompt the kinds of class actions that Colonial Pipeline has gotten, because they did delay in making that decision. They ultimately paid. But if you know that there are consequences that are far reaching to what you do that extend beyond the company's bottom line, I don't see payment as a sin.
We have a comment, and I'd like to kind of pivot on that slightly if I could. The advice presumes honest criminals, that is, that they will actually decrypt your files after the Bitcoin arrives. I would say there's a few ways to help mitigate that. One is do work with law enforcement. And some people are a little apprehensive to do that, but I strongly encourage you to reach out to law enforcement before the cyber attack. So establish a relationship with your local FBI office. Talk to your, here in the state of Ohio, we have a wonderful group called the Ohio National Guard Cyber Force that we can reach out to, who can help us. Make contact with these people before the incident occurs so that you have that chain and that communication channel open. Second thing is they can actually provide you some intelligence on that hacking group. If you can identify which hacking group it is, they can help advise and give information relative to, well, what we've traditionally, it's almost like a credit rating. What we've traditionally seen is this type of behavior from that particular group. So I don't want to say that they can do that categorically, but if they're familiar with the group, they can certainly provide it. Third thing I would recommend is form a partnership with a third-party security firm that does this for a living. Put them on retainer, almost like a lawyer. Have them at the ready. They may recommend that you put Bitcoin on a parking lot, just in case this were to occur. I think I've done some reading that on average, it's about 1.7 Bitcoin per server. And then there's a process you can go through for actually getting the payment put in place and getting the decryption done. The question is a wonderful comment, because you really don't know if you're going to get good services coming out of that. And these hackers almost approach it as customer service. They have a customer service rating. It's almost like pay us and we'll be happy to help you kind of thing. What you can do though is ask them to decrypt one server. So to give you the key for just one server, decrypt that, scan it, and check for integrity, make sure it's there, and then ask them for half the other servers, right? The first half of the other servers, do that half, and then the last. And what that does is it keeps them engaged to you during the process, and it also helps your organization to make sure you're getting the data back that you need. If data's been exfiltrated, that's a whole nother conversation. But again, legal counsel can help you with that. Third-party security firms can help potentially search the darknet for you. And of course, the FBI is always at the ready to assist. So certainly reach out and make those connections. So I wanted to, again, look down in the Q&A section. Do you see it as a viable policy for the federal government to attempt to prohibit the use of cryptocurrency? And I guess I just wanted to give a quick minute comment for anyone who wants to address that particular question.
I'm on the blockchain panel too, so I'll take a stab at this because we talk about when Facebook was going to release Libra, now it's Deem or something like that. One of the concerns that Secretary Mnuchin had was the facilitation of criminal conduct. And I don't really think that you're going to see any regulation to stop the proliferation of cryptocurrencies. Cryptocurrencies are here to stay. You might see the criminalization of how cryptocurrencies are used. And much like you see cash reporting requirements, banks are required to report if $10,000 of cash or more deposited by an individual to raise concerns over criminal activity. I do believe you'll see regulations like that because that's a primary concern of regulators right now, is to limit the use of cryptocurrency in criminal activity. But I don't really foresee the government, blocking cryptocurrency for that reason primarily. It's just too widespread right now, its use and acceptance.
Okay, very good. With that, I think we have arrived at what I believe to be the end of our panel. Joe, is there anything, or are there any other burning questions that we need to address outside of that?
One thing I thought we would cover, but just for everybody out there, if you're interested in cybersecurity, the Supreme Court's decision in Van Buren versus United States has widespread implications. Have a look at that. It essentially is the first time the court has looked at the Computer Fraud and Abuse Act, our primarily anti-hacking statute, and the Supreme Court has really adopted what I thought was a surprisingly liberal approach to what prosecutors could and could not charge under the CFAA. Other than that, that's all I have.
Thank you.
Okay. Go ahead, Robert.
I just want to wrap up. On behalf of the panel, we want to thank all of you for your time today. We hope this was an interesting and engaging panel for you and good information. And with that, I'm going to turn it back to Joe for next steps. Thank you, everyone. Thank you, panelists, as well. Great job.
Thanks, Robert, and thanks, panelists. That was a very engaging, interesting, and more I learned. Anyway, right now we have everyone taking a break and then coming back at 12:30 for the midday keynote from Catherine Lowry, Director of Practice Services at Baker Hostetler. Again, thank you very much. Extraordinary panel. And see you at 12:30. Bye. Welcome back, everybody, to Ignite Legal Tech Innovation 2021. And we're very excited to have our keynote here with us today, Catherine Lowry, who is the Director of Practice Services and Head of Incubator. She serves as co-chair of the Emerging Tech Practice Group and strategic leader for Baker Hostetler's information technology, legal content, and research, data management, innovation, and training services. She co-created Incubator in 2015 and leads a dedicated consulting and R&D team that supports corporate legal departments and their digital transformation, privacy management, and data initiatives. Incubator Innovation Lab is known for leading developments in creating self-executing smart legal contracts, a cryptocurrency reward program, and human-machine trust studies. She was recently recognized as an honoree of the 2021 Fastcase 50, and in 2019 was named ILTA's Thought Leader of the Year. We're very lucky and fortunate that we have Catherine Lowry today to give the keynote for Ignite Legal Tech Innovation 2021. Thanks for being here, Catherine.
Thank you, Joe, so much for the warm welcome. I'm excited to be here today. You know, we talked about doing this a year ago and so much has changed, but yet so many things have stayed the same. So today I'm going to talk about innovation teams, legal tech, and what I call the purple cow. Although I didn't originate that, and if you haven't read the book, I would encourage you to do so. What I'm referring to is a book by Seth Godin titled The Purple Cow. And inside of this book, he talks about, you know, being able to see a pasture, brown cows and black cows, and how common that is. But if you were to see a purple cow, that would be truly remarkable. And he sets this tone of the purple cow in context to marketing, but I believe that it has a strong similarity to our struggles and our inspirations in building innovation teams and in legal tech. So I'm going to talk about the purple cow in the context of how can we make our business remarkable. You can replace that with department or services. How, if we find something in legal tech, how can we find something that's not just what everyone has or what's new on the market, but is it truly remarkable? And then really how to adopt something remarkable. So these three things I hope to share with you over the next half hour and hopefully inspire you along the way. So first, we'll start to tackle how to make your business remarkable. As Joe had said, I manage an innovation team that's now 6 years old. So it feels young, but it still feels that maybe this is twice in its age based on the amount of work that we've done. So I want to talk about our desire to build an innovation team that was truly remarkable and our journey in that process. This is a dashboard that's current day, it's version 11.7. Our incubator team works very hard to identify legal tech, to categorize it, interview them, do demonstrations, possibly put them through proof of concepts. Our ability to be remarkable, at least for us when we started 6 years ago, was to leverage what we knew, and that was research. Research, study it, have turmoil with it, and come out on the other side with a great deal of experience. We started with less than 100 in our first dashboard. We have 500 solutions and eventually figured out we couldn't fit them all on one page. So what represents here is probably 25% of what's in our larger database. This is an everyday activity to stay aware of the ever-changing market, those that have unfortunately in the pandemic that have downturned and have gone away, those that have come through stronger, those that have latched onto partnerships and are leveraging. It's our ability to be remarkable is really our ability to help connect the dots and to make sense of all of the changing landscape that we see with legal tech. Now, what I would say is that that's not enough. We want to also look at how can we help monitor the law. So we have a lot of great vendors that help support us in this effort, but Incubator took it upon ourselves in areas that simply we didn't have at the time. And in 2016, when we were taking on blockchain initiatives and really trying to understand what was happening, not only in the marketplace, but also whether laws were being introduced, whether they were being passed, whether they were dying on the floor, what was happening and what were they about. We took it upon our efforts to start to monitor the law, to use this as a form of analytics so that we could create the word cloud like you see on the left, and to be able to drill deeply into our own taxonomy for how we wanted to create topic tags so that we could understand the forest from the trees, if you will. Patrick Flanagan on our Incubator team is the rightful owner of this and has monitored this for years for us and keeps it present day. Just quick note, you'll see in 2020, there's a pretty significant dip over here to the right and the number of bills even being introduced. We're starting to see that increase. This is what helps us be remarkable because we're able to start to understand not only what technology is about, how it's going to impact our clients' lives, how it might impact Baker Hostetler, the firm I work for. Again, really, I think the sentiment I want to share here is that it took the ability for us to say, we don't have to be perfect. We just have to try. And we have to start somewhere. So let's start with what we know best and let's leverage from there. I will say 6 years, maybe even less than that, 4 years later, we started to create a consulting arm. We came up with this mantra. We wanted to help lawyers navigate the intersection of three things: digital business, emerging tech, and the law. Often when I talk to clients, I would say, if you're looking for any one of these in particular and not the other, you probably don't need Incubator. For the law, we have a great legal services team. That's our lawyers. But if you are looking for someone to help you with a legal operations transformation, to help digitize your contractual pipeline, to be able to help create workflow automation so that your assistants are not having to spend all of their day in matter management, those are areas where we start to come alive. And this is what Incubator serves today. So I think all of the pre-work that we did and understanding the technology, understanding the impact of the law, understanding digital business helps put Incubator in a situation that allowed us to be what we think is remarkable in the group. And I think, and in the market, I think the same could be for you, whether it's something as, as big as a consulting arm or something as specific as a service. Think about those things, leverage what you have and use those to help make yourself remarkable. Today, the success is that we are managing more clients. Incubator's bringing in client matters on our own. We're being asked back by clients to do even more work. And when you look at the backdrop of this prediction from Gartner that legal technology budgets will increase threefold, there really is identification of a need here. And had we not done a lot of the pre-work to get us ready for that, we might not be as successful and as much of an advisor to our clients. What I can tell you working with corporate legal departments is that their budgets are increasing. Technology is getting much more saturated in different parts of the market, and it becomes confusing, number one, on how to even take one step forward. Number two, a lot of the corporate legal departments are being asked to stay flat. So they may be asking for more money. They have the need for more change to modernize and digitize, but the complexity around who's going to do it is often an issue. I feel fortunate to be in the position today to support the innovation team and our clients in this way. As we go through, kind of share some more insights into that, but hopefully that's helpful on how to be remarkable in creating your business. I want to turn quickly to how to find something remarkable and under the context of legal tech. I've already shown you our dashboard. A dashboard's fairly significant in how many solutions that are out on the market, and it's just indicative of how crazy confusing it can be. But there's some real work that has to be done to really find the golden nuggets, as I like to call them, that really can help you achieve goals. Like often what I'm asked to help with is create levels of efficiency or process automation in optimizing process, or be able to look at a way of how we can deliver new services, or be able to elevate staff so that they can do more meaningful things. The real key here is understanding the business, but then using that to help find the solutions that will make your efforts remarkable and be able to achieve the goals that you set out. So let's talk about this a bit. I wanted to share with you some of our innovation goals and practical experience in this space. To find solutions that have a lot of bells and whistles is easy to do. We know that. But to really find whether or not they're remarkable and can meet your goals, difficult. So what we did was create a four-pronged approach in which we would look at assessing impact, pipeline, pace, and culture. And our goals centered around creating alignment with the business, creating a diversity of different innovation projects so that we did not have all of our eggs in one basket, and that we would set a pace of trying to achieve these quick wins in order to show operationally our business that success could be had with legal tech, and be able to build credibility for larger investments that we wanted to spend more time where it was much more complex. We also wanted to think about our culture, who we were going to engage with across the organization. Similar to the type of projects, the culture and who we're going to spend time with had to be diverse by different practice areas, by different levels of complexity, and so on. Because one of the underlying goals of our success and how we think you can build legal tech is making sure that people even understand what it is. Conceptually, that's sometimes one of the hardest things, and will be probably the last thing I talk about in this session. So as we move forward and we're trying to figure out what solution in legal tech can be remarkable, this is how we started to align with the business, our imperatives. And this is actually quite dated for us, but I think it was a fun reflection for me, and so I thought I would share it. Some of the activities that we did were trying to figure out in our transformative play, we wanted to work with blockchain. So what were we going to do with blockchain? Well, we wanted to align with how we could help increase activity by the associates, specifically in pro bono work. So we aligned our initiative, our tech initiative, with that and created a cryptocurrency reward program and a prototype for how we would do that. It helped us twofold, helped us understand how cryptocurrency works, how we can build applications around it, and it helps attach to a very meaningful business imperative for the firm. Other things like understanding of a very already saturated market in legal tech is contract analytics, understanding why and when we would use one of these solutions and when we wouldn't. This helped us be remarkable because we could understand which of these solutions was going to fit our needs. And potentially for a client, we know that our needs and requirements may not be the same. But because we know the level of accuracy of their algorithms against certain clauses, and because we know of different capabilities like reporting, which isn't part of emerging tech necessarily, it's a tried and true, it's a necessary, but those elements combined together make it really powerful when you're trying to find a solution that's truly remarkable and that can help your organization advance. So again, not putting all of our eggs in one basket, looking at the business imperatives, letting that dictate how we experimented with different solutions. And that helped us create real constructs for determining which solutions were remarkable. And even if they weren't, there was a level of education that helped us understand what they could and couldn't do. The pipeline of innovation. This is very true, but dated. This is a few years ago, our pipeline incubator carrying 41 projects. There you can see in the pipeline, you're not doing all of them at the same time. And if you're trying to find a legal tech solution that's remarkable, you're probably going to have to put in a good deal of effort in what we call proof of concepts. Obviously not our term, but important for us that we are testing and we're determining levels of accuracy. We're testing capabilities, in essence, lifting the hood on these. And probably even most important is working with our attorneys in real life simulations so that we can not just demo, but we can really attest to this works or doesn't work. And I think as we get into the next section, I'll tell you how that also corresponds with how we adopt something that's remarkable. So in the end, these, you might ask what the color codes are of each one of these. And each color holds a different meaning behind it. Our attempt was to diversify across different levels of legal tech. So a red might be data analytics, whereas the dark gray might be blockchain initiatives, and the others may be, like the blue, would be process improvement. So really trying to diversify our experience around data analytics, machine learning, all things that we knew we saw in the market that we'd identified that we wanted to see. And I think part of this picture hopefully helps emulate the message that, you know, we have many, many more ideas than we can take on at any one time. And so we looked at how we could spend a great deal of time in proof of concepts, which means that we're working closely in simulations and gonna have to take on less projects. But we're also keeping track of those that have gone all the way through the pipeline and completed and tried to measure the value of success and whether or not we were going to truly adopt those inside of our organization, and anticipating for what eventually became consulting services. Culture goals. I would say that this is probably one of the most important pieces, and it'll help me kind of segue into my next section. But before I do, I will say that creating a framework to be able to determine what the technology can do and can't do was seminal to our success. And I think it helped us identify solutions that were remarkable. Specifically, what I'll refer to is our black box studies. So we knew that there were a lot of solutions that had machine learning capabilities, and we really wanted to be able to lift the hood and understand, you know, how does that work? What data are you using to train the algorithm with? And in the end, is it reaching the higher percentages of accuracy that we need in order to implement this into a process? It also helped us with engaging our attorneys through these studies, deep dive studies, simulations. We'd create different workflows that they'd have to go through. We unified them so that every attorney went through the same one, so they gave us a great baseline. We used empirical studies, both in quantitative and qualitative metrics, to be able to have you know, more of an accurate reflection on what we saw during this time. These studies lasted anywhere from 60 days to even over a year in different areas. A great deal of time and effort, I think, from the whole team to be able to think about how we could approach this and minimize bias, but also draw, you know, observations that helped us with understanding even people reaction. Some solutions that we faced, we would often see that there would be this negative impact of thinking, is this going to replace me? And I think these active, interactive sessions help demystify what technology and legal tech solutions we're offering, and that in fact, it's not going to replace you. It's going to help augment. It's going to help you get to analysis faster. Certain levels of risk that we have to look at also were identified. And so means for how we would mitigate risk in utilizing technology was also a very core part of our culture goals. All of these, in essence, I would say, are really important for, at least from my experience, for how you determine and find solutions that will truly be remarkable and help leverage, whether it's efficiency gains, identification of risk, or other objectives that you're setting forth. The last piece of the presentation is really to focus on how to adopt something remarkable. As I've said before, it is it is a difficult piece to deal with adoption. You can find solutions on the market that have all the bells and whistles, and it would be easy to do a demo and be enamored with it. I think part of our group and why we think, making Incubator remarkable was really focused on how do we take away the smoke and mirrors? And we are ensuring that it's not only something remarkable, but that our people will adopt it. Because if you don't have this last piece of adoption, it really will lead to a pretty sour result. You may overly invest in a solution that isn't delivering on promises. Credibility could be knocked, and lack of future funding could be an issue. While I want to embrace failure, I want to make sure that the team and our team in supporting of our clients make educated guesses on exactly how we can transform using legal tech and making sure that there's identifiable needs in order to adopt these solutions. So I want to talk about that a little bit more. There may be, and I put up a couple examples here, you may get through your process and identify this is a legal tech solution that I think is remarkable, and I want to implement it at our organization. I put up 3 here that are more focused in automation, but that may have some level of machine learning, so therefore kind of move into a little bit of an intelligence base, like a chatbot, rapid process automation, and then maybe even just straight workflow automation. And in these examples, I've tried to put more concrete examples, which is how we often communicate to our attorneys. A very high level, robust, introduction of these is often less articulate and less helpful for them to even envision what can this do for me, which is often the question that we get in the process of adoption. So in one means, if I took something like rapid process automation and I wanted to really streamline a 72-step process, there's really great impact that could happen to an organization. Think less losing a person, a head count to do this role, and be able to maximize that person to do something else more meaningful. Often, and remember, our corporate clients are facing flat headcount, meaning they can't go hire new people, but they have new demands and pressure that are building. So this equation often helps draw out, okay, let's take an example and let's try to implement that. But the people side of it is often very, very difficult. If it's not an assistant that's supporting an attorney, it's an attorney that says, hey, listen, all I really want to do is practice. And that introduces a lot of area and room for tech fatigue. If I introduce too many of these solutions at once, and I'm not satisfying them, or they're achieving that level of adoption and seeing the success off of it, that's where we sometimes run into this larger tech fatigue. And so just trying to set ourselves up here for kind of walking through acquiring a solution, and then how we're going to move to adoption. I will tell you that you could select any one of these on the screen right now, but I will tell you that the constant that everyone will face in this room is change. And change is what I would consider a simple word with a difficult meaning. And so no matter how great the success might look, some are just not willing to do it. And largely, I have been able to, and I had a lot of time, I had a quick vacation just a week ago, and I've been thinking about this a lot. So there's some epiphanies that I'm going to share with you today in regards to adoption and to change. Some people will say, I welcome it, with the caveat, as long as nothing is altered or is different, which for us in a legal tech role that's trying to help implement, it's all about change. And to find success, you have to change. So our approach has to be a little bit different. And so I want to talk a little bit about a change model that I came across just recently, by the way. I will have to say that this light bulb kind of went off in my head, because I could almost draw the same curve for you. Might have drawn it just a tad bit different, and will tell you as we kind of walk through it exactly where people struggle and when they give up. So I present this to you today. It's the Satir change model, and was able to find kind of another rendition of it that I think makes sense in the legal tech space. I added the time spectrum and the productivity spectrum of the different axes so that you could see that, you know, any change is going to take time. What you want to do to be successful and to get that adoption and remarkable adoption is that you want to increase productivity, right? That's not always the goal. We may want to identify risk, but essentially, I will say 9 times out of 10, clients are coming to us to increase productivity and trying to figure out which technology can actually do that, number one, and, you know, can they effectuate that process change inside of their organization. So let's walk through this just a little bit. You know, status quo, keeping things normal, we start to introduce change. There is what is emulated in this model is a fury of chaos. Almost a downward spiral is what it looked like to me when I first saw it. And in almost every example, working with clients, working inside of our firm, I will say this happens. There is this transition moment where people feel out of place. The norms aren't the norms anymore. There's, you know, an aha moment for them that, hey, I could have been probably a little even more productive had I just stayed the way that I was, which is often a big battle in this chaos phase. At some point, and I'll come back to chaos in just a second, at some point you will hit a level of transformation where we're going to take a little bit of a small dip, but we're going to come back out on the other side with iterative practice and integration into a process. Eventually, if a project is successful and you've been able to have a remarkable adoption, you will find a new status quo that is a higher level of productivity. And that is ultimately what the goal is. Oftentimes for us, the goal is in many of our legal tech projects. Couple of thoughts. We have to know when to cut bait. We need to know when to set limits. Just as if you were investing in the stock market, right? I'm not going to just let all my money dissipate and find no return. This is a little bit of an art. It is this area right here. I could probably put a graphic that is just churning and churning and churning because you will be in this cycle for quite a bit. But I think a couple of things. Chaos can sometimes help us see levels of innovation. People will adapt. Always. So I think there's a bit of psychology to legal tech and how we get it, to find remarkable adoption. People will adapt. Levels of adaptation here could be indicative of how a new status quo and higher productivity could be delivered. The second thing, and one that I'll leave you with and hope you'll ponder as much as I have, is that helping attorneys, helping assistants, paralegals, anyone in your organization that you're trying to help embrace legal tech, helping them understand that this is a true pattern and that this is going to happen and you're going to feel this. But in the end, we're going to make sure we set limits so that we don't go down with the sinking ship or lose all of our money. And that we have a plan for how we're going to get to the productivity is important because it sets expectations. And when we know and can expect a level of chaos, and hopefully it's organized chaos, and the art of how you support these projects, I think is actually in this curve right here. That's going to allow for everybody to get a little bit more comfortable with the process and open up a bit. And those expectations, I think, are really important. If I say we're going to do this project and you think we're going to go from this productivity to this productivity almost as a straight line, I've misled you. Because that is not how legal tech integration works. And it takes a bit of this time and a bit of the turmoil to go through to really make remarkable process change. So I hope that that has inspired you a bit to understand, if you haven't gone through this, or if you have, and that is an aha moment for you, I'm really excited about that because, this is what we need the most of right now in legal tech. Implementation projects is to help set this expectation, but to know that we can get somewhere on the other side. So if this helps you at all, help you to, with your organization, embrace change, I would be really grateful for that. Joe, very excited about the opportunity to speak to you today. A lot of great panels that are getting ready to happen this afternoon, both on blockchain and AI, and looking forward to those. So thank you again for the opportunity.
Thanks, Catherine. That was fantastic. And I love the Satir change model. Actually, it was introduced to me when I was getting my MBA in organizational behavior. And it's helped me so much stay calm and confident. I have an organizational management that was built largely a lot of intuitive aspects of it, but also what I learned to get my MBA. And this model was always in the back of my head. There's going to be chaos. And there was when I got to Case Western, there was chaos. People go, what the hell is he asking us to do? You know? And time was involved. It took probably a little bit more than a year. But then there was a lot of resistance at first. But then everybody pretty much got on board. And it was this concept in the back of my mind. I thought, they're going to come. They're going to come. And they have. So thank you so much. I had a couple other questions, but in the interest of time, we've come up against it. So thank you so much, Catherine. I know you're going to be moderating one of the panels later this afternoon, and we certainly do appreciate you giving us a fantastic keynote, and we'll see you in a little bit.
All right. Thanks, everyone. Yeah,
you bet. Okay, folks, we have your lunch hour now until 1 o'clock. So we'll see you back at 1 o'clock. Hello, welcome back to Ignite Legal Tech Innovation 2021. I apologize, folks. I probably lost some people for about another 15 minutes. I got the time wrong, and I said there was a half an hour where there's only 15 minutes. So I hope people out there have a better grasp of the schedule than I do. But anyway, Catherine Lowry, great keynote. Thank you, Catherine, and she will appear again later on this afternoon at a panel on the future of artificial intelligence. Just a reminder for the CLE credit today, you will be given that code at the end of the program. Eric Siller, our CLE guy, will be telling you that at that time. And if you have any questions on any of this thing, I will try to answer those. You can also write down my email, jac311@case.edu, or Joseph, this is easier, joseph.custer@case.edu. Okay, here we go. We have another exciting panel, and this one is coming up next. It's on blockchain technology changing the legal industry. And blockchain is so fascinating to me, and I know to many of you out there. Our moderator for this exciting panel is Brian E. Ray, Alan Miles Rubin, and Judge Betty Willis Rubin, Professor of Law and Director, Center for Cybersecurity and Privacy Protection from Cleveland Marshall School of Law. And at this point, I'm just going to hand it over to you, Brian.
Thanks, Joe. Really excited to be part of this wonderful event, and really have an all-star lineup to tell you about the always fascinating and ever-changing concept of blockchain, and with a focus on the legal industry today. So we're going to jump right in, and with apologies for not giving them their due, I've actually asked each of the panelists for our session to do a brief self-introduction focused on how they fit into this particular space. And I'll ask, or I'll invite rather, the attendees to go to the website to take a look at their full bios and really get their full backgrounds. But we really do have a pretty stellar panel, which shows one of the things that I was surprised to learn as I got into this area is the depth that we really have here in Cleveland. And that was kind of jump-started a bit, but also represented by the Blockland conference that's taken place the last several years, not during the pandemic, but we'll see if that continues. But even if it doesn't, we're really lucky to have some pretty deep expertise on the legal side. And so with that, we've got a Bob and a Rob on the panel. I'm going to start with Bob Fernier and ask him to give his self-introduction.
I've introduced myself to the conference several times, or a couple of times so far, because
but just in case.
Just in case, I teach at Chase College of Law. I'm the director of the Lunsford Academy for Law, Business, and Technology. My expertise, to the extent that you can say I have any, comes from my development of a series of courses for online law and tech, a degree with our Master's of Legal Studies program, and those courses are available to the lawyers as well. I've been practicing for almost 40 years, got into the academic world on the tail end of my career, as so many of us who spend years and years practicing say what I really want to do and do next. And I've been at Chase since 2017, and I also am adjunct faculty, again, teaching law and tech at HBCU, Historically Black College and University, Law School, Southern University Law Center at Baton Rouge. My primary expertise, to the extent, again, you can say I have it, on blockchain and cryptocurrency comes from my teaching a course called Digital Commerce and the Law. And most of us, you'll find, are self-taught, either self-taught or we learn what we know experientially, because these subjects are not taught in law school. They're only now beginning to be discussed. And as I'll explain in my short presentation at the very beginning, blockchain is somewhat mysterious to us right now, but we all believe on this panel that it's going to be a major force in technology in the next 10 years. And as mysterious as it may seem during our presentations and after we're done, you still may be scratching your head. My prediction is 10 years from now, you will be a believer in its importance. Thank you.
Thanks so much. And yeah, it definitely is challenging to figure out how to fit this into the legal curriculum along with all the other maybe more accessible technologies. I like to say I haven't been scratching my head over this technology, I've been banging my head against it for the last several years. Anyways, moving on, someone who's got equal and perhaps even a longer tail in this new industry, because anything that's certainly more recent than 2014 is a long tail. David Croft.
Thanks, Brian. Can you hear me okay, by the way? Just making sure. Okay.
Sound good.
So I'm a partner at Myers Roman. I'd say that the best way to describe me is I'm a tech attorney. So I work with hardware and software, intellectual property, data privacy, cybersecurity, and all things related to tech. So if someone's got a tech issue at my firm, they're going to come to me with it, usually. So I started with crypto in 2011, but I actually started even earlier with digital currency in 2005, working with video game currency brokers. But I did start working in crypto, which was an easy jump in 2011 with miners. And then over the years that's
miners, M-I-N-E-R-S, not O-R-S.
I used to laugh about that a lot in 2011, 2012, but I think once you talk to people enough in this industry, it just kind of goes over their head. So, so over the years that expanded into software and hardware manufacturing and distribution. So obviously you've got the computer miners that we work with, ICOs or initial coin offerings, exchanges, centralized and decentralized exchanges, IRS audits with some of my tax partners with the great Coinbase subpoena, companies using smart contracts in their day-to-day operations, and crypto hacks, theft, disputes with various companies, and most recently, and very interestingly, the rise of the NFTs. So that's kind of my practice. Today, I still do a lot of work with miners. I started off with proof of work mining, and in the past few years, mining's changed quite a bit, and I do a lot of work now with proof of stake. And we can talk about that later on if we have time.
Yeah, never fear. Although it sounds like you are now in a video game, we will unpack many of those terms of art as we go along. I've never been involved in mining, although I'm waiting for my helium mining device to arrive, because that's an area that's really interesting to me. Anyways, last but yeah, we'll see. So last but not least, we've got Rob Musiala. Rob.
Hi, Brian. Hi, everybody. I'm Robert Musiala, go by Robert or Rob. I am co-leader of the blockchain legal practice at Baker Hostetler, a national law firm with several offices in Ohio. I have been working in the blockchain industry since 2012, so 9 years now, believe it or not. It's time has really flown. And I got involved in this industry originally in my role as a financial crimes investigator. And back in 2012, I was working with PwC and had an investigation that led to Bitcoin. And I was asked to figure that part of the investigation out. And I immediately became fascinated with the technology and kind of picked my head up and said, guys, this is more than just a tool for criminals. There's a whole new technology here. And from there, I went on to help found PwC's blockchain practice and did a lot of work there on what I call the dark side, which is investigations and anti-money laundering, Bank Secrecy Act compliance, things like that. And got to did some work for a 3-letter agency in that regard. And also did some work on the bright side, which is solution building and some of the new things that this new technology can do for us. And along the way, I've become the inventor on 2 pending blockchain patent applications. One of those actually just got granted and is still owned by my former employer, PwC. The other one I own in my own right. And I joined Baker Hostetler in early 2018 to help build Baker's blockchain legal practice. And in that regard, I've done a variety of work all over this industry, really. Done a lot of work on investigations, Bank Secrecy Act compliance, GDPR compliance for blockchain companies, SEC and CFTC compliance. I've helped to launch 2 Ethereum-based networks, doing a whole bunch of different legal compliance work related to those. Currently working on a 3rd blockchain network launch right now. I've done some work on, I helped to do the very first BD alternative trading system application for a company that is now trading private securities using a Hyperledger-based blockchain solution. So one of the first private permission blockchains used in the securities market. And I'm currently working as the coin-appointed receiver in the matter of SEC versus Chin, which is a large fraud scheme involving cryptocurrencies. And my role there is to try to figure out what happened, investigate, try to find some of that value and get it back and give it back to the defrauded investors. And a lot of that money is in cryptocurrencies, so it's a very unique situation. So currently working also on a client in the DeFi space, as well as some 2 different NFT initiatives. So it's this industry has been just a fascinating market to work in. It changes very fast, and it never disappoints. There's always new and interesting things happening. So really happy to be here to talk about some of those.
Yeah, and again, we added some more terms that we will try to unpack. And I forgot to say at this top, please feel free to drop into the Q&A any questions you have, and I'll fold them in as we go. As we can. We got a fair bit to cover, but we've left plenty of room to respond to your questions. And really, we want to tailor the conversation to what's interesting to the folks who are out there. So we're perfectly happy. We're going to pitch things at a relatively high level after we do this intro. So again, I really encourage you, ask the questions and we'll make the conversation fit what everyone's interested to hear. And yeah, Baker Hostetler's been involved in this from the start, and your CIO, Bob Craig's been a good friend to me in learning it, although we haven't interacted in a while. But one of my favorite memories is Baker co-sponsored the very first ever Cleveland Global Legal Hackathon, and a team of my students and a student from Akron who had the great idea, and a technical blockchain expert from Baker, went on to make it to the global finals with a really interesting application on how to standardize shipping terms, which is an area of law that I had no familiarity with. Anyways, it really is a lot of expertise here in the area, and it really is a lot of fun to try to figure it out, even if you don't become an expert. So with that, I promised we would kind of give a background, and we're going to start with the basics. With apologies for those of you who are blockchain experts, this is an area where it's always useful to go over the nuts and bolts before we move on. And I'm going to go back to Bob. And Bob, as an academic who attempts to translate this stuff for the very new, we're going to ask you to just give us that thumbnail sketch and explain what we really mean when we talk about blockchain.
Yeah, and I'm going to share my screen in a minute, but let me echo something that Brian just said. It's David and Rob. These are the fellows that are going to confuse the heck out of you, right? They're going to be throwing these terms out, and you're going to be walking away saying there is no hope for me. So as I introduce this subject, the first thing that I want you to encourage you all to do, who are listening, who may have just a little less ignorance of the space than I do, because I'm primarily a teacher, understand the focus should be on the functionality of the technology and its potential, not upon the nuts and the bolts. And we have two people who not only know the nuts and bolts, they're creating the nuts and bolts, right? So when we talk about form over function, I want you to think about your smartphone. How many of us really understand how that thing works? And yet we're amazed at all the things it does. And as lawyers and as a litigator for nearly 4 decades, being asked to do litigation in products liability. I started out in the Rely Tampon toxic shock syndrome mass tort litigation for Procter & Gamble over in 1983. And I would graduate to different other technologies or medical issues that I'd have to learn. I understood that I was not going to be able to really get a intimate understanding to the degree that Rob and David have. So as lawyers, the focus should be not so much on its on the technology, but its potential. And before I just give a little 10-minute presentation about what blockchain is, I really believe, and I got interested in blockchain because I really believe it's the next big thing. And if some of you saw my presentation on teaching blockchain in law school yesterday, I started out by playing a video, which I won't waste my time about, but I want to take you all back to when the internet first came on the scene, maybe even right around the AOL, giving away the $9.99. They give you the free discs with the trial, and then it'd be $9.99 a month. Most of us didn't appreciate the potential. Now it's helped us survive a pandemic, and I think in many ways, and I don't know, I'll be curious after I finish to see what Rob and David say, that there are many folks who believe that blockchain has that potential, in the legal profession and society generally, and we'll be talking about some of the use cases. And when you hear us talk about making 2 billion people bankable and giving through blockchain and cryptocurrency and giving them access to much needed financial tools in order to pull themselves and their fellow countrymen out of poverty, it's hard to believe when I start talking that this new technology is going to do it, because you're going to be dramatically, grossly underwhelmed by my presentation for 2 reasons. 1, because I'm the one giving it and I'm stumbling along, but 2, because even after we tell you what it is, you're still going to scratch your head and say, so what? Okay, so with that, and that's an easy way to say, when you see my movie, you're probably not going to like it. It's probably going to be overwhelming, and so be kind. But I really do believe that this is a technology that's worth going to conference and conference after like this one and to try to understand. So I'm going to share my screen and just go through a few of these PowerPoints if I can. and I'm going to start. I always have trouble because all these things are blocking it to even get the slideshow started. So what is blockchain? And this is part of that mystery that I was telling you. This is a common definition. It's one that I get from a great website that I'm going to endorse called Block Geeks. But a blockchain is an immutable distributed digital ledger. Now, that should, if you're like I was, it should mean nothing to you. You know, those words, they're packed with a lot of information. But essentially what you'll hear people describe blockchain as in the simplest form is a spreadsheet. You know, that, and it's a spreadsheet that can't be changed. And it's a spreadsheet that is maintained by multiple independent people. In this case, you've heard David Croft call himself a miner, M-I-N-E-R. And in the case of these blockchain ledgers, these are folks who don't necessarily know one another, who act independently, but who maintain the system. And we talked about two essential features of blockchain technology, and you'll see on the right, it's called distributed ledger technology. Blockchain has become like the Xerox word for distributed ledger technology, much like Bitcoin has become the Xerox word for cryptocurrency. When most people think of cryptocurrency, Bitcoin comes to mind because in 2009, its creator Satoshi Nakamoto coined the phrase and really created the most famous cryptocurrency. And we don't know if he was a person or if it was a group of people, if it was really a pseudonym. But when you hear folks talk about this distributed ledger technology and the various forms, they're talking about blockchain. The other popular distributed ledger technology, and we're going to be talking about this later today with respect to smart contracts, is Ethereum, which is essentially blockchain technology with the ability to also use applications like smart contracts. But the two key distinguishing factors of blockchain technology is immutability. These transactions, once they're recorded, cannot be changed. So I've never checked on this because I'm not into Bitcoin, but from what I understand, if you can get access to the Bitcoin chain, you can go all the way back to the very first transaction and to the very last transaction in order to see the exchange. The other aspect of this, and it's kind of the lifeblood of blockchain, is that it's distributed. These digital records, this data is stored on multiple places. This slide says it's on a computer network. Typically, it's not on what we would call the same server, computers within the classic computer network. It can be on multiple servers anywhere in the world. And it's being maintained, particularly if it's a public blockchain, by independent miners rather than company employees. You do have private permissioned blockchain networks, but the benefit of the distributed technology is it's while it's not unhackable, it makes it much more difficult to hack a transaction on a blockchain because the data is being stored on many different computers. When I say many, 15 or more than one. Here's the typical, and David, I'm sure he'll chime in at some point about whether this process is as simple as this. But when you enter this transaction, you're going to the transaction is going to be validated on these peer-to-peer computers across the world by miners. And the way that the validity of the transaction is confirmed is through equations that require a great deal of energy, or at least they used to. And I don't know if they still do, but that's one of the problems. The downside of blockchain transaction is its slow speed and the energy that it takes to maintain the computer power necessary to run these transactions. And once it's confirmed, these transactions are clustered into blocks. And then these blocks are attached to the chain, creating that long history of transactions. And then the transaction is complete. So essentially what you're doing is, again, creating this ledger that cannot be changed. It cannot be modified. Once you create a block, once it becomes part of a chain, you cannot go back with your digital eraser and say, I'm going to change this transaction because I made a mistake. Once it's there forever. There are additional security involved with blockchain. Primarily, you need a key in order to get into the system and to access your Bitcoin. And even though your Bitcoin is not actually, you can't really store it on your computer. You hear these nightmare stories of somebody who stored their keys on their computer and their computer died and that their Bitcoin was forever lost. There is no third party that you can go to say, hey, I lost my password. Can we reset it so I can get my Bitcoin back? You know, that's one of the downsides.
Hey, Bob, the only thing that I would add to what you're saying here is just
Please
to provide
do.
a little bit of context in the miner world. For those of you that aren't familiar, the computers that are validating these transactions, just to give you a picture, a suburb, at least a suburb around here, typically will run on about 1 megawatt of power. There are massive mines out there in the US and other places like China that are tens to hundreds to thousands of megawatts of power. And so there are millions and millions and millions of miners. And think of this in the context of each specific token or cryptocurrency that's being mined. They're all out there fighting for these blocks, because when you create a block, you get the reward is the token or the coin that you're mining. So just to give everyone a little bit of a picture of what this kind of looks like out there from a mining perspective.
And David was actually, he built a mining business and sold it. Isn't that right, David?
Correct, yeah.
And what was your energy cost equipment and energy costs associated with the business?
So we had 14,000 miners, which is, a flick. It's a speck. It's a nothing compared to most of these mining groups. And our electric bill was somewhere around, I'd say about $50,000 to $60,000 a month.
Oh my!
So you can imagine some of these mines that have millions and millions of miners, what they're paying. But mainly you're seeing a lot of these miners being set up at power plants by the owners of the power plant, or hopefully they're being set up close to renewable energy sources like water or wind or solar.
And I just want to actually add one thing that you mentioned, David, and then I think we want to move pretty quickly into some of these more applications. But
sure. You
mentioned proof of stake versus proof of work. Proof of stake is an attempt to move away from this resource-intensive method of validation. Could you, David, just give us a quick summary of that? I know it's not an easy concept to describe.
So proof of work is the more computers you have plugged in that have higher computer power, that are using as much energy as possible, the more power you have to solve for blocks. That's proof of work, and that's the most simple way I could explain it. Proof of stake is the more coins that are owned by a miner, the more mining power they have. So basically the way this works is you stake or you pledge your coins to get more power to mine. And as you mentioned, Brian, it's better energy efficiency, lower barriers to entry, reduced hardware requirements. You said you were buying a helium miner. I can tell you that that's probably a fraction of the cost of a Bitcoin miner, and you can get a bunch of them. And stronger support for shared chains. There's other things that are beneficial in proof of stake. I'm not making a commercial for either or the other, but that's the main difference there.
And if I could just add a tiny bit on that, from my limited understanding, the big difference is the model, the basic Bitcoin model, which most cryptocurrencies followed of proof of work. The idea is you've got to expend some resources, energy primarily, to solve a problem. And that ensures that you're, or at least attempts to ensure that you've got skin in the game and that you're going to do this legitimately. And the reward for it is getting the cryptocurrency. Proof of stake, the reward is kind of inherent, or the skin in the game is inherent in the fact that you already have some of these currencies and you're going to stake them in order to get more of them to do the work of recording the transactions. And the basic problem is we need somebody to record the transactions to have the distribution, and we want to incentivize that so that it doesn't have to be command and control centrally. And the original genius of Bitcoin didn't fully contemplate or anticipate how it would scale and how resource intensive it would become.
That's right.
And Robert, were you going to jump on?
Yeah, I'll just add to that. You know, this whole issue of energy consumption has been, you know, in the media a lot lately, and I think it's still anybody's guess as to whether proof of work or versus proof of stake or some hybrid or both will win out. But you know, one of the interesting things to me about the Bitcoin network in particular is that the protocol is designed such that the more people who are trying to mine, the more people who are trying to win that reward that gets paid out every 10 minutes or so, the harder the algorithm becomes. And therefore, it sort of turns into this arms race, and has turned into this arms race, where you've got more and more people and more computing power is needed to be the winning miner. Interestingly, what we've seen recently is in China, there's been a major crackdown in the mining industry, and a lot of Chinese mining operations have shut down recently. And as a result, the algorithm has actually gotten easier. And so it's actually recently become easier to mine because so many miners have gone offline. And so, you know, there is this really interesting aspect of the Bitcoin network in particular, how the protocol is able to sort of adapt based on the amount of energy that is putting into it. And so it may be that one day, you know, proof of work, at least in the Bitcoin context, reaches a sort of, you know, the industry works together to reach a sort of harmony with respect to, you know, securing the network on one hand and efficient energy consumption on the other. The industry may never see that harmony, and instead what may happen is we may see more of a move to proof of stake, as David mentioned, which, you know, the Ethereum network is working on right now. So just another interesting part of this story that, you know, is unfolding in real time for us.
Rob, thanks.
So
well, go ahead. One of the things I
just want to add one more thing. I know
ahead,
I said I want to get past this, but Robert mentioned the Hyperledger network. So one of the things we will talk about is there are blockchain variations. Some might dispute whether they are appropriately called blockchains, but nonetheless, at least distributed ledger solutions that don't involve tokens at all. And the trade-off there is more, you need more centralized control to make them work. But go ahead, Bob.
What I was going to say is I forgot to mention that blockchain is to crypto as internet is to email. While Bitcoin really brought blockchain to, it was like the tail wagging the horse, to popularity, the blockchain is the underlying technology to facilitate a particular use case. In this case, we're talking about Bitcoin, but fundamentally, blockchain is the kind of the infrastructure on which all these other uses are built. Let me see if I can move forward one, because I only have a few more slides. Yeah, very quickly, some of the benefits, and I'm glad that Rob and David chimed in. This is and actually this is Brian's point. This is a trustless situation and a technology, and what that means is you no longer need a bank in order to facilitate a money transfer. You no longer need a governmental entity to record the sale of a house if states ultimately adopt blockchain as a method of record keeping. When the case of smart contracts, you don't need a lawyer, that formally trusted intermediary, in order to make these transactions happen. So there's a convenience factor that really makes blockchain very attractive, particularly when you're talking about a couple billion people who don't have access to a bank or a bank account and need some other way to transfer money. once a transaction started, it's unstoppable. We mentioned the immutability. We mentioned the decentralization. In theory, the cost is lower because while you have to pay a miner, you're not paying a bank fees and you're not paying a lawyer fees. It's peer-to-peer. It allows me to interact directly with Brian if I want to transfer money. In theory, someday you might be able to replace Uber by having someone on a network who's willing to drive me, and I don't need Uber there as that trusted intermediary. It's transparent. I mentioned transparency very loosely here because many people interact on blockchain networks anonymously. And while in the Colonial Pipeline situation, the DOJ claims it recovered 60 million, or I don't know if it was 60 million, but 68 Bitcoins or something, a good chunk of the money that was paid in the Colonial Pipeline ransom. That's very, very hard to do. And the final point I've already made, it allows for universal banking. And very quickly, and then we'll be able to get back to the main presentation. We're going to be talking, I think, about smart contracts, and you'll see the definition there. It's computer code. It's an if-then situation that if certain things happen and the parties agree to what the then is, that these contracts are self-executing. And I draw a distinction here between smart contracts and smart legal contracts, because smart legal contracts have the same characteristics as all other smart contracts, but they have to have the necessary requirements, offer acceptance consideration in order to be considered legal contracts. I'm going to stop there. I had a few more slides, but I know we've got to move on. So that's it. That's basically blockchain in a nutshell.
And that was perfect. And I'm going to apologize in advance. I'm at my parents' house, and my dad has a collection of grandfather clocks that are not all on the same time. So I'm getting dawn. I've been able to mute myself, but I apologize if you start hearing noises. That's what it is. Anyways, excellent, Bob. And we're going to go back to those characteristics in the second to last slide you had as we go through our next section. So that's a breakdown. And anytime you try to do an overview, inevitably you have to get somewhat technical and it gets confusing. We're going to try to pull out now and talk about, well, what does this all mean? What are people doing with blockchains? And in particular, with some emphasis on the legal side. But we decided, and this is Robert's great suggestion, we're going to break it down into kind of two general buckets. Cryptocurrencies, crypto assets, and then kind of everything else, but really information-related applications, which is a pretty good way to think about how these things work. And they obviously interact, and we'll get to that, but it's a good way to kind of start to get your head around. So I'm going to let Robert give us a quick overview of that first category, crypto assets.
Sure. So, one of the unique aspects of blockchain technology is that it allows us to create a unique digital asset. As a general term, I'll call it a cryptographic asset. And that cryptographic asset can symbolize just about anything. And what makes blockchain unique is that it's a database where those cryptographic assets can only exist in one place and with one person at a single point in time. And also the transaction history of the transfers of those cryptographic assets is recorded in this immutable ledger that Bob talked about. And so while these cryptographic assets can represent anything, in the very first use case of blockchain, which is Bitcoin, and in many of the use cases that are in existence and that the industry is working on today, they represent certain types of financial assets. And the reason why blockchain is a great place to store and transfer financial assets is, again, because of these unique aspects of distributed networks, immutability, cryptography, and ultimately the ability to transfer things without a centralized party managing them, which sort of takes it outside of the traditional world that we're all used to, where you can take a digital file and copy it very easily. You can't do that with a blockchain. And so this allows us to build systems related to any type of asset, but in particular financial assets that are highly secure, highly efficient, And so, you know, financial assets has emerged as arguably the most used use case for blockchain so far. Finance, you know,
can I just stop you real quick there? I want to connect something that Bob had mentioned. So Bob made that distinction and said, well, you know, blockchain is or Bitcoin is the blockchain as email is to the internet. If we think about blockchain as that kind of quintessential digital asset, what does that mean? Or maybe I'm only seeing this parallel.
So I would say, you know, blockchain is the technology that allows us to create what I'll call cryptographic assets and store and manage those in a way that we couldn't do before. You know, Bitcoin is the first implementation of blockchain. Bitcoin is a payment system. And so blockchain enables us to create new payment systems using these cryptographic assets. But as we'll get to near the latter half of the panel today, you know, we can also use blockchain to help store and manage other types of assets, you know, namely other types of information or data outside of the financial context. I don't know if that completely answers your question, Brian.
Yeah, I guess what I was thinking is one thing that helped me early on is to distinguish Bitcoin and blockchain is, well, Bitcoin is an application to transfer money. And it necessarily, the money in that case, or the money is the financial asset is the coin itself, which also happens to be an integral part of the blockchain system. But the whole point of Bitcoin primarily is to exchange money that is the token. So that's the part where we start to get kind of like, but anyways, that helped me to think about that. And there are other things you can do that may or may not involve tokens with blockchains, which is what we'll go for now, right?
That's right. So to put it another way, Bitcoin is one application or one use case for blockchain, one of many use cases that I think the industry is still exploring today. And, you know, just as a kind of aside there, you know, the Ethereum network has all those features that Bitcoin has as a payment system, but it also has additional features, things like smart contracts, things like decentralized autonomous organizations, things like non-fungible tokens that allow it to be used for other applications, and in some cases, non-financial applications, and in other cases, financial applications with a higher degree of complexity than what's available on the Bitcoin network. So I think maybe that's a good segue into some of the legal issues because, you know, one of the things I like to say about this industry is that, you know, you've got a lot of the ethos sort of from the first tech boom is still underpinning some of the excitement around this industry, but there's kind of a big difference between kind of the first tech boom, which I think dealt mostly with information and sort of speech in particular, which is largely unregulated for the most part. I mean, there are some, but for the most part, an unregulated industry. And now the blockchain industry, especially when we talk about financial applications, we're dealing with money, which is one of the most regulated things on the planet, and financial instruments, which are one of the most regulated things on the planet. And so there is a little bit, and I've seen in my practice, you know, certainly a lot of disconnect between sort of this ethos that I think came about in like late 90s, early 2000s with the tech boom, you know, building a new industry that was largely unregulated. And you have a lot of that same ethos involved in building this new industry that is actually very, very regulated. And to put it simply, kind of at a 30,000-foot view level, you've got these cryptographic assets, you know, call them cryptocurrencies, call them digital assets, whatever you like. And, you know, to say that they are unregulated is the farthest thing from the truth. They're in fact, you know, it gets complicated because we don't have comprehensive legislation, but what that ends up, what that results in is we've got 4 different regulatory agencies in the US that are regulating these assets in 4 different ways according to 4 different sets of regulations. So you've got the IRS, which defines cryptocurrencies as property. And so you've got to calculate your basis and your gain or loss on transfers of those cryptographic assets. You've got FinCEN, the Financial Crimes Enforcement Network, which is charged with enforcing the Bank Secrecy Act and anti-money laundering laws. From their perspective, cryptocurrencies are, quote, money, so regulated just like money would be from an anti-money laundering perspective. You've got the CFTC, the Commodities Futures Trading Commission, which has defined cryptocurrencies as commodities subject to their regulations. And then finally, you've got probably the most complex of all, the SEC, the Securities and Exchange Commission, which has, for the most part, defined cryptographic assets as securities, with a couple of notable exceptions. So, you know, there have been public statements by commissioners and directors discussing how Bitcoin is not going to be considered a security, and neither is Ether. But just about everything else is really fair game from the SEC's perspective in terms of being regulated under their jurisdiction. And so those are the four main main regulations that you're going to have to deal with if you're an attorney navigating this market and, you know, assisting businesses that are dealing with cryptocurrencies or any type of digital asset or cryptographic asset. You know, later we'll talk about data management, and that brings with it more regulatory agencies, things like the GDPR, the CCPA, and even the antitrust laws. But, you know, what I like to highlight for any attorney practicing in this space or interested in this space is that if you ever hear someone say that this industry is unregulated, that is the farthest thing from the truth. It's actually about the most complex regulatory environment you can be in, where again, you've got 4 different regulatory agencies that you have to deal with. And I often say to clients that, you know, you want to be able to build solutions where you only have to deal with ideally only 2 of those agencies, because you're going to have to deal with the IRS and at least one of the other 3. In a lot of cases, you'll have to have a framework for complying with 3 out of those 4. And if you can avoid dealing with 4 out of the 4, you're actually in pretty good shape. So that's just a snapshot of how complex it gets, you know, from a legal perspective when we're talking about these very new assets that can be that are being transferred and managed on blockchains.
Robert, before you move on with that, can I keep him on that last point?
Yeah.
Part of the challenge I think that we have with blockchain assets, they're being exchanged on the internet that is not geographically bound, right? I mean, you have people engaged in blockchain transactions all over the world, and I think at some point that's going to add another layer of complexity, because if you are doing a lot of business and, you know, the European Union suggests that you're doing business over there, we're going to see, I think, even more complexities as governmental entities become, you know, more concerned about protecting their turf.
Yeah, and we were already seeing that with the exchanges. And at least when I was more immersed in this, there was a really interesting phenomenon where you had countries competing on their the flexibility of the regulatory environment to enable the use of systems that involve tokens in particular. I forget which small island country had actually, you know, made itself kind of the, you know, the equivalent of a tax haven in the sense that they were deliberately creating an environment where they would work with you on a case-by-case basis to define whether the token was a security or not and what you had to do. I just want to probe one piece of that, because it's really interesting how fast this evolves. Even 5 years ago, when I was first getting into this and talking to people, you'd go to conferences where the tech folks were saying, no, this isn't, tokens are not a security. And they would just say that flat out because they believed it in a kind of, they were lawyers, but they believed it. It's sort of like, it brought me back to my days when friends of mine would say, you know, keep my music free on Napster, right? Keep the law, same kind of sort of ethos where, you know, this is tech that's doing amazing things. I don't want you, the law shouldn't get involved in a kind of moral way. David, can I pull you in here and just, could you explain just a little bit what that tension is between, if you're using a token-based blockchain, why you sort of have to have a token to make it work, and how tokens in some contexts might operate in ways that don't look like securities, but how the distribution almost inevitably makes them security-like, and therefore the SEC is a sort of jurisdiction.
Sure.
And David, could you explain what a token is? I neglected to do that.
Sorry. Yeah. Start there.
So a token is another, well, a token can be also referred to as a coin or a cryptocurrency. It's essentially, it represents either a currency or an asset. It's a representation of something that is transferred along the blockchain for whatever blockchain you're working on. And so just to kind of set the table here on this a little bit, Most attorneys that work in securities know that the SEC uses the Howey test to determine whether or not something is or is not a security. For those of you that don't work with it a lot, the Howey test was a court ruling, a test that was court made in the 40s that dealt with investment contracts for orange groves. So, you know, you could see how it's applicable to Bitcoin and blockchain, right? Nevertheless, that test is used when the SEC determines whether or not a token is actually going to be considered a security. And so I would say that out of, if I talk to 9 clients that are issuing tokens, I would say 9.9 of them are going to be considered securities. Because the only way that you're not considered a security is if you're a true utility token. And we're talking about ICOs generally, issuances of tokens. And I'm not talking about non-fungible tokens, which we'll talk about in a little bit. But what we're really talking about is someone issuing tokens. They're selling these tokens. They're raising funds. And largely the success and the value and the increase on value is based on the actions and the efforts of third parties. And so the SEC has come into a lot of these companies and looked into these situations and said, you're a security, you're offering your token to the general public, and you haven't registered with us, you don't fall under an exemption, and therefore we have to do something about that, whether that's fines, whether that's disgorgement of funds. But I would say for a large part of the companies that are out there that are issuing tokens or doing what most clients call ICOs, they're going to be considered securities. And I would also say, Robert mentioned FinCEN earlier. To the extent a component is not a security, the FinCEN is also going to be looking at that as a money transfer or money services business. So there are some very important regulatory institutions, government agencies that are looking into these transactions, and it is complex. I don't know if I answered your question, Brian.
Yeah, and just the way I was able to wrap my head around this as a non-expert in securities and barely a person who understands technology is there's an app that helped me understand. Let's call it an app on Ethereum called Steemit. Okay. And what did Steemit do? Well, they took advantage of the nature of this structure and said, well, we're going to create a Reddit version of Reddit where instead of you just, stick it, clicking your thumb and getting things upvoted that way, which invites all sorts of strategic behavior and bots and all sorts of like that. No, we're going to have a token called Steem. And the way that you decide if you like something, you got to pay Steem for it. And that's how it gets upvoted. And so that both creates an internal economy to write good stuff because you earn Steem, and also makes it more credible that someone actually liked it because they spent Steem to do it. And so that's, as you mentioned, utility token. That's a utility. That function is utility in the sense that it creates an internal incentive-based thing to make the function of the app actually work in an integral way. Well, how do you get Steemit up and rolling? No one has Steem until they have Steem, right? So you got to distribute it out. And that's the problem of the ICO, the initial coin offering, which was a terrible acronym to use if you didn't want to be called a security, because it sounds a heck of a lot like something that the SEC regulates. But nonetheless, that became the term of art. And so the problem is to get it out there, well, you have to have some way to do it. And the way that it's done on Ethereum is, well, you start with Ether, the token on Ethereum, and you use that to buy it. And there's an economy around it, which in the sort of, especially in the bubble, created lots and lots of essentially, bets around, hoping that some of these new things might become more valuable, and some did, some didn't. So in that initial distribution, often it very much looks like a security. Once it's up and running, it might no longer have to have that, there's enough of it out there and it's distributed enough that you can, you can get that thing moving. But there's that chicken and egg problem that's almost, I think, you guys correct me if I'm wrong, an inevitable component of starting up a token-based application. And so you know, where do you draw the line? The SEC rather arbitrarily, because they kind of had to, said, well, Bitcoin and Ether, well, you guys have been around too long. We're not going to jump in now and start, you know, disgorging profits from, especially with Bitcoin, who the heck knows, and say you're now a regulated security and you shouldn't have done the distributions you've done. With these new ones, they're getting involved in part because there's a lot of scamming going on. Anyways, I didn't mean to talk that much. Anybody else want to add into that before we move on to our second piece, the what else you do? Although maybe we should talk about NFTs real quick. Robert, you want to tell us about NFTs since we mentioned it, which is would fit in this first category, right?
Sure. Well, let me just let me just react to a couple of things you said and try to add a little bit of context here. So we talked about the Ethereum network and how it's got all the great qualities of a payment network that Bitcoin has, but it has other qualities as well. And one of those interesting qualities is the ability to create your own, well, for lack of a better word, token. And these are called ERC20 tokens. And it's, from a technical standpoint, relatively easy to create your own tokens that can be created on the Ethereum network, transferred, managed, stored on the Ethereum network. And that's one of the unique aspects of Ethereum that allows us to build things that couldn't be built on networks that didn't have that capability. But it also creates this tension because, as you know, Brian, as you talked about, and as David's talked about, when folks started creating these ERC20 tokens, and with different ideas of how they would be used in different types of applications, the process of distributing them in most respects will trigger the securities laws. And what I'll say, to try to put a little bit of a bright line on it, anytime you're creating a network where you're creating these ERC20 tokens and you're distributing them in a fundraising event, you're selling these things, to raise funds, that is almost certainly going to be considered an unregistered securities offering. It gets more complicated when you're creating an ERC20 token that has some other real functionality within a real network, where it's not used as it's not being sold in fundraising efforts. But even then, Brian, as you said, there's this difficulty around how do you get that distributed in a way that doesn't trigger the securities laws. So, that's just to kind of put a little bit cap on the securities laws issues and the concept of an ERC20 token. More recently, folks building on the Ethereum network and other networks have created, at least on Ethereum, they're called ERC721 tokens. It's a different type. It's similar to an ERC20 token, but a little bit different. The difference is that with an ERC20 token, you create a batch of these things, and they're fungible. Each one is just like the next one. And so, typically people would create like somewhere in the neighborhood of 1 billion of these things. And they're all essentially, each one has the same features as the other. With an ERC721 token, that's where you get this concept of an NFT or non-fungible token, which means that each token has, sort of the technical equivalent of a unique identifier or barcode or something like that embedded within the token, such that you can see that each one is unique from all of the others. And it's these ERC721 tokens or non-fungible tokens that have enabled the new NFT market. And the way that NFTs work is you have an ERC721 token, so a unique token where people can prove that this is, quote, the official version of this token. And there's only one like it out there, and we can prove who owns it at any given point in time. And that token is embedded with technical features that point to a digital media file that is stored typically not on blockchain, but somewhere else, either a centralized database or a different type of decentralized database like IPFS. And whoever is holding that non-fungible token is the only one that will be able to access that media file. And so even though other people may be able to obtain that media file from other sources, only the holder of that non-fungible token, that NFT or ERC721 token, will be the one who can claim ownership of, quote, the original version of that media file, whether that's a digital image, whether it's a video, whether it's a music track, whatever that might be. And I'm not here to judge, sort of the value of that. I think that's up to the market to judge. But there is inherent value in the idea of being able to prove that you own the official version of a certain digital asset. And that's sort of kind of the core concept behind NFTs and why people find value in them. And, you know, as I think people have seen in the media, like these things are more and more NFTs are being launched almost on a daily basis. And it's created a real, you know, a lot of really interesting implications for all sorts of industries. You know, I think to like baseball cards, you know, I collected baseball cards as a kid. Well, it could very well be that NFTs are sort of the new version of baseball cards, where instead of storing them in your pocket or in your backpack, you're going to be storing that baseball card or that NFT media file on your smartphone. And so that's just a little bit of an introduction to NFTs, but I'm certainly interested to hear what some of the other panelists have to say.
Well, you mentioned, we already talked about the issues with crypto and tokens as it relates to the SEC and the other alphabet agencies. So the one thing that I find so interesting is the intellectual property issues that come up with NFTs, as well as just general ownership and transfer of ownership issues that come up with NFTs. It's so interesting. I think the NBA was selling NFTs, but they were selling like sets of 8, like of the same NFT. So almost like prints when you buy an original painting or prints of a painting. So I find the intellectual property issues, copyright, trademark, all of that comes up is really interesting, and it absolutely needs to be considered in every instance.
Yeah, I don't get it, quite frankly, the value of saying I have the only Gucci purse if everyone has something that is exactly identical and you happen to have the one that was the original. And, you know, as David said, what I can't unpack, and I'm not an intellectual property lawyer, is how you can have images. Perhaps the most famous NFT is this, a dunk, a fairly commonplace dunk by LeBron James in an NBA game that has sold for hundreds of thousands of dollars. And trying to understand, you know, how you get past the, you know, the ownership rights by the broadcast system that actually filmed it, how you get past, you know, LeBron James's image being used for commercial purposes, how you get past, you know, the team's intellectual property rights to their jerseys and the NBA to the game. And I think it's an assumption of the risk issue, really. So long as somebody's willing to pay for it and then take on that responsibility, that legal accountability for whatever, you know, protection that, you know, those assets, you know, require, I think the market's going to flourish. And interestingly enough, you have artists who are creating the original copy, and they get a royalty of sorts. But it's astounding. There was one artist whose name I should know. It's an odd name, who's just totally baffled because his artwork has generated tens of millions of dollars, but his share of the original artist, his share of that art is very small as it gets transferred, and the price goes up exponentially. And I think, like so many crypto assets, cryptographic assets, I think we're going to find that the volatility of NFTs is going to mirror that of cryptocurrencies, where it's really defined by what the value that people will lend to it, unlike fiat currencies, reserve currencies, where, you know, it's got real live value that you can go into a store and you know it's worth what it's worth.
Well, what's interesting to me is how the NFT, you know, it takes advantage of blockchain's unique characteristics, including immutability, transparency, and therefore auditability, to do what we used to do physically with signed prints, right? So it's really easy to fake a signed print, and you have to get, you know, these experts to try to decide whether it's really one of the 100 or the one of one. And the beauty of blockchain is you can actually, you know, you know, it's pretty hard to fake that. And so you get it, but then and then how clever that opened the door to, well, if what matters is that confirmation of uniqueness or of distinctiveness, because it's one of a set, We could do that to anything, even something that is easily applicable, like the screenshot of LeBron's dunk. I mean, to me, that's just a fascinating, and the value, the value question is a market question, as David said. But but from the perspective of art, I think it makes a ton of sense in that digital art, at least, it gives you a way to really confirm, hey, this is the one. And this is the one that the artist got value for, and that should have value in the marketplace if we care about uniqueness in that context.
And Brian, isn't that really what interests lawyers, I think, is that validation process? Because most of the record keeping that we think blockchain is going to replace, who really owns this house, right? Yep. Who really owns this car? Whose digital identity is this? It's that validation process, even though portions of the record itself that's being validated may be stored somewhere else. At the end of the day, blockchain's value is to verify only one person can own this asset at any given time. Or if 6 of those assets are out there, only 6 people can own them, unless you divide them up like Bitcoin.
And who owns them? So that's, I think, a perfect segue to our next section. Before we move on, the first and only, to my knowledge, Cleveland martial law NFT. It's not yet on chain or for sale, but I'll take offers afterwards. Just kidding. It'll never go for sale. Which raises another issue that maybe we'll get to about gas and transaction fees. But let's move on to the second category that we mentioned, which NFTs maybe start to bleed into to some extent, but this notion of using the blockchain as a ledger, right? As Bob said, but a really advanced ledger that has really interesting properties. And David, I'll let you introduce that for us, and then we'll have a similar conversation.
Sure. So we were talking about equity or securities. We talked about NFTs. Some of the other interesting ways that blockchain can manage or the applications useful are transfer of other assets like real estate or vehicles. I guess vehicles could, well, no, that I don't think that would. Tracking identity.
And actually, David, I forgot. There's a question that maybe you can fold in.
I was going to get to that. I saw it.
Oh, good. All right, good. And Brendan, we'll circle back to yours. Yours is a little bit more complicated, but go ahead. Sorry.
So identity is one important one. We've already had an application in Northeast Ohio for voting using blockchain technology. Government ID, helping banks to implement anti-money laundering and know your customer policies. But one of the best use cases, non-financial use cases for blockchain technology is supply chain and logistics. And so the question, I think, asked if blockchain was being used in the food industry, and yes, it is. I believe that Walmart has implemented its own, but just a general example I would give for a good use case for supply chain and logistics and also product tracking is on food recalls. So when using lettuce or spinach, for example, if there's a salmonella outbreak, usually large swaths of lettuce or spinach or whatever, they're recalled and they're destroyed, costing millions and millions and millions of dollars to the many parties involved in that particular recall. Using blockchain and the special characteristics of blockchain will allow the parties involved with the recall to focus that recall a little bit more and limit the damages from destroying the huge swaths of lettuce and spinach or whatever food product you're talking about. So I hope that answers the question for the food use case for blockchain.
David, it's used for medicines as well, correct?
Well,
I think we're seeing the pharmaceutical industry explore that as well.
Yeah, it's being explored there as well. Another example would be medical records, although that presents its own issues because potential HIPAA violations with disclosing medical records that could potentially produce some issues. So yeah, those are some of the examples of the non-financial applications for blockchain technology.
Yeah, and so just to recap that, and the food industry is a great one, as you said, and Walmart's is exactly what you said. I heard a great presentation on it. They are, and this gets at some of the complexities with other emerging or existing technologies. They are using Internet of Things tech, scanners, and essentially some kind of a chip. And the example I heard was hogs, pigs. You know, they little scannable code on their clip to their ear, so they know what the hog is. They know what it's fed, and the farmers have to use this scanning device to input data as the hog goes through its life cycle. And then when it's butchered, I don't recall exactly how they keep that tracking going, but I think the packaging in each phase continues to maintain that code, all the way up, you know, down to up to the grocery store if there's some kind of a problem with that. So first of all, you track, hey, this is a, you know, pasture raised, grain fed, or whatever it is you want to say about that final product, which of course, you know, you get to a grocery store. How do you confirm that, you know, my eggs are in fact free range, humanely raised chickens? Well, this is a great way to do it. Again, you've got a ledger that's recording all of that. And then if you need a recall, well, now you can recall exactly, right? You find out from the consumer, if they still have the box, well, hold on, which eggs do you have? We don't have to get every egg from that farm now. We know it's probably these eggs or maybe some related set, much smaller, and it speeds it up. Go ahead. Somebody was going to ask something.
I was just going to say, traditionally, historically, and currently, those types of things are tracked with systems, spreadsheets, whatever, that are easily manipulated. And they often
human error.
Right. And they often go through many different hands, sent via email, copied, pasted, etc., many different times before it gets from where it started to where it goes. Whether it's a distributor or 5 distributors in between, that information can be changed many times. And it's not just with food. This is applicable to medicine, medical records, identity, etc. But all of these things can be changed, easily manipulated. Now, Bob mentioned immutability as it relates to blockchain as being one of the things that was great about blockchain technology. I will say that it's practically immutable, right? There is a thing called a 51% attack in a decentralized system. A centralized system, one party can control the transaction, so they could go in and change things. Maybe not as easily as an Excel spreadsheet, but they can go in and change the rules. With a decentralized system, you have to own 51% of the mining power or the transaction validation power in order to change the rules to go in and change things like that. So if you're working with a decentralized system, one of the shining characteristics of a blockchain technology is that it's very, 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 very difficult, almost impossible to change something, change information on that network. And that's why it's a good use case for supply chain and logistics. It may not be the most practical from a speed and cost standpoint, but if you're looking for reliability and quasi-immutability, it's definitely the greatest product out there right now.
David, is that what you would call it? Is that how you get forks in chains? Is through that 51% mechanism?
Well, I mean, you certainly would need that in order to fork. I mean, there has to be a consensus amongst the parties involved to fork it, but it's not necessarily by a 51% attack if it's not planned for anything like that.
Okay.
Yeah, no, that's a great question because it illustrates. So when we think about a public chain, a token-based, truly decentralized chain, which Bitcoin is and Ethereum is to for the most part, the way you decide how it's going to operate and including its technical infrastructure is through mining consensus, right? That's the whole genius of, you know, a trustless trust or decentralized decision making. is you just got to decide. And a fork in the chain, the reason why we have Bitcoin Classic and Ethereum Classic and Ethereum is there was some consensus formed with relatively more or less kind of top-down decision-making, more so in Ether than in Bitcoin, but still a sort of cadre of old guard people at Bitcoin that decide, you know what, we got to upgrade the network. We got to change the way it functions, which changes, you know, and the mining has to follow that for it to work. And if some of the mining stays on the old network, then that still continues to function. So you get these really interesting governance issues that we really haven't talked about. And if they're planned in a sense, it still is kind of a bet. You got to have it happen. There have to be enough miners that decide we're going to start mining on the new infrastructure that's created by the fork. Whereas a 51% TAC is just a decision by 51% to make some other decision that we would define as not in the public interest, but in the self-interest of that 51% group, and therefore illegitimate. But it raises really, really interesting questions about legitimacy that relate to a topic that we haven't yet talked about, which is smart contracts. And maybe we'll get to DAOs if we have time, but we've only got 15 minutes left. So I do want to sort of circle back to that smart contract concept and talk a little bit more about it and how smart contracts sort of are another use case that take advantage in a more sophisticated way of this ledger, this basic function of a ledger. And Robert, maybe I'll ask you to kind of introduce that for us. Bob already gave us a quick overview of smart contracts, but maybe you could talk about what do we really mean by that and how do they work?
Sure. Well, so smart contracts were another one of these innovations that was originally offered by the Ethereum network, but they're now able to be programmed into other blockchain networks, including private permission blockchain networks like Hyperledger. What a smart contract is it's basically the ability to program logic rules into a blockchain so that when one type of transaction happens, another type of transaction automatically happens. And there are all sorts of applications for this smart contract technology. I mentioned DeFi earlier. DeFi is decentralized finance, is based off of smart contracts where certain financial transactions happen automatically because they're programmed based on smart contracts. David was talking about the food supply chain as an example of like a non-financial use case. It could be that, in a non-financial blockchain application, when delivery is made of a certain good, a certain notification is automatically sent to another party that has an interest in that good having been delivered. So that's generally what smart contracts are. It's the ability, and another way to put it is the ability to program an if-then statement into a blockchain. So if one type of transaction happens, then a certain other type of transaction automatically happens. I like to say that, I'll borrow a soundbite from a colleague. Smart contracts are neither smart nor contracts. They're only as smart as the programmer. And so smart contracts have been very much susceptible to hacking because like any computer code, they're only as good as the code. And for every brilliant coder out there, there's an even more brilliant coder that can figure out ways around code and figure out how to take advantage of it and manipulate it for ways that it was not intended. So in that sense, they are not necessarily smart. And they're not contracts in the sense that they do not, unless there is a real legal contract governing that smart contract, they do not necessarily have the enforceability that a typical legal contract would have. And so, another soundbite that I like to say is get a contract for your smart contracts. So in other words, if you're building a blockchain system that relies on the functionality of smart contract technology, you should very seriously consider hiring an attorney that can work alongside your tech developers to create legal contracts that govern the operation of those smart contracts. And in particular that, have safeguards for events involving unintended consequences of that smart contract code, where maybe the smart contract code didn't function in exactly the way that you wanted it to, and that especially in the context of like a larger ecosystem where you have people that are relying on those smart contracts, if the smart contract malfunctions and there are downstream effects on other parties that have an interest in that smart contract functioning correctly, what are the rights and remedies there? And so those are some of the aspects that I think, that I would encourage people to think about, when they're deploying smart contracts in, a live environment, and how to build legal contracts governing those that adequately safeguard and protect the interests of the different stakeholders, in that smart contract, which is really not a contract, but actually just code.
It's not a contract, Robert, but I know one of the things we talk about in class, without coming to a real answer, is you do have an unauthorized practice of law issue. If in fact you're calling something a contract, you're suggesting to the outside world that it will eliminate the need for a lawyer, and that you can create with software, with programming, what otherwise might cost you money to have an attorney create. And that's one of the considerations, I think, that would almost demand that lawyers be part of the process for some of the more complicated uses of smart contracts.
Yeah, so it's interesting to me. It's kind of like blockchain and Bitcoin's view of banks, right? Is, in some ways, maybe Bitcoin is not a smart bank. I don't know. But, one of the impetus behind it was, let's get rid of banks because banks are corrupt and extract value that they don't deserve, right? You can see how that then becomes a programmer's view of contracts. Well, what do contracts do? Well, they commit people to do certain things. We're just going to code those things and make them execute on their own, and we'll call it a contract. But in reality, from a lawyer's perspective and a legal perspective, well, the code is just a mechanism to perform the duties. And at least when we call it a smart contract, it's generally a mechanism that is going to self-execute. That's the key of it. And as Robert emphasized, for us, well, that's not a contract. That's just code. But if you're going to call it, as Bob says, a contract, and that is, that's where things get kind of interesting, right? You've got some really clever developers, many of whom are lawyers out there, thinking about, well, there are ways that we might be able to encode the terms of certain kinds of contracts. And then we get into that hard question of, as us good lawyers know, well, words are always amenable to some degree of interpretation and some more than others. And in many ways, contracts often are deliberately ambiguous. So both parties think they're getting a kind of different kind of deal, even though functionally they're basically getting to the same result that they're happy with. If you try to encode very prescriptively the terms of that contract, you raise a whole interesting set of issues around translating business intention into hard code as well as legal requirements. So it's a fascinating area. David, you look like you were going to jump in?
No, I think we're running low on time. If we've got other topics to cover.
Well, we've got a couple questions we didn't answer. The first one, I'm going to throw it to Bob because it seems to fit squarely in your expertise. Do any of you have a recommendation for a resource that would help a novice professor teach blockchain to students in English?
Absolutely. Block Geeks was my go-to. If you go to YouTube and you search the word Block Geeks, they've got a great series of videos that are available in YouTube. And YouTube to me is encyclopedic. I'm a big YouTube fan. I don't think that resorting to YouTube is necessarily like resorting to Wikipedia. It's got that bad reputation. But and for the more sophisticated practitioners, it's the Digital Chamber of Commerce, which its members are kind of at the vanguard of what the blockchain industry are trying to do. They monitor what's going on in the regulatory environment. I mean, Robert made everything sound complicated because he was talking about, the federal stuff. We have 50 states, right? And the states are starting to decide what's our role in regulating blockchain, and particularly when you're talking about record keeping and replacing, the government as the record keeper. And so the nice thing about the Digital Chamber of Commerce is the folks who are involved in the chamber are kind of incentivized of staying up to date. So you can get legislative tracking there. You can get some nice, more sophisticated than block geeks, at least from a legal perspective, information on the enforceability of smart contracts, what tokens are, and what various regulatory agencies are doing. And I strongly encourage lawyers to at least get that fundamental understanding before they try to make the leap in reading opinion letters from the IRS or the SEC or advisory letters, because you're going to be way out of your element. And we joked about something privately that I think we need to talk about and warn everybody about here. I'm not David, I'm not Robert, okay? Before you get into this area and start advising clients, understand that this is a highly specialized area, much like environmental law was. And having a little bit of understanding in an area like blockchain may allow you to sell your services to a client, but you really have to recognize your own limitations, like Clint Eastwood and Dirty Harry said. A man's got to know his own limitations. It is so fast moving. Unless you have the time to devote to regulatory developments, you're looking for a malpractice case against you.
CoinDesk is also a good.
It is. That's very good for cryptocurrency.
And on that same note, I'll just mention my own weekly blog that I curate and edit for Baker Hostetler. I'll put it in the chat now. And what I try to do with this blog is take all the news that keeps coming out week by week and summarizing it in a concise way that kind of cuts out the noise and gives you only the pieces that are most relevant. We link you to the source documents. And so if you want to know what I'm paying attention to, it's all in that weekly blog.
I subscribe to Robert's blog. It's very good. I recommend it.
Thanks.
Yeah, and I threw in there, IBM has a lot of resources. We've been talking a little bit about and mentioned several times private or permissioned ledgers. And IBM is part of a consortium that created Hyperledger, which is the major sort of, I don't know, someone else describe it better than I can. Robert or David or Bob, how would you describe Hyperledger and what's the big difference?
Yeah, I'm happy to, let me take a shot at that one. So the Linux Foundation is a nonprofit that has been around for a long time, and it's composed of several different companies, large companies in the tech space, IBM, Dell and Intel and others. And at some point, IBM created the first private code for a private permission blockchain. So a blockchain where rather than anyone being able to support the network through mining, instead it would be invitation only in terms of who's hosting nodes on that network, supporting that network, and private in the sense that it was invite only in terms of who would be able to use the network. And they created the source code for what eventually became known as Hyperledger Fabric, and donated that code to the Linux Foundation. And since then, there have been like dozens of iterations of Hyperledger code. And there are dozens of different types of Hyperledger. Hyperledger Indy was another one of the early ones. Hyperledger Sawtooth was an early version. And the list goes on. And each of these versions of the Hyperledger blockchain source code is tailored for different types of business use cases. So, for example, Hyperledger Indy is one that I find particularly interesting. It's tailored toward blockchain solutions for identity management, so digital identity. Hyperledger Fabric is used for a number of things, but it's one of the key blockchains used in a lot of supply chain solutions, some of the things that David was talking about. And the list goes on. And so you've got these different blockchain protocols that were developed for use in, again, private permission blockchains, but where the source code is public and can be downloaded and then tweaked, for other specific purposes. And the work on the Hyperledger code bases continues to grow such that more and more of these codes are becoming publicly available and tailored toward different use cases as people continue to build different non-financial applications of blockchain.
Yeah, and the basic idea is for businesses trying to do this in a way that allows for more control, Hyperledger provides at least the start of, it's a little bit like social media. It's accessible, but you can build something on it that isn't completely open, that you gatekeep what's going on, but provides a kind of common infrastructure to do it and typically without the complexities of tokens. Anyways, we're almost out of time, and I said we'd close with takeaways. So speed round, starting with David. Biggest takeaway for lawyers interested in the space and lawyers who think they don't need, or lawyers who think they don't need to care about it.
Well, I'm just going to reiterate what Robert already said. It's heavily regulated. Be careful. Be very, very careful. If you have a client that comes in and says very quickly, I want you to help me with this, don't just assume that it's something simple you can handle. On one hand. On the other hand, I do a lot of non-tech stuff in this industry. Power purchase agreements, leases, operating agreements, employment agreements, terms and conditions, privacy policies, So this industry is all encompassing, but be very careful. Do your homework, reach out to one of us. I'm happy to help. I'll point you in the right direction or do what I can. The rising tide lifts all ships in this industry.
Bob. I think building on what David says, regardless whether you want to specialize in this field, there's an inevitability to its adoption, in the marketplace. So you have to have a basic understanding of blockchain, if for no other reason than to have enough understanding to pass along the issue to someone else and to be the one who quarterbacks that issue.
Robert.
I would say if you are interested in the industry, recognize that this is a fast-paced industry. It's changing every day. And so dive into it and find your resources, your go-to resources that you can continue to read and take in on an ongoing basis. Build your network, meet different folks, both in the legal industry and in the tech industry, and get to be able to speak both of those languages, legal and tech, because that's where a lot of the opportunities are. And recognize that as we've said, it's a complicated industry and it's multidisciplinary by its nature. So no single legal issue is just blockchain. It's always blockchain plus one or two or usually 3 or 4 traditional legal practice areas combined. And so form your own network where you have different experts in those fields that you can go to. And if not, if you don't have that, go to someone like David, go to someone like me, go to a law firm that has those larger resources. And we often, I often work with solo practitioners or general counsels where they're coming to us for a little bit of extra firepower and a little bit of extra expertise, but where they're still kind of keeping the client and managing that client. And so that's a framework that even a solo practitioner can use to capture opportunities in this industry. If you're not interested in the blockchain industry, I would say recognize that it's here to stay. Like any new technology, it's going to change our lives for the better, and oftentimes we'll be operating behind the scenes. And so you ought to at least know how to recognize and spot blockchain issues when they arise, so that when you've got one of these issues that you may need to go to someone with more expertise for.
And I'll just say, close, it's a lot of fun. Joe, back to you.
Wow, what a dynamic panel. Over 50% of the time, nobody had their mute on. I mean, you guys were ready to jump in at any time, and it was really engaging. Thank you so much. What a wow. Okay, let's be back at 3 o'clock. We got a little break, and then we're back at 3 o'clock. Thanks, everybody. Great panel. Thanks, Joe. Thanks, everybody who attended. And thank you, guys. Take care. We'll probably get a notice. Hello, welcome back. We are to Ignite Legal Tech Innovation 2001, day 2. We're getting toward the end of the program. It's been a great 2 days. And just one reminder, at the end, you'll get the code for the CLE, okay? And now we have the next panel, the future of artificial intelligence and what it means for the legal industry. Our moderator is Catherine Lowry, Director of Practice Services at Baker Hostetler. She's in Cincinnati, Ohio. And Catherine, I'll turn it over to you.
Excellent. Thank you so much, Joe. I really appreciate it. I'm very excited to be here and with this esteemed panel, which I'm going to introduce in just one moment. But let's get started. I'm going to share my screen and I'm going to go through a couple of introductory slides. So as I do that, just bear with me for 1 second. It is an important, I think, session, and I would say it's last but not least in today's agenda, because there's a lot to discuss in regards to artificial intelligence and what it means for the legal industry. So I wanted just to kind of open and share as a moderator, things that we have to keep in mind when we're talking about AI. And from my perspective, I'm a director of practice services and head of Incubator, which is helping clients to integrate technology into their corporate legal department. We have to keep in mind some of the pressures that are on our attorneys, our assistants, our paralegals, others in our organizations that are trying to adopt technology. I put this together a while ago. I think it still rings true. Some of the things that we're faced against: high demand of work, need for organization, demands inside our organization, outside our organization, time, lack of time. And if you were able to tune in maybe a couple hours ago, I expressed some concern over time because we have to toil with AI. We have to understand some of the ramifications of it. We need to know how to best implement it across our organization, what we want to adopt, what we don't want to adopt. So I always like to kind of start and keep this in mind. This image for me is reality and can often identify some of the struggles when we're talking about legal technology and specifically AI. So I wanted to also kind of just start and open up. I'm a big fan of Gartner because of the deep research that they do. They put together this prism for use cases and utilization of artificial intelligence for corporate legal practices. I think this resonates with legal as well. Law firms specifically is what I meant. But I love how it's starting to look at and prioritize some of the business value and feasibility of what AI can do today. I think it's going to be an evolution over time. You're going to hear that from this esteemed panel as well. You're going to see a couple of deep dives into some of these solutions. And as we kind of think about that first person on the first slide, right, how much can any one practice group take? And part of that is you have time that you have to help and implementing attorneys and the legal profession have to absorb this. So it's going to be critical to prioritize. Thinking about business value and feasibility, I think, is a great metric. The more solid the bubble is as we go down means that it is a very high business value or very feasible. And it's not a surprise to me to see e-discovery at the top. I think it's been one of the kind of founding elements of AI in the legal industry. Seeing a few mixture of contract risk analysis as well as exploratory data analysis, some research. Hopefully this is kind of tantalizing you as far as what you're going to hear about today, because we're going to go a little bit deeper into to some of these. We'll talk about some successes and some potential issues or challenges. We'll even start to explore from a substantive area of law, what does this mean for us, all right? We all hold, as attorneys, different levels of competence that we have to bring to the table in regards to technology, ethical obligations. And so while we won't cover everything today, I do think you're going to get a great mixture from this panel. So without further ado, I'm going to stop sharing my screen and just do a little round of introductions, if you don't mind. And Make sure I've got that. Okay, so I stopped sharing. Good. So real quick, I'm going to start with Roger Skalbeck. I appreciate you being here today. He is the Associate Dean and Professor of Law at Richmond School of Law. So at this law school, Roger teaches legal research and copyright. He's a member of the Virginia Access to Justice Commission's Committee of Self-Represented Litigants. And he's taught courses and led initiatives in the areas of access to justice in Virginia and DC. He manages the people, sources, and technology at the law school library. And fun part here, during the pandemic, played a lot of online board games, had to keep busy, and still working to perfect a homemade ginger beer. And I suspect, Roger, that if we were in person, you would provide some for all of us, right? So we'll hold you to that next time we see you in person. Next, I have Todd Northman, who's a partner at Tucker & Ellis in the Cleveland hallway. He has been a transactional attorney, a lawyer for more than 25 years. He's co-founded and chairs the firm's autonomous vehicle and artificial intelligence technologies practice group, and he also serves as the business group's representative on Tucker Ellis's innovation committee. And in that role, he has tested and adopted a wide range of AI-powered products. So I'm excited to hear some of the successes and challenges that you've seen, Todd, here in the presentation. Bob Ferner is a director of the W. Bruce Lunsford Academy of Law, Business Plus Technology at Chase College of Law, Northern Kentucky University, which is just a stone's throw away from me here in Cincinnati, and is an adjunct professor at Southern University Law Center. He teaches law and technology courses for Chase's Law and Master of Legal Studies program and the legal app development at Chase and Southern. So I think a lot of experience you're going to share with us on that as well. And he's a former vice chair of the ABA Tech Show board and former member of the ABA lawyering task force. So a lot of great experience. I am really excited to be here with everyone today. And I would love at this point, Roger, I'm going to pass it over to you to kind of further introduce and share with us some of your insights.
All right, can you hear me?
Yes.
You can see the slides, excellent. Well, let's get started. I'm super excited to join you. Thanks to Case for putting this together, Catherine for moderating, and co-panelists for getting through things here. I'm going to talk relatively quickly and try to get through things in short order so that we can get to the conversation between all of us, because I think all three of our presentations here are going to bring to fore some things that are useful for us to discuss together and hear from the panelists and participants here on. As Catherine mentioned, my area of interest and teaching expertise is in copyright and legal research. I'm going to be talking mostly about legal research related things here, connecting that to the world of artificial intelligence. And so the way that I'm going to frame it here today is I like a good alliteration here. So I'm going to look at this in three sections, which is patterns, predictions, and products, going across all of AI and legal research, trying to get this done in about 15 minutes or less. So simplify many things, and I'm sure there are many details that I'd love to explore in follow-on conversations and things like that. And as I was preparing for this, one thing that I reflected on, having used legal research tools for well over 2 decades, is that the things that we're seeing now touted in marketing speak and brought out to be brand new features have kind of been around for a long time and are just simply evolving and not coming on the scene here anew, kind of from whole cloth. And it got me thinking about a marketing campaign that's been gone for a while, but was around for about 2 or 2.5 decades, which introduces another P, which is Palmolive. So Palmolive was this thing where Madge would lure people into her spa and introduce people to this wonderful thing that brought you benefits that you didn't expect and didn't know you were experiencing. Here it was Palmolive dish soap that apparently made your hands really soft and smooth. And so it got me thinking that, we're thinking, well, is there any AI in legal research? Well, turns out we've been soaking in it for a long time. So I want to frame that this way, and I realize it's a cultural reference that probably is quite dated and reveals my age. But I thought the P alliteration here would be good on an afternoon on a Thursday. So first example of this, looking to see where has artificial intelligence existed in legal research platforms for a long time. Natural language processing is something that a lot of systems do well because they want to take normal speak to use to connect with concepts. Turns out that natural language existed as a search concept as far back as 1975 in what is the precursor to modern day Westlaw. So at the time, it was just a digest only headings that you'd be searching, but you could just use regular words and phrases going into this. Fast forward to 1992, Westlaw is natural, or WIN was the acronym they attached to it there. And there they're kind of expanding a little bit as to what it is that they want to enable attorneys, and my sphere here is law students, to search. And this was an interesting article I found from somebody who was analyzing what it really meant to be using this as an AI-influenced search technique. And there was actually this funny quote in the introductory paragraph here where it says, this person is a librarian writing about it. It says, "I'm worried that students believe it functions as some form of artificial intelligence." Well, it turns out it does, but I think her concerns are different than whether or not it's properly categorized that way. So natural language stuff, been around for a long time in Westlaw. Looking at this a little bit, here's a little bit of what Westlaw is natural looked like. I won't read every point here, but basically there was a lot of kind of weighting and analysis and computational complexity that went into taking somebody's normal thought as a human into results that were meaningful and responsive. So again, trying to figure out how do we remove the cognitive load that exists between something and not force people to think in a certain way of kind of modeling arguments and seeking information. A couple of other things that Westlaw included at the time, and sort of briefly looking at this in terms of sort of an evolution of the components of this as a platform. They were doing already with this WIN, or Westlaw's natural stuff, entity extraction, where you could look at things, you type in a citation like 101 F2D1, and it knew you wanted, the first page of the first reported case in 101 volume of the second reporter series of Fed Reporter. Fast forward then to 2000, we're then doing a little bit more in the area of things like entity extraction. What that's doing is trying to look automatically and sort of code the content and records in the database so that you can look to see a named judge or attorney mapping directly to the content that they've written in terms of articles. Other AI innovations that West has introduced, and I'm just using this so we have a single sort of a trajectory or evolution. Other companies do it as well. Westlaw next then moved on to things like machine learning, clustering, log analysis, looking to see things like, how did one person do something? How much time did they spend doing it? Let's use that as a feedback loop into better learning in terms of the ecosystem. And then the most recent iteration that they have is now called Westlaw Edge. And that one actually has now embraced and sort of put in the forefront AI as a component to it. So their Web Search Plus, for instance, does a lot of that. It's a little bit more sophisticated, but again, this dates back to 1975. So one other thing that's in there that you see a lot, that a lot of the platforms are doing, is predictive searching. You just start typing New York Times vs, and it's like, oh, you want the New York Times v. Sullivan famous libel case. You go directly to it. Again, trying to figure out how do we save the time of people and enhance their experience for these premium services. So patterns. I want to look at patterns and sort of talk about this as a paradigm for a lot of the artificial intelligence development that happens. And also just recognizing that this is why legal is a ripe opportunity and sphere for great benefits to come about and great progress to be made, which is we're trying to find meaning in connected content. And ultimately, this is just a question of big data. So what does this look like for patterns, and why is legal uniquely poised to create lots of new opportunities like this? Well, with legal content, we've got lots of structured content. Your briefs, your pleadings, your cases, your statutes, even a lot of your secondary sources are highly structured. And all of the sources that are used in transactional law and litigation and things like that also have typically relationships between them. And the sources of law are really big collections. So as you're starting to look at this, we see patterns emerge. It's going to be enabling quicker, better, and simply different analysis of things. So what do these patterns look like, and how are we seeing kind of what this transforms, and what kind of opportunities does this bring to people practicing law and learning about, you know, the skills needed to practice law? One thing is visualization. This is an example, happens to be taken from Fastcase. Ravel Law does this as well, and others do as well, which is taking what would be a traditional text-based search result and presenting it to you visually so that you might find different meaning in the same content that you're using. The algorithm that goes into returning the results is the same as the algorithm that would be doing it for images as well as text. But here what we're doing is we're finding a different way to present it so that we can think differently about it and start to see relationships and start to uncover new opportunities in connections between these things. So again, these patterns are evolving because we have this unique opportunity of lots of source material that relates to each other. Another direction that lots of places have going into for a while, and this actually looks a little bit like the dashboard that that Catherine had presented during her keynote here, is looking to see how we can present visually information that comes from a lot of sources that gives us things that very quickly we might make judgments about, or we might make conclusions about. So Judge Lucy Coe, federal trial court judge in California, how often does she grant motions to dismiss, and how does that compare to the average? These kinds of things. A lot of this used to be done manual between AI, big data, and other kinds of things. We are definitely seeing this come up a lot more frequently here. So this is judicial analytics. It's on a number of platforms. And then litigation analytics is sort of its cousin there, which is looking to see, for instance, it might be whether it's clients or it's law firms, potentially your own firm or your competitor. What are they doing for certain things? Where do they practice? And how often are their motions granted, denied, or otherwise treated? So you get an understanding of what happens when you're looking at these patterns to figure out what is it that I'm appreciating from the interaction that we have here. Patterns in language, the other thing, so these were sort of text-based. The first two were about cases and judges. The other thing is just generally looking at language and mapping language. Lawyers care about concepts. Computers care about keywords. So figuring out ways that we can map, whether it's natural language or simple terms and connectors, to the underlying concepts, so you don't have to have the exact connection from one thing to another to be able to allow you to actually find the answer that you want that's responsive to your own needs, your client's needs, or something that you're involved in a legal proceeding for. Predictions, the second P that we've got here. Now that we've seen all of these models in terms of patterns that are starting to emerge, what we'll want to do is then figure out what can we take from this to understand how we're choosing to use the data to then model things to guess, you know, what is the future going to look like? What kind of predictions can we make based on these often algorithmically driven or big data sort of assembled sorts of materials? You know, the questions that you might, you know, introduce are things like, well, how long will this case take? There's a cost factor involved in every single billable hour, so I want to figure out, is it worth it? Should we settle? You know, what are the patterns for this? What should we file? The other one, sort of more fundamentally to this, is, did I break the law? Can we see something in patterns and analysis and things like that? What kind of predictions can I make to say, am I going to win this? Did I break the law? And how might a judge rule on this for that? So figuring out what we can do to sort of guess at and sort of feel a level of comfort in the predictions based on the patterns that we've seen for things there. Expert systems is another area where we'll see. I know one of our other presenters is going into this, so I won't dwell on it much beyond simply saying expert systems are a way that you could instill into it legal reasoning and decision-making, including weighted evaluation of things, to figure out what would we predict that would be the outcome based on a certain number of criteria or based on a certain set of factors that go into that. These are a couple of different platforms that develop sort of the content that would go into an expert system. The final P that I've got in the paradigm here is around products. So I just want to look really quickly here at a couple of AI-enhanced legal research products. Just think about how is the process of actually doing research changing, and what kinds of things do we see that are different and new opportunities. Well, the first one that's come out recently that everybody then copied is this concept of a search not by keyword, not by natural language, but to use the document itself as the source of research. So you would look to see, these are all the key things that you argued in your complaint. Well, how do people typically respond, or what's missing from the complaint? Upload a document, find the tailor results, review the on-point authorities. Case texts, Kara is the one that I highlight here. 4 other providers present something like this. And it's all AI-enhanced search using a different paradigm for things, where it's a different way to approach things. And it's, again, finding new opportunities in these patterns and predictions, ultimately. Another thing that the same company has been doing that sort of channels a little bit of the natural language and sort of pattern-based searching is parallel search, where you're using complete sentences to find concepts, even without matching keywords. That's natural language stuff that we saw dating back to 1975. It's just keep iterating over the enhancement as to how things are put together. And then Compose is an automated tool for the routine kinds of things and procedural motions, where it's not just finding a document bank that says, I'm going to start with a form and kind of adapt it. It's actually asking you questions about what components go into this in terms of jurisdiction, party, and so forth. And you're basically writing something with an assistant on the side to complete, again, procedural sort of routine motions for that. Another thing that's really exciting to see is that all of these innovations are not exclusively in the area of litigation. This is just one example, and there's a ton of them, looking at a company that does AI-enhanced analytics and analysis in the area of transactional documents, specifically contract analysis. And I've already apologized in advance to Catherine. I also stole one of her slides, which is simply to say, I'm only talking about a few of these to get these broad concepts out there. This is something that she at Baker Hostetler had put together as part of their team that looks to see the entire landscape of all of these new companies, new technologies, and new resources that are developing and evolving in terms of the kinds of opportunities they create for people. The last P I'm going to add there is peril. So I did the 3 as I promised. I'm throwing in an extra one here just as a bonus. So peril, we've got danger, Will Robinson. All of this stuff is spectacular. Everything is always good, except occasionally there's problems when you go into this. I hope other panelists get into this, and I'm excited to go into this in the conversation. So peril, there's the black box of artificial intelligence. You don't really know what you're getting when you put stuff into it and what you get out of it. You have a degree of confidence if it's getting you results that are responsive, if it looks like it's doing something well, but you don't know. And that the unknown, I think, is something that gives people a lot of concerns. I'll just highlight here, just by name, without going into detail further than that, a couple of the other challenges, which are going to be in the area of bias, lack of context, potential lack of transparency, and also a lack of a debiasing strategy in terms of looking to see sort of a self-reflection kind of approach to see, am I able to eliminate these things in the tools that I have? I want to bring it full circle back to where we started, which is with our last example here. So looking at this bias, we got be wary of making conclusions from limited evidence or imperfect observations. So if you see something, for instance, here, we've got Madge is now saying, it's got fingers, it must be a hand, all right? That's the evidence they had, it's fingers. Well, what if it's a glove? What if what you're looking at is not a hand, Obviously, she sees a little bit more evidence than that, but I thought this would be a good way to bookend it. And then a final one here as a cautionary measure here. Profiling behavior or predicting outcomes obviously has to recognize this bias potential. So you don't look at somebody's hand and you see, you know what, call the police, these hands are a crime. That's all I have to say there, other than, and I'll put these in the notes as well, I highly recommend 2 books here. One is AI for Lawyers. It's south of $30. You can get it on Amazon. It's spectacular if you want a good read to understand kind of what sorts of topics are coming up nowadays. And then the other one that's a little bit more in my sphere here on librarianship is law librarianship in the age of AI. Both highly recommended resources. And if you're looking to delve into this a little bit further, I recommend you go to your local library or you get on Amazon and buy them for yourself. Catherine, other panelists, thank you for your time, and I look forward to the conversation.
Yeah, thank you so much, Roger. A couple things. I'm glad that Madge had a cameo on this presentation. And I'm starting to think that your online board game was Scrabble, but I could be wrong. But nevertheless, appreciate that. That was very, very informative. And want to do a quick reminder, because I failed to say this in the beginning. Please go ahead and start loading the chat with some questions. I'm typing away here too, but we want to hear from you. I will actually ask Todd to go next here in just 1 second, but after we're finished, Bob's finished with his presentation, we're going to get into a little bit of more conversation and Q&A, and I think there's quite a few areas that you've already identified, Roger, that we can probe into, but please don't hesitate to do that now. I'll capture those, keep them organized and ready for us after we finish with Bob. But next, Todd, please, your turn.
Okay, great. Thank you very much, Roger. That was terrific. And you set a very high bar, so I should have insisted on going first if I had known how organized and articulate you were going to be, which I should have guessed based on our previous conversations, but I didn't give you full credit. My title really reflects how I came into this. I've been interested in artificial intelligence really from the time DARPA got started. I got into it from autonomous vehicles and just feeling like that was the magic that was there. And that's really shaped the way that I've come to appreciate AI's potential in the law. And that'll come through in the slides, I hope, as we get there, because I feel like I've been believing that robot lawyers, to use a term that was popular in the 2010s, were going to be taking over the practice of law. I've now added 10 years of gray hair. I don't feel like we're any closer to my being displaced than I was then. As Catherine mentioned, I focus on autonomous vehicles, artificial intelligence technologies, also transportation generally. So that's my prism, and I have been in charge of sort of looking at different products really over the last decade since I joined Tucker Ellis and seeing how we could use them in the field. And that's the perspective that I'm going to speak from. So to get started here, and by curmudgeonly, I mean that with all love to myself. I generally a pretty positive person, but there's nothing like following AI to cause you to wonder if we're going to get there. So I want to start with Sundar Pichai, the CEO of Google, who talks about AI in a way that is not consistent with my experience, but he's a bright guy and he's by no means the only one who's a true believer here. But I put this in because I think that's the background of the expectations. That's what I want to hold the profession to. If we're going to use AI, it really should be transformative. Maybe not fire electricity, but it really should be wow. And that's what I think is missing as I look at this. I think Roger did a nice job of highlighting really the best use of AI in the profession now, which is legal research. And there are some other fields, I'm going to call them out, where we are achieving more. And I'm going to suggest some of the reasons that might be, and that may help us identify how some of the other fields could improve here. But, again, remember, it's that profound, according to Sundar. Wow. I mean, is that consistent with your experience of AI? I doubt it. But this is. I have some young kids and they use Legos. This is a free app available. It's called Brickit. And I'm not trying to be frivolous by interjecting this into a legal research, but if you use this app, you start to appreciate the power of AI, because you literally just take a video of a pile of Legos, and it will kick out a variety of different designs using those pieces. And you can configure it in different ways so you could use as many pieces as possible, or you can design the coolest different part. And you don't have to give it this. It kicks these out, you know, as a matter of routine. And keep that in mind, because I'm going to return to that, because I think that's really where we are with some aspects of law. We ought to be able to expect